Hey guys, hey friends. I'm assuming everybody knows the big headline that Judge Bradbury denied Zachary Adams' petition for post-conviction relief, namely a new trial. Um, Decision came down, I think, like 2 p.m., right? This is timestamped like 2 p.m. local time.
Yep.
So it's kind of like, to me, I look at that as on the way out on a Friday. You sign off on this order, you give it to the clerk, and you go about your weekend. Like Regina George in Mean Girls throwing the pages of the book in the hallway. So
Mhm.
it is 97 pages, you guys. We are going to read. I'm optimistic we'll read the whole thing. I've read some parts in more depth than others, but some of it will kind of just be stuff I glossed over and won't really process till I'm reading with you guys. And I think Katie's saying you tried to skim through it. You saw this while you were on the road last night, so a lot of this will be the first time you're reading all the words as well. Before we do that, I think it's pretty important. We need to talk about some stuff in Tennessee. So going back to some critical context here, I think it's important that we remember Zachary Adams was convicted after a 2017 trial, and it was a death penalty trial through the guilt phase conviction.
So we have a death penalty certified jury, which I think matters here. They're statistically, I think your group knows, statistically way more likely to convict on less evidence.
And it should always be the highest expectation, in my opinion, but also when you're dealing with a death penalty case, again, only for the guilt phase here is how it played out. But at the time, contemporaneously, the expectation should have been that counsel was performing at the highest, making the reasonable efforts to explore every pathway to both mitigation and something that could be exculpatory, leaving no stone unturned, the highest expectation of counsel. And I think that's going to be pretty important as we explore ineffective assistance of counsel and deficiency analysis under the Strickland standard, which we're going to see Bradbury opine on quite a bit here in his 97 pager. Some other things, because this is going to be a long stream. So I think I'm guessing at these common questions that I expect, right? So the idea is this the final decision? Nope, not the final decision. Zach can appeal this specific order, to the Tennessee Court of Appeals. That is different than a direct appeal, which he already raised in 2022, and that was denied that was like an 81-page order. But he can appeal this specific order from Judge Bradbury to the Tennessee Court of Appeals. We're going to talk briefly before we get into the order itself on what the Tennessee Court of Appeals will look at, what they won't really try to unwind, and why it matters as we read the order. And then additionally, you could raise habeas petitions. And if for some reason brand new evidence, especially scientific evidence, because in my opinion, I think Katie would agree, the bar for bringing something through a quorum nobis petition under a case called Dellinger, it needs to be new scientific evidence. And it has to be something that either wasn't available or could not reasonably have been uncovered within, the time frame, the relevant time frame. And that's a really high bar. We saw that not play out so well when Doug tried to raise, I think he used the ATM video specifically as the new scientific evidence, because it's like physical material, it's like forensic examination. And those arguments didn't go so well in the PCR filings that we read. So that's a high bar, but if there was some new evidence to emerge, you could go back to the trial court with a new error quorum nobis petition, and the trial court would evaluate that information for the first time. Besides that, Katie, anything, your take on, is this the final decision? Is
Oh,
this
no,
where it ends?
absolutely not. I mean, it's disappointing that he didn't get it right. I thought he was going to. It's not the end. I'm just disappointed because it's going to be a lot more work. But that's work that we'll do, and we'll get it right. And if Tennessee doesn't get it right, the federal government will get it right. But somebody's going to get it right because it's too obvious not to.
Yeah, and in the interest of justice. Now, I heard a voice in my head. I can already hear the argument from someone whose name starts with an A, ends with a Y. It's 3 letters, saying, another court has found that Zachary Adams is guilty, just like the jury did. Does a decision like this prove guilt or innocence?
The facts prove guilt or innocence. The decision proves whether someone was paying attention and has the balls to do the right thing. That's how I see it.
Yep. So this is an analysis of legal mistakes. And really, I think these questions tie together. A lot of what matters with this decision is how Judge Bradbury goes through and does, for the most part. It's 97 pages. He does do a lot of explaining on here's these million different witnesses, and here's who I'm crediting, here's who I'm not crediting, and why. And while as we go through it, I'm going to point out gaps that I see in chat. Please participate. Read the words for yourself. Throw in your 2 cents. It's very valuable. We should rename that phrase. But what Judge Bradbury's doing when he says, hey, this witness's testimony during the PCR hearings, I'm going to credit that. I find it credible. That's a determination that the Court of Appeals is going to give deference to. They're not going to want to like undo that unless it's like so objectively unreasonable, right? So as we go through this order and we're reading Judge Bradbury explain, here's who I find credible, this is why, I don't find this person credible, here's why. Just know that that's pretty solid. That's something that's going to be pretty hard to make an argument for, to undo, to unwind. And then there might be some gaps. There might be some things that he doesn't explain, and maybe the Court of Appeals will want the trial court to weigh in on that later. We talked about new evidence with quorum nobis. I think it's a very, very high standard in Tennessee that if there's new evidence, it needs to be new scientific evidence. You need to argue timeframes. I think it's just difficult to bring new evidence through a quorum nobis petition, personally. But that would be a possible avenue if that comes up. We talked a little bit about what happens next. I think you would have a better gauge on this. And if you guys didn't know, can you also explain, like, Dana announced he's like stepping back from trial and error, but why?
Yeah, Dana McClendon is no longer hosting trial and error with me because there's a rule about pre-trial publicity that he wants to be very careful to abide by, because he's going to be joining Zach's defense team for what comes next, which will be an appeal. And without speaking for the attorneys, I would imagine an appeal and a federal habeas is in Zach's future. I know no one's planning on rolling over and taking this.
Then we've got, more important here is Napue. You're going to hear me pronounce this differently, 10 different ways. Napue. I'm going to change the way I say it throughout the stream. We're going to see Bradbury list the specific cases through which he's doing his legal analysis based on his facts and his crediting of different witnesses. And one of those cases is Napue. And that comes from a case where the holding is prosecutors cannot knowingly use or fail to correct testimony that's false. So if you've got a witness on the stand and they're just lying, you as a prosecutor have a duty to correct that. And then Glossip was a case. You guys might know the case of Richard Glossip. I think the biggest headline recently was Kim Kardashian came out and paid his like $500,000 bond, posted that for him after his conviction was overturned, but he was still being held on bond. And his next trial is set for September. Well, the Court of Appeals, or Supreme Court rather, back in 2025, heard Glossip's case, and their holding in their decision reinforced the Napue standard and reinforced that the standard isn't the highest thing ever. It just needs to be any reasonable likelihood, that false testimony, whatever testimony was not corrected, could have affected the jury's verdict, which means you could have a different verdict. And yeah, that could be either maybe a full acquittal, maybe a lesser charge. And remember, Zach Adams was convicted of several different charges here. So there could have been lessers on the table. There could have also been, just to say it plainly, for example, this timeline issue, where how did these guys do all of these things that were supposed to have been done from 8ish in the morning, between then and the time they got to the ATM in Parsons, shortly after 11 a.m., maybe if the jury was able to hear something like Paul Dillon's route testimony, maybe they'd be like, hey, they had plans but had to abort the mission. Maybe we don't have confidence that they would have convicted on the rape charge, though. And just because we have this slew of different charges, I think there's several ways that this new reinforcement under Glossip could be looked at through the lens of this timeline evidence that the original jury didn't get to hear. Because is it really possible for him to be convicted and carry out all of these crimes? Would the jury have found as such if they knew about this timeline limitation? And they didn't know about that. And yeah, so that's what I've got on that. You got anything on that?
What do you think, how do you think it would play out if Victor Dinsmore were to also recant?
I mean, I think it would be a cleaner recantation. Because, right, he moved, right? He's outside certain jurisdictions, outside statute of limitations for certain things. I mean, what would his risk be? Perjury?
He's outside the statute of limitations for perjury.
Okay, so I mean, I think it'd be a cleaner recantation than the issues that we have with Autry's. You know, we can't consider that for the purpose of PCR. If you guys remember, even though us as viewers trying to learn about this case, we heard about the Jason Autry interview that Katie went and did. We heard about that, obviously, that occurred after the conviction. We heard about it through the petition for post-conviction relief, but ultimately its admissibility was denied for the purpose of these petitions for a new trial. So it was not considered as part of what Judge Bradbury was weighing in here. Now, the decision was already appealed, right? There was an interlocutory appeal on that, and the appeals court said, we're not.
Well, they said they were going to. Actually, I don't know where that stands, because I thought the whole thing with that is they deferred their decision until the ruling came.
Maybe, or maybe the appeal was just on the transport issue.
I don't remember now.
For Autry.
I thought it was basically the issue. I thought there was an interlocutory appeal on letting Autry's recant in, and then the decision of the appeals court was they're not going to make a decision until the ruling, and then they'll make a decision on it maybe as part of the rest of the appeal. I'm not sure. I'm not confident I have that right.
All right, we can revisit that. We could probably do a whole stream again on like the legal issues surrounding the admissibility of Autry's statements and the fight to not, hey, if we can't let Katie's video in, maybe we could transport him and he could talk to us like fresh on the stand, just like go under oath, and the fight against that. That's a whole nother thing. Oh my goodness. And then yeah, so let's see. We're going to see when Bradbury's about to do his legal analysis, like, okay, I find these people credible. Now I got to do the legal analysis. Was there deficient performance? Did it cause actual prejudice? Was there a Brady issue? Were there any of these issues? We'll see those case names pop up in the underlying order. But something that I think we need to, as a group exercise together, talk about is Fields v. State. Now, Fields v. State, from what I see, is what currently controls it's Tennessee case law, and it tells the appeals court, the Tennessee Court of Appeals, you know, this is how you review something that comes up to you on appeal. So Bradbury has this 97-page decision. When this gets kicked up, Tennessee Court of Appeals would get to consider the entire record and analyze the legal conclusions made by Bradbury in this decision. They're not going to revisit his factual findings unless there's something so glaringly unreasonable about them. And that's like a super high bar. I almost never ever see that happen, even though I see it argued all the time. I don't know if you would agree with that, Katie. But it's always like, to me, what the lower court found, it's so rare that somebody will find it objectively unreasonable as a factual finding.
Mm-hmm.
So big red X on this one. This is probably not going to happen at the Tennessee Court of Criminal Appeals as they read any arguments about this 97-page order. But what they will look at fresh, that's a de novo review, is the legal conclusions. So as Bradbury goes through and he says, well, under Strickland, for ineffective assistance of counsel, I am or I'm not going to find that the performance by the trial counsel was deficient on this issue. And then if he does find deficiency, he has to go to the second required prong of that analysis and decide, well, was there actual prejudice? Was this deficiency something that would have, if it had been properly investigated and presented to the jury, is it something that would have resulted in a different outcome at trial with this jury? You got to do, it's 2 prongs under Strickland. So if he does an analysis like that, now the Tennessee Court of Criminal Appeals could say, hey, we're going to look at whether this analysis was correct. We're going to look at the issues with fresh eyes. Based on the facts that he found, do we think that there was deficiency? Do we think that there was actual prejudice? So they get to look at those 2 issues with fresh eyes. So keep that in mind as we go through this 97-page order. And then I think the last thing is the 4 buckets. So as we go through, Judge Bradbury is going to say, if there's a given issue, he could find that the issue was waived. So he's not going to weigh the merits of it. You didn't even raise it, you waived it, I'm not even going to get to a merits analysis, which would be the legal analysis that could be looked at with fresh eyes. If you abandon the issue, so maybe you raised it at some point, but you kind of like mentioned it, but then didn't really like present anything through these hearings, we're going to consider that abandoned. That's another bucket he could find to throw something in. It's not cognizable. That would mean that for whatever reason, I'm barred from weighing in on this. I can't make a factual determination. And the biggest example I think we're going to see is he's going to say that he's barred from weighing in on the actual innocence standard under Dellinger v. State for several issues, which is, I think Doug tried to raise actual innocence several times in his petition. And he's just going to say, Bradbury's going to say, look, it's just not something that I'm allowed to evaluate here. If you get through these buckets where something wasn't waived, it wasn't abandoned, and it is cognizable, then we can look at the merits, and that's where we're going to see things like, hey, I do or don't find this deficient, I do or don't find this to be a Brady violation, and here's why. And that analysis, again, is going to be ripe for argument to the Court of Appeals. So as we go through this, let's look at the buckets. Let's look at the buckets. Everybody grab a bucket. And we've got 97 pages to sort and see how Bradbury does his sorting. So before we do that, anything else before we start with this monster of a reading?
Check your message real quick before you start it, just
Okay.
a reminder of something. And I'm ready to go.
I'm going to prop my phone. Oh, remember there's a private chat in StreamYard too. I'll probably see that faster than my phone. I have a phone, guys. I do not like ever look at my phone. If I'm on my phone, I'm using it to like read stuff. Like I'm reading an order on it and I'm not messaging anybody. So also big thank you here. Right when we got started, Factual Lie gifted 10 memberships. So, you know, raising the spirits. Thank you for supporting the channel. Thank you for doing something so kind, but also on a day where I think a lot of people are coming in like bummed out.
Mm-hmm.
Like just bummed out, disappointed. Thank you for lifting the spirits in the chat. Big thank you, Factual Lie. And I know Factual Lie's over in the UK, so I can imagine she probably woke up after a lot of us heard the news last night. Just woke up and you got to see that first thing in the morning, and that sucks. So big thank you. Christine here, thank you for 2 months. Thank you for hanging out with us. I know you've been around longer, so big thank you. Crystal, thank you for becoming green. We have Martina sticking it out almost 2 years here. Says justice for Zach, screw the judge. Yeah, I'm glad I didn't do a stream last night.
Brad Bay, he is not.
No more Bayberry. Oh my goodness. Docket Decoder, great channel, you guys. Also did a lot of great coverage of this case, so make sure you check out Docket Decoder. Thanks for hanging out with us today. Thank you for becoming a member. And Weekend Court with Jordy, I believe, before I read your super chat, I think you mentioned that it's your birthday this weekend. I don't know if it's like today specifically, and you don't need to give us a day. We'll celebrate all weekend. But happy birthday. Let's get some good spirits in the chat. Happy birthday to Jordy in the chat. If I saw a message like go by earlier and I'm totally getting this wrong, then we're going to pretend it's your birthday anyway. But I think it is your birthday this weekend. Happy birthday. Thanks for spending it with us. Sorry for the bad news coming right at the same time. Thanks for the super here that says, guys and gals, show your support for Kat and Katie. Now that we got Katie here, like the stream and super chat if you can. This is her full-time job now with us. I'm still trying to off-ramp from my old job. It's been a fun time, but hoping to do this full-time. And then we have, let's see, Miri. I can't believe that this is a verdict after all bombshell moments on the stand. After Jennifer admitted she failed as a lawyer. Great to Dr. Katie Spirko. I think this means great to see. And I agree. Thank you for the super here. Thank you for the thoughts. I'm hoping, and I honestly feel like some of the questions Doug was asking during these proceedings, he wasn't just asking them for use at the trial court, the decision for this post-conviction relief. I do think a lot of the testimony he was eliciting was meant for not just higher state courts, but once all those routes are exhausted, federal route. So what you're pointing out here about Jennifer admitting she failed as a lawyer, and again, I'm going to keep harping on it, this was a death penalty case at the time of the conviction, right? It didn't proceed to a penalty phase because after the fact, the attorney who wasn't even appointed as the death penalty counsel, Jim Simmons, was appointed as the death penalty counsel once the state filed notice. But we heard that it was actually Jerry who's speaking with Paul Hagerman and gets this. Paul Hagerman agrees, all right, this isn't a death penalty case after the conviction. And I think that procedural history is so critical to something that could be argued about the expectations of effective counsel, the constitutional right to effective counsel when it's in the context of a death penalty case. So I don't think this is the end of the importance of Jennifer Thompson falling on her sword, quite frankly. So great food for thought here.
Got a DB in the chat says, poor Dick Adams, man. Tomorrow is Dick Adams' birthday and the anniversary of his son's death.
Oof.
So it's not a good weekend for him. I think Cindy's probably watching, so I know that the support means a lot to her. It's a hard weekend for the family.
And the easiest thing for me is keep it. That's why I didn't want to go live last night, because it wouldn't have been very logic brain. It would have been very like staring at screen, sighing, and just shaking my head. And I don't know how valuable, useful, encouraging that would be.
I'm still a little bit there, which is why I'm so grateful that you're doing this, and because it's so important that it gets out and people know what's going on. And thank you, because we need a logical analysis of this.
That's why I don't sleep. I was reading all night, a very pensive sleeplessness. I don't know how to say your name, and I don't want to say it wrong. You guys know me and my pronunciations.
Wait, mine?
No, the comment.
Oh, I was like, I'm sorry. My brain's not on yet.
Elinalia says, I forgot, is Dylan still in prison? Yes, Dylan is still in custody. And quick, do you think there's a possibility, like, there are different, a unique set of facts for Dylan? Yeah, he's a co-defendant, but the way he was interviewed, the way he was held, the way he was initially arrested, like there's a different set of facts that can be argued through different frameworks. And if there was some movement, and this could be a general answer, but if there's movement in a case where there were co-defendants, not every decision that could become an appellate issue that grants some type of relief for one co-defendant will necessarily automatically become relief for another co-defendant. But what could be interesting is if certain constitutional issues were raised about the way Dylan Adams was interviewed, was interrogated, and there's an evidentiary hearing raised in that regard, and then there's new testimony to come forth to argue that issue one way or another. That's court testimony that perhaps could be useful in other proceedings that could impact a co-defendant, just generally speaking. So, sucks that Dylan's also still in prison, but if there's movement in his case, it could be something that sheds light on or brings forth a new testimony that could become relevant.
Yeah, the key would be trying to figure out the legal outlet for that Dylan has available that's not already by statute of limitations or some technicality not available to him.
I'm still confused on, I think it was 2024, 2025 where Tennessee enacted, I don't know if it's just like sounding good in name, but there's like pathways where if you take a plea, an Alford plea, it's not necessarily a full waiver.
Yes.
Of your right to appeal, but it's not really honed out.
And I think there might be some statute of limitations issues with that, for him to take advantage of that. I know that legally he's not in a great position. And we need, anyone who wants to pro hoc vice in from another state, any attorneys in Tennessee watching that want to join our little weird group of justice warriors. But Dylan would probably benefit from some help legally. The family's resources have been exhausted by paying and paying and paying until they don't have anything else. And Dylan needs help.
Maybe there's someone out there who's really passionate about the Hunter decision that SCOTUS just came down with. The 12 orangutan is how I would characterize that. Like, is it reasonable to have 12 orangutans decide your fate? Was something that came up repeatedly through those arguments. But it was a case that dealt with waiver. And even if someone knowingly, they say out loud, yep, I'm aware I'm waiving something. If it's an outrageous miscarriage of justice, should it stand just because it was quote unquote waived?
Yeah, I think certain things are just, the idea of waiving it is unconscionable, where it's like, did they really waive it? And is that the standard you want to have, that we can just trick somebody into saying something they don't understand and then use it against them later when they...
Yeah, so if someone out there is real passionate about that Hunter holding, the new SCOTUS decision, maybe there's a way that they could apply it to whatever Tennessee came out with about Alford pleas and waivers and whatever else. So, or maybe the statute of limitations shouldn't be barring if it would be a miscarriage of justice. So,
and who wants to argue it? Docket decoder, bar card or not, you, sir, are a justice warrior. I declare it.
Heck yeah. Oh my goodness. Also, Amber Dondam Johnson's hilarious. Thanks for being a member 15 months. Says, girl, is there such a thing as morning drinking? Couldn't be me. I would get hungry. I would get hungry so early in the morning just from drinking. It would be a problem for 2 reasons. But I could see why you're asking.
I got a Red Bull. There's nothing in it, but maybe there should be.
And then
today would be a good morning drinking day, though. If we were gonna morning drink, today would be the day.
Right, and it's a Saturday. Valerie Trout, never forget Valerie Trout, says when Valerie Trout took the stand, the judge looked at her as if he knew her. There was something there I can't explain. He's totally biased. Yeah, and I wonder, maybe there's familiarity with prior testimony. And we'll have to see. Well, let's get into this. Thank you for the super. Let's get this, because we'll see what Judge Bradbury specifically says, why he's going to credit or not credit Miss Trout. Miss Trout with 2 T's. Right, so you guys already know the header. Order denying, why am I typing? Order denying post-conviction relief, findings of fact, and conclusions of law. Now remember, this is probably what's, I don't know why I can't highlight. That's so annoying. This is what the Court of Appeals can look at with fresh eyes. This, probably not, unless it's like so unreasonable. So unreasonable. So keep that in mind. This matters before the court for adjudication. Remember, this is a circuit court of Hardin County. The trial took place in Shelby County because they moved venues.
Question. What about finding of facts that aren't in it?
Send it back down to the trial court because they have to weigh in on something.
Okay, so that's something that the appeals court could address.
You mean facts that were raised during this petition?
During
the course of this petition, if it was raised but ignored in this order, then what?
Yeah, essentially in the order, conclusions of law are up for appeal, not the findings of fact. The findings of fact are going to be understood as correct. What about facts that aren't in the like that were omitted or that presented at trial and weren't included in the judge's decision making? Because if he presents them and then makes a legal determination upon them, then we're assuming the facts are true and the legal conclusions are up for debate. But if he doesn't present a fact that was presented at trial, therefore he does not weigh in on the legal conclusions of that fact. So I would think that
send it back down.
Okay.
Send it back down. And that, I mean, that can happen in quick cases. Remember, this was a expansive evidentiary hearing. Like, I mean, when have you guys ever watched an evidentiary hearing that spanned almost it was like a year, like March through New Year's?
Yeah, December 29th, I think, was the last hearing date. It was what was it, 11 days? I think it was longer than the trial or close to. I want to say, I can't remember what, because I wasn't even present for the actual trial because they were pretending that they were going to call me as a witness. But there were several post-trial hearing dates too. And so between those, I can't even guess how many, but was it 11 about trial days for an evidentiary hearing?
I don't know the exact, but it's voluminous. It's voluminous. So the idea that even though this is 97 pages, and that's part of why this is 97 pages, if there's something that maybe appellate counsel is like, hey, we really need a finding on this fact because it's material, especially if we're going to argue cumulative error, like we need all of the facts adjudicated because we need to make this analysis on whether the cumulative impact of these other issues necessarily denied our client's right to a constitutionally proficient trial.
Bitch, I'm sorry. I didn't come up. I'm just reading it. I just read a chat. I didn't. If anybody, I don't think Doug. If anyone is watching that would be mad at me for anything I were to say, I did not come up with Brad bitch. I was just reading a comment.
Blame the chat. So then we've got, all right, we're going to get our dates back straight because it's been a while. So the case history, and I think this will be helpful because it's been a while. May 2015. Petitioner Zachary Adams is charged with murder, kidnapping, and rape of Holly Bobo. And we have a footnote here that says the court refers through this order to the victim, Holly Bobo, by her first and last name, or by Holly or the victim. So it's going to change. We're not just sticking with one thing. In September 2017, the Honorable C. Creed McGinley presided over the trial, which resulted in guilty verdicts of first-degree premeditated murder, 2 counts of first-degree felony murder, 2 counts of especially aggravated kidnapping, and 3 counts of aggravated rape. Although the state had filed a notice of its intent to seek the death penalty, following the verdicts, the parties agreed to an effective sentence of life imprisonment without the possibility of parole, plus 50 years. So the posture of this case through the conviction, again, it was a death penalty case.
Sorry to jump in again. Kinsey is in the chat. Kinsey, would you mind, because I'm seeing some requests in the chat, could you put the ruling on the Innocent Brothers website so that people can access it, like just have it on the homepage, easy to find? And then if you could just let the chat know when it's up there, I would be so grateful if you could do that. So then y'all can grab it and follow along yourselves if you want.
And Kinsey, you should be blue now, so you can drop links in the chat.
Oh,
for whatever
perfect.
you want to drop. So sorry, I forgot. Because Trial and Error was modded, but not her individual account.
Oh, thank you. I learn so much about this stuff every time I'm on here.
The YouTube things. So we've got in affirming the convictions, the Tennessee Court of Criminal Appeals summarized the pretrial history. This is talking about the direct appeal and the evidence presented at trial, which this court incorporates by reference. And again, I believe that was an 81-page. In my opinion, that direct appeal, the order that came down from that, just repeated the state's arguments. So you guys might remember we did a stream a long time ago where we looked at, I think we did Terry Dyke's affidavit and talked about the direct appeal. We listened to the oral arguments, and that order just like recited argument by the state. And I just thought it was rubber stamping, quite frankly. But here that's being incorporated.
We should pull that up and look at it sometime because, and I could be mistaken. I'm fairly certain I remember reading that and them listing every piece of evidence that was logged at the Remain site except for the 380. It's weird.
And I'm going to share the link to the 2022 decision that's being referenced here in the filing. And then Katie definitely pinned that. I think stream in and of itself. So, oh my goodness. Okay, let's see. Where was I? All right, so they cite the whole case number. That was easy to find my place. Petitioner did not seek permission to appeal to the Tennessee Supreme Court. This court will address specific trial evidence only as relevant to petitioner's claims. And wasn't this right around the time, when was the first error quorum nobis petition filed?
That would have been,
Is this it? The first time would have been 2023?
Yes. Yeah, because it was with the PCR. They were the PCR was filed by Zach pro se, and then I want to say the error corba nobis was filed between that and Doug filing the amendment, or between the first and second amendment of the PCR. But it's right at the same.
Okay, interesting. I didn't realize there was a somewhat gap of time here between September and then July from this order on the direct appeal. And then on July 24th, 2023, this is when Zach Adams files his pro se petition for PCR. The court finds the claim colorable, appoints Doug Bates, the fourth, to represent petitioner. Bates filed an amended petition on January 22nd, 2024, a second amended petition on December 12th, 2024, and a proposed supplement on May 2nd, 2025, with a footnote stating that Attorney Bates also filed a petition for writ of error quorum nobis contemporaneously with the amended petition. There we go. The court held in abeyance the post-conviction petitions until ruling on the quorum nobis matter, which the court dismissed as time-barred by order, filed September 10th, 2024. And that's where we get the analysis under Dellinger that this wasn't found to be new scientific evidence that wasn't available or reasonably could have been available previously. The state submitted a response and a motion to dismiss certain claims. At a January 16th, 2025 hearing, petitioner conceded that paragraph 36 of the second amended petition did not present a proper post-conviction claim, and the court dismissed that claim by order filed February 3rd, 2025. During the same January 16th hearing, counsel for petitioner clarified he was relying upon the pro se petition and his second amended petition. Accordingly, this order does not address the first amended petition and resolves all remaining claims. This matter was heard on May 19th through 22nd. These are all the dates of the hearings, you guys. So May 19th through the 22nd, August 14th and 15th, November 19th through 21st, and December 29th. That's the day we got Boat Guy. After careful review of the claims, the evidence and arguments presented, and the entire record, the court concludes that petitioner is not entitled to post-conviction relief. All claims are denied. You ready, guys? We're going to go witness by witness.
In that other, if you want to at some point to pull up, it's on page 13. I knew it was on the bottom of page 13, but I thought I was getting confused because it was evidence marker 13 too. It's 13 is a number in this case, I guess. But on the bottom of page 13 of that appeal, if you want to look, it's interesting the one piece of evidence that's omitted.
All right, so quick looking over at the direct appeal. 13. This
And
paragraph?
then,
It's kind of
go. Yes.
okay, so we list.
During
You
the
could handle
search,
this one.
yeah, during the search, the following items were recovered: a cloth strap to a purse, which contained what was later identified as the victim's keys, camera, mirror, and earring, which weirdly was found by Jeff Jackson by himself while everyone else was at lunch, which made no sense. But anyway, going on. Where am I? An inhaler, a small purse containing pens, highlighters, lipstick, and a memory drive, chapstick, chewing gum, a black hair tie, a ring, pink fabric, an earring, a lotion bottle, a wallet containing the victim's identification, the sole of a black flip-flop, a single .308 caliber cartridge casing, hunting round, a single .410 shotgun shell casing, hunting round, and multiple teeth and bones, which were later identified as belonging to the victim through dental records and DNA analysis. So the one piece of evidence in that entire crime scene area that's not identified in this appeal is the .380 auto cartridge that Jennifer Nichols lied about being too big to be the murder weapon to the jury in the closing.
Because it had to be the Dinsmore Autry revolver. Yeah, very interesting. So again, this decision from the direct appeal, Bradbury says he's incorporating it for use in his findings here. So he's going to go through, he says the evidentiary hearing spanned 9 days, during which 25 witnesses and 156 exhibits were presented. The court carefully considered all the witnesses' testimony, observed their demeanors, and reviewed each exhibit. Below is a summary of the evidence in the order in which the parties introduced it. So we're going to go with John Walker. John Walker, and I think we only were able to see like 9 minutes of his testimony. So I think he was on the stand a bit longer than that. At the time of the crime, oh wait, I'm thinking of Joe Walker. At the time of the crime, John Walker worked for the U.S. Marshal Service, where he specialized in tracking fugitives using cell phone activity. We've got a footnote that says, although retired, the court refers to John Walker as Marshal Walker to maintain consistency with the direct appeal opinion. The parties' references, and because TBI agent Joe Walker also testified, and will be referred to as Agent Walker. Other witnesses will be referred to by last name only once established. TBI lead investigator Terry Dykes asked Marshal Walker to assist in locating the victim. The defense called him as a witness at trial. He'd mapped Holly Bobo's phone locations, located her notebook near the end of the mapped route, and interviewed both Clint Bobo, the victim's brother, and suspect Terry Britt. And they cite here to, this looks like the direct appeal, and transcripts. So with a footnote that says the court refers through this order to the trial transcript as tr.transcript for the 2017 trial, and post-conviction hearing transcripts as PC transcript. And then trial exhibit is trial exhibit, and to post-conviction hearings as PC exhibit. So that'll be fun. It's going to be a lot to follow. And then let's see.
While I don't like his conclusions, I do really like his footnote stylings.
Yeah, just making it clear beyond belief what I'm citing here. At trial, the state challenged his expertise in cell phone analysis, and the court precluded him from testifying about his data and route mapping. So this, to me, I think this is something worth highlighting, because it's something that this is being reinforced here, that the jury, the 2017 trial jury, as the finder of fact at trial, that came back with the convictions, did not get to hear this. Did not get to hear this. The defense presented the excluded evidence by an offer of proof. And that's coming from the trial transcript. At the post-conviction hearing, counsel properly established Marshall Walker's expertise. So it can be established. And it wasn't. I think that's important. Why? Because what does that point to, chat? If his expertise can be established years later, but it wasn't established at trial and he was precluded from testifying, well, what issue do we have there? What issue do we have there? So then they say, counsel properly established Marshall Walker's expertise at this post-conviction hearing in 2G cell phone tracking, and the court recognized him as an expert in that specific field. His testimony during the hearing was consistent with the offer of proof, also very important, I would say, and with his involvement in the case. What follows is a summary of Marshall Walker's testimony that the jury never heard. Marshall Walker explained that, to help TBI determine where to search for Holly, he reviewed cell tower data and tracked her cell phone activity and movements between 8 and 9:25 a.m. the day of the abduction. With help from an AT&T employee, he created a map of area cell towers, then drove the surrounding roads more than 50 times taking measurements. And this is coming from his post-conviction exhibits and I'm assuming his testimony. He proposed a route that Holly's cell phone traveled that morning. According to Marshall Walker, the route could not vary significantly. Otherwise, the route would have connected with different towers, or the timings of the pings would not match. For about 30 minutes, her phone stayed with the same cell phone tower sector. He believed that sector was where her body would be found. Along the route he mapped, law enforcement located several of Holly's personal items. The final ping came near a creek where the last of her belongings were discovered. Marshall Walker further noted that a death occurring within an hour of abduction was consistent with FBI behavioral analysis. Additionally, Marshall Walker mapped the location of the phones of the 4 charged with this crime. So we've got footnotes here. Zach Adams, so he's going to be Zach or petitioner. Dylan Adams is going to be Dylan or petitioner's brother, or could be first and last name. Jason Autry is going to be...
That's not right. Marshall Walker mapped the locations of the phones of the 4 charged with this crime. Dylan didn't have a cell phone. There's no cell phone data on Dylan. There's cell phone data on Zach, Jason, and Shane. Unless I'm forgetting, but I'm pretty sure. Kinsey, correct me if I'm wrong, but I don't think there's cell phone data on Dylan.
We'll see. We'll put a huh there. We'll put a huh there. Okay, and then Jason Autry, who doesn't have a footnote, we're going to refer to him as Innocent Man Walking, and Shane Austin, as well as suspect Terry Britt. According to his analysis, Britt's phone was at his home that morning. Zach's phone was at his home, and the phones of Dylan, Autry, and Austin were nowhere near the victim's phone. So we're getting
that's not true either. He did not say that Britt's phone was home that morning. He said that Britt's phone was not in use that morning. The first use of Britt's phone was at 12:17 when his ex-wife called him, which he said was to tell him that somebody kidnapped somebody, and I guess to find out if he'd raped anybody that day. But that doesn't mean he was home. And Walker didn't say he was home. Just he and Janet weren't using their phones.
Okay, that's a bad circle, but that's the relevant part that we're unsure about there. Zach's phone was at his home, and the phones of Dylan, Autry, and Austin were nowhere near the victim's phone. Marshall Walker interviewed Clint Bobo 4 times, describing Clint as honest and direct in his account of the man he saw with his sister that morning. Marshall Walker believed Clint's description matched Terry Britt. Based on all of his work, he concluded that the suspect was likely a local resident familiar with the isolated rural roads along that route. He identified a general area where the suspect would likely live. The home of Terry Britt was within that area. In Marshall Walker's view, Britt's appearance, known behavior, and home location fit the suspect. He also stated that a hair found inside Britt's vehicle was microscopically similar to the victim's, though no laboratory report was introduced to support that position. We've got a footnote that says later in the hearing and addressed in this order, testimony is provided that the hair was not Holly Bobo's.
The hair was a microscopic match that the FBI said was a 1 in 100,000 chance of not being Holly's. They had mitochondrial DNA testing done on it. Mitochondrial DNA testing is not nucleic DNA testing. For mitochondrial DNA, hair has a very high mutation turnover rate, so that a negative finding does not mean that it's not, it's inclusive but not exclusive. If you don't match to your own hair, that happens 1 out of 4 to 1 out of 5 times. So the hair on one analysis was said to be 1 in 100,000 chance of not being hers, and another analysis says it's not a match, and that's the case in 1/4 to 1/5 of people in the world.
Yeah, I mean, I think it's kind of odd.
There is a hair follicle that was collected suitable for nucleic DNA analysis that was never
And
tested.
they didn't do it. Yep.
It's still either sitting in the Jackson TBI office, evidence locker, whatever, wherever evidence vault, they call it, unless they destroyed it along with other evidence in this case.
I'm going to leave this a blue line because he says he's going to address it further later, but I think it's odd to word it just to say flat out. And he's saying testimonies provided, so it's not really his analysis here, but he's putting it as a footnote to show that it was disputed, that this was missing from the post-conviction proceedings here. We have testimony where it's testimony, but it wasn't supported with the lab report. So how is he going to say it was disputed later? Is he going to say that the disputing evidence presented was stronger, was easier to credit? Well, we're going to want to look for that. At Dyke's request, Marshall Walker interviewed Terry Britt while Britt was incarcerated on another matter. He did not expect Britt to talk. However, when Marshall Walker outlined his theory that Britt was the perpetrator, Britt responded with, "Sounds like you've got it all figured out." According to Marshall Walker, Britt said he would plead to a 20-year sentence. Britt also said he would show something if he were released, leading Marshall Walker to believe Britt might reveal the location of the victim's body. Marshall Walker stopped the interview at that point, believing that the TBI, not he, should continue the interrogation. We've got one smart person who's not just going to stomp over somebody's Miranda rights. I feel like this is so rare. So rare. So he stops this interview, according to him, because he felt like it should be TBI that continues this. On cross-examination, Marshall Walker clarified that he documented the conversation in a report and expected TBI to investigate it further. He never suggested that he had solved the case.
Imagine the investigator that happens to find a piece of evidence by following the factual line of clues also has the ethics to remember Miranda rights do exist. It's like somebody's competent.
Just coloring in the lines. We don't do that often. So he says he provided all this information to Agent Terry Dykes, who agreed that the cell tower analysis produced in post-conviction exhibits 4 and 5 provided an accurate route and timeline. Marshall Walker testified that, apart from Agent Dykes, most TBI personnel and prosecutor Jennifer Nichols rejected his conclusions about the route and the perpetrator. He said some investigators attempted to discredit him because his findings conflicted with theirs. Towards the end of his involvement, TBI agent Mark Lewis and Mike Frizzell interrogated him and filed an internal affairs complaint, which was ultimately dismissed. And that comes in as post-conviction exhibit 6. Finally, Marshall Walker said he met with defense attorney Jennifer Thompson only once, the night before he testified at trial. I think this is important because he's going to ultimately, jumping ahead here, he's going to find that John Walker's credible. So he's crediting this version of events, that this critical witness who was precluded from telling the jury at trial about these routes and the phone positions and how it's likely a good read of the route because of the available routes plus the pings from AT&T. You can narrow down, when you have a sector, it can be anything in this area, but if there's only like drivable roads that go this way and that way, and we have a more precise ping over here, we can corroborate that the route is likely this or that. So I think this is important to be credited. He only meets with defense attorney Jennifer Thompson the night before he testifies at trial. So he described her as casual and drinking wine during the meeting, and he finds this credible. He said she did not understand the difference between a cell phone tower expert and a 2G tracking expert. Because of this misunderstanding, Ms. Thompson presented him incorrectly at trial, leading the judge to refuse to allow his expert testimony. The court found that Marshal John Walker testified in an earnest, consistent, and credible manner. His testimony at trial, both in front of and outside the presence of the jury, was consistent with his post-conviction testimony. So he's credited. I think this is very important that he was credited. So next up we have Dylan. Guys. Dylan Adams, petitioner's brother, did not testify at the original trial. His post-conviction testimony was offered to show what he claimed he would have said if called as a witness. Dylan testified that neither he, Zach, nor Shane Austin had anything to do with Holly's abduction or death. He stated that on the day of the abduction, he woke between 9 and 10 and drove with Zach and Austin to Parsons in his 2006 gray Chevy Silverado. He identified his vehicle in photographs from a TBI report and from an ATM video taken at 11:12 a.m. on the morning of the crime. He also identified himself on a store video in Parsons at 11:55 a.m. the same day. Although he acknowledged telling TBI agents in 2011 that he was in Parsons earlier, between 8 and 9 a.m., he did not explain the discrepancy. He continued to deny any involvement in the abduction, rape, or murder of Holly, and denied speaking about the case to Jason Kilzer or Kilzer's mother. Footnote says the importance of conversation with the Kilzers will be later discussed. Dylan explained that in 2013, he and Jason Kilzer were arrested on unrelated federal charges. After pleading guilty to those charges, Dylan was placed on probation and required to live with Dennis Benjamin. I think this is interesting too, because there's contemporaneous statements that, that wasn't part of the post-conviction proceedings where that representation seemed to be more like witness protection.
Dylan, yeah, when I went and saw Dylan, he still was under the impression that he had been in witness protection and had no idea what had happened or why. I mean, he really did not have any clue why this all happened.
Either he's right and that's how it was represented to him, or he's wrong and he clearly doesn't understand the terms of something that he pled to and would ultimately lead to these special conditions.
Cindy was also told the same thing.
Oh, well.
By Jeff Jackson and Brent Booth, who are liars. Documented.
Yeah, I agree with that just from watching the interview snippets.
2 episodes are coming down the pike in Trial and Error. The next one is going to follow up on the last one, just with the routes and what the cell tower data is saying about where their alibi says they are and who's not. And then the next one will be my interview with Sheila Kilzer. And it's disturbing.
You guys know the drill. I'm sure someone's going to drop Trial and Error's link real quickly in the chat, but it's also in the description for Replay Crew. So hop over there and get a quick link over there. Make sure you hit the bell. Hit the bell so you get noticed.
Please do.
Especially since you guys had a hiatus. I feel like even if you tell YouTube, like, look, I want to get notifications for this channel, if they haven't posted in a while, when they do start posting, it's like hit or miss if YouTube's going to keep telling you. So you got to like actively revisit channels you haven't heard from in a while.
Yeah, so we just put out episode 13, Occam's Razor, which goes through that morning timeline and what the cell phone data says about where everyone was kind of leading up to when Holly Bobo's phone leaves the residence. And then the next one's going to go from there. And we're going to look at where everyone's phone says they are versus their alibi at the time her phone is leaving the house. And then I'm going to get that out soon, like within the week for sure, because I'm anxious to release Sheila Kilzer's interview.
Yeah, and it's like, I feel like it's, we just had a footnote. So we have a footnote that makes curiosity at the highest level right now. So look out for that, you guys. We've got, the federal charges, pleading, and then He was placed on probation and required to live with Dennis Benjamin, an investigator assisting the Bobo family. So I do like that we have it just plainly said that he is an investigator assisting the Bobo family. You know, we're not gonna, I think the state didn't want to concede this. That's the impression that I got. According to Dylan, Benjamin constantly harassed him about the Holly Bobo case. Because of Benjamin's harassment, Dylan falsely implicated himself, Zach, and Jason Autry during a November 17th, 2014 interview with TBI, and he cites the post-conviction exhibits 10A and 10B. He claimed the entire confession was untrue. And let's emphasize here that Bradbury's wording this to say that because of harassment, Dylan gives false implication during November 17th, 2014 interview. So, cause and effect, this happens before this. During cross-examination, the state confronted Dylan with written statements and telephone call recordings he made months before being placed with Benjamin. In the written statements, he implicated Zach and Autry, and he cites the post-conviction exhibit 12. In the calls, Dylan said that he'd seen Holly Bobo at Zach's house, and there is zero physical evidence they upended that house. So
they didn't just not prove Dylan's story. They proved that Dylan's story is impossible because what Dylan describes would have left evidence in a porous surface and upholstery that it would not have just been absent. When they searched that house, there was no DNA evidence. They literally sawed the floor out and to test the floor, and not only was there no DNA evidence or any biological evidence to suggest that anything of the sort happened, but there was no evidence of use of like harsh cleaning products or anything that would have possibly even attempted to conceal said biological evidence. It just, TBI themselves acknowledged that Dylan's story was not true.
Well, and the reason I think it's interesting is when we get to his final conclusion about Dylan's post-conviction testimony, Bradbury's not going to credit. He's going to say it's not credible, it was self-serving, he had his own interests for this testimony. But he didn't testify at trial, right? So we don't have, the best we can rely on is an Alford plea, which an Alford plea carries certain constraints as far as what you're maintaining about your own innocence. So we can't really point to an Alford plea as a concession and admission to the state's factual basis when they were charging you at the time you took that plea. And then we have this gray area here that Bradbury's including. He's saying, well, look, and the purpose of this is he's pointing out the state disputed, the state cross-examined. It was adversarial. But part of what he's including as the context of that adversary nature is this detail, and Katie just explained why it's critical. When it comes to crediting, to me, I think this is a reasonableness issue. This might be the exact type of thing where you can actually raise, you can either say, look, you need to make further findings about a stone you left unturned, where you didn't make a determination of fact, or this idea that it's unreasonable to say that he was disputed when what you're pointing to dispute something is also objectively disproven by other testimony that you didn't weigh in on and loop in, even though we had post-conviction testimony about it. So I think this would be kind of like a complicated issue to get down in like a concise manner and argue on appeal, but I do think that there's something there. So, and correct, Adventure Aaron says they didn't play Dylan's statement for the 2017 jury, correct? Correct. Like, Dylan was kind of like missing quite a bit. He was mentioned when someone was like, oh, it was Zach, Dylan, and Shane in the car or whatever. But as far as, I don't think anything about what he stated came in because you wouldn't be able to confront him.
They purposely tried Zach first because they knew that then Dylan couldn't be called because he would have Fifth Amendment rights that would keep him from being a witness in Zach's case. And they were going to get Zach, and then Dylan would fold like it always was.
The chat is saying, a bunch of people are saying, like, hey, he also said there was a basement, and there was no basement. So I don't know. I feel like there's something to work with here. Like, this is like, Bradbury is going to make a determination about the credibility of his post-conviction testimony, but there's stones unturned because something wasn't adjudicated by a jury. There really hasn't been certain fact-finding on certain issues, and that would mean that we're just relying on the questions, the decision to question, and questions aren't evidence either. You can't say that just because someone asked the question that's proof. We're finding that that's a fact. So then they say the state also introduced a sealed transcript of Dylan Adams' guilty plea in federal court. And I'm not aware of what that says. We have a footnote. The United States District Court for the Western District of Tennessee sealed the transcript. This court considers its evidentiary value, but will not refer to its contents. So
I don't understand why that's allowed to be sealed. Why is the state allowed to arbitrarily, I guess, is it the federal? It's Beth Boswell either way, because she was on both sides of it. Why does Beth Boswell get to arbitrarily just seal whatever is inconvenient to her for the public to know about? It's just like, look at all of these cases, look at all how the cases interlink with one another, and then go on Pacer and see for yourself. Everything that is inconvenient to Beth Boswell just goes under seal, and we act like that's acceptable, I guess.
Yeah, and I think the secondary point with that is that, I mean, you can't cross-examine not just Dylan on this specific issue, any of the contents. So, but also if you wanted to get into that with Beth Boswell, you wouldn't be able to substantively cross-examine. So,
and I think there's some sealed. I think there are some sealed things that I just have a feeling are very relevant to Dylan's defense. You can't seal that much stuff surrounding a defendant for no apparent reason, and it's all a coincidence. It needs to be unsealed.
Well, and I think this sounds like it's a plea colloquy because it says transcript. So it's not just like the final plea paperwork. This is transcript. So to me, that's the colloquy. And based on what I've learned about Dylan, my own observations of Dylan, I would not expect him to have an accurate, if you like, hey, we can't look at this transcript, can you tell us what happened? I don't think that his recitation, his recall would be comprehensive, would be precise, would be like, it's hard to, if you're not fluent in a language, it's hard for you to repeat back what somebody just said in that other language you're not fluent in, because you're processing it at a slower rate than if you were fluent. So, like, we also can't expect him to be able to bring forth any issue that he's been sitting and marinating on, because he might not even be able to recite it, especially years later.
And that's the worst, because I think even if he knows it, he's not going to be able to communicate it effectively in a way to advocate for himself as his constitutional rights would have him do.
Yeah, I don't know. And I feel like we just don't know if there's any issues there. And at a colloquy, there could be many, many issues.
With all the bad faith in this case, and it's like this attitude of entitlement, like, oh, just trust us, there's nothing in it. No, you're not trustworthy. Unseal the documents. I think it's BS.
Yeah, I don't know. That's an interesting issue, and we have a footnote. It was worthy of, hey, it's sealed, it's doubly sealed, and I'm considering it, but I'm not gonna give an explanation out loud here. So how does the Court of Appeals, if they wanted to do a review of the legal analysis for anything that might relate to what could be in this transcript, how do they weigh his analysis? I mean, maybe we'll see something. Maybe we'll see him get around that. But how do you determine if an analysis is objectively reasonable if he can't like state his analysis, his explanation?
Yeah, I understand the dichotomy of the facts are going to be not up for debate, but the legal analysis on which that is coming from the facts, but when you don't present it at all, you can't, it doesn't work, because you can't present a legal analysis that relies on a foundation of facts that you're not presenting also. So how would that ever be sufficient?
Yeah. Because, I mean, going and looking at the ceiling wouldn't help. It's the analysis they have to look at. So, just a pickle. Another legal pickle.
It's a dilly of a pickle,
Uh,
isn't it?
oh my gosh. On redirect, Dylan reiterated the statements he made to the TBI and his mother were untrue. He said he would have lived with his mother after his release from federal custody, but he was not given the option. On recross-examination, Dylan went further, stating that everything he'd said about this case since February 2011 was a lie. He explained that he cried during one of the jail calls because his mother gave him an ash chewing. We got that in quotes. And that's from the post-conviction transcript.
Notice it's since February of 2011 and the crime happened in April of 2011. Which fits with, I mean, it's like meta, it fits.
Yeah, I don't know. After reviewing his trial testimony and all related exhibits, the court concluded that Dylan Adams was not credible. Although Dylan testified that he implicated Zach only because Benjamin coerced him. The documentary evidence contradicted this claim. Dylan implicated Zach and Autry in a written statement in February of 2014, 6 months before moving in with Benjamin. Dylan's jail calls reveal he made incriminating statements before any alleged coercion occurred. Therefore, the court did not credit Dylan Adams' testimony. And while I think it might be, if he doesn't want to credit the testimony, all right. But saying that somebody coerced you and moving in might not be mutually exclusive.
And there is more than just, I guess, maybe it wasn't adequately explained that it wasn't Dennis Benjamin on his own off the street without any cooperation and collaboration from the TBI. What was going on, and the jail cell was mic'd up because they had Jason Kilzer and Dylan in the same cell, and they had it mic'd. And what was going on is Dylan was being pulled out of his cell for hours at a time on a daily basis to be interviewed by Jeff Jackson and Brent Booth. And this is going on day after day. And you hear this interaction between Jason Kilzer, the inconvenient witness that was killed by cops in 2025, in August of 2025. Jason Kilzer is telling Dylan, stop talking to them. They're trying to set you up for the Holly Bobo case because they need to close it. And they're completely taking advantage of you. Stop talking to them. You need to get a lawyer and not be like, he was trying to help him and protect him. And Dylan was just feeling really good about himself and proud of himself because he thought that he was helping, because what they were telling Dylan is they needed to know all the rumors that were going on that he was hearing in the Holly Bobo case. And as he's repeating and then having him repeat them over and over and over again, and then saying that he's unlocked these details where somehow what he's telling them is giving them these crucial details where they're able to piece the whole case together. And so he's going to be the star witness of the Holly Bobo case. So at this point, Dylan believes that he's going to be the star witness of the Holly Bobo case, but he doesn't understand why. And he's saying that he's just saying, and he's saying, I'm telling, like, he's reminding them they're just rumors, and he doesn't know if any of them are true, but they're just repeating it over and over again. And then you hear Jason Kilzer in the cell and talking to his mom saying they're setting Dylan up for the Holly Bobo case because they can't close it. They look incompetent and they want it out of the press and they want the Bobos out of the spotlight. And Dylan's going to get hooked for this if he doesn't stop. And now
Jason Kilzer is an unavailable witness
who was telling people in the days leading up to his death that he was scared, terrified. Multiple sources saying that he is not a kind of person that gets scared, and he was genuinely, for the only time they could ever recall in their lives, he was genuinely scared and telling people that he was going to get killed by a cop because this case is getting back opened up and they don't want him to be able to talk. And then officer involved shooting 2 days later. So that's the background context for why Dylan was making statements prior to them setting him up. Like, that's why they set him up to live with Dennis Benjamin. They primed him up and he couldn't repeat the stories consistently. But they'd gotten him confused and excited about the idea because he had to sign off to be willing to this weird plan that they're going to be presenting. So they had set Dylan up to think that he's helping everybody. And that's the perfect way to manipulate him, is
And it
to make
makes
him feel
sense.
really important and helpful and getting all of this approval while being confused about all the details that are being presented over and over again. And then they're having him rehearse it over and over and over again. I mean, we've heard what Brent Booth and Dennis Benjamin are like. We've heard what Dennis Benjamin is like to Victor Dinsmore. Can you imagine? Like, that's what Dennis Benjamin is like when he's recording himself out of his home, having crossed state lines, being an unlicensed investigator in a case where he has no business. And I think actually one of those recordings where Dennis Benjamin is threatening Victor Dinsmore with death and being scary. I would have to double check, but I'm pretty sure that Dylan was actually living in his home at that time while that recording took place. It was right in that same time frame. And so if that's how Dennis Benjamin is acting outside in public while recording himself, imagine what he's doing in that home when no one's looking with Dylan. And then you watch this crazy confession that makes no sense and is a confused kid that's uncomfortable saying the word vagina. But we're thinking he's going to be
talking about panties, and then meanwhile at trial they present panties that were found that don't belong to Holly.
And spend like half an hour talking about him, going on and on about panties that weren't Holly's. It's maddening.
Well, and what you just went through gives credence, going back to Jason Kilzer, if he's saying like, look, I'm afraid because they don't want me talking about this case, and this is getting like reopened because of the post-conviction stuff, the activity, there's new eyes on it, it's heightened risk. To me, that brings credence. If that's Jason Kilzer saying that, who I don't know, I don't think there's any like intellectual disability question there. It brings credence to the idea that if somebody's mentioning witness protection program for Dylan and telling Miss Cindy, oh yeah, this is for witness protection. And I believe an uncle did a contemporaneous interview saying like Dylan was put into witness protection. That's what I heard. There's like it's in one of the playlists, like an old clip, a news clip that we looked through. It kind of seems like, why was the idea of witness protection on these guys' minds when clearly it wasn't actually witness protection? It just seems like the thought process of someone being afraid of what they were doing was on their mind, and they're like, let's project that forward and tell Dylan, tell his family members that this is what it is. Except it's not us that you need to be afraid of. We're going to protect you. It's just some random other boogeyman that you need to be worried about. Meanwhile, who was Jason Kilzer worried about? Allegedly.
Mm-hmm. Jason Kilzer was worried he was going to be killed by someone who was a deputized U.S. Marshal, which is exactly what happened.
Fun times. Also,
it's like it sounds crazy. All of these things sound paranoid and crazy if you look at them in a vacuum. But if you step back and see the batting average of, oh, but these things actually, they're right. Like, that did happen over and over and over again. It's just insane to look at this and completely miss the gestalt of it all. It's like you're looking at each piece in a little vacuum and refusing to see how they clearly all fit together in a system that is not what our forefathers had in mind.
Hopefully not. And DB pointing out here correctly that this deals with a federal guilty plea transcript. So good correction there, because I don't believe that was an Alfred plea either. So, and I would assume that DB probably looked it up in like the couple minutes we had here and actually went and looked in like Pacer or something to see. So yeah, good correction here that this transcript that the state provided was specifically a guilty plea in federal court. And now revisiting that, going back to what we talked about a few minutes ago, it's actually kind of making me think that because it's following this sentence, these statements, that it is relying on Dylan probably said something was true somewhere. Like, and they're going to rely on truthfulness. He claimed to be truthful about certain things in another matter here. I don't know. Let's
The
see.
Spitfire Dragon, legit.
Okay. Okay, did we read the end of this? Dylan's jail calls reveal he made incriminating statements before any alleged coercion occurred. And I disagree with this finding because there was alleged... I think there was coercion alleged when we were discussing while he was in custody, before he was released. Like, I think there was testimony about that at the PCR. And
The
I
arrest
feel...
itself, that Beth Boswell is arresting the witnesses that she wants to leverage in the state case in federal charges to have something to hold over them, and the pattern that happens throughout the case with that. And that's not, we're not calling that coercive control to create the leverage that you want to use to abuse somebody's rights.
Well, what I'm saying is, like, I do think, because he's saying before any alleged coercion occurred. So he was asked a set of questions specifically about 2014, which would have been in November 2014, which was after, because he went to go live with Dennis Benjamin in September of 2014, right? So I really disagree with this finding. I feel like it's corralling around the timeline. He spells out the timeline issue here, and I really take issue with this. He spells out this timeline. That's
not right. That's not right. That date is wrong. It wasn't November 17th, 2014. It was September 17th, 2014, because the remains were found on the 10th, and this interview happened 7 days after that. So September is when he stopped living with Dennis Benjamin. It's supposed to be September. The interview happened September 17th, 2014. So,
okay, so that's but it's still after living, right? But
yeah. So February is when he was incarcerated for the gun charge with Jason Kilzer, and and that's where Jeff Jackson and Brent Booth are pulling him out of his cell. That's where the coercive control is starting, and not starting, it's back, but that's where it's really in full force.
Well, and that's why Bradbury's analysis here isn't, it's meant to decide whether or not to credit Dylan's testimony. And I think there's a reasonableness issue if this specific answer is from a specific line of questioning about this September 17th, 2024 interview. September or November, it's an incorrect time, but it still places it after the time period where you've been living with Benjamin. But if you're saying, yeah, I lied in that because of that, and then you're discrediting his testimony because there's other things he made statements of that are a different time period before he lived there, I don't think that's a reasonable analysis of the issue. I think we have issues here.
Look at the circle. Jeff Jackson and Brent Booth prime Dylan while he's incarcerated.
And Benjamin's already in the picture.
They have the cell bugged for the Bobo case. Why do they have the cell bugged for the Bobo case when this is supposedly a completely irrelevant federal charge that just...
And Dylan is where we get probable cause. So if Dylan's the reason we have probable cause, how do we have the bug already on that basis?
Exactly.
And that's why I'm saying, like, the idea that, okay, there might be statute of limitations. I don't know how things work, but to me, that's where you get a manifest injustice, such a blatant violation of a constitutional right. But I don't know the confines of carrying out an argument.
I don't understand how. I just don't understand how there's not some switch that you pull where it's like, really? A statute of limitations, so we'll just let the innocent rot in prison while the guilty continue to exercise authority over our citizens because there's a statute of limitations. That's not acceptable to me, and I don't think it'd be acceptable to anybody when you really look at it.
Yeah, we know that Dennis Benjamin was already going to he did a return visit to Victor Dinsmore in March of 2014, March 26, 2014. Which is before the moving period. So Dennis Benjamin is clearly and on the record. And the issue is that there's evidence on the record from these post-conviction proceedings that Dennis Benjamin was already part of this dynamic before this live-in situation. So to confine the ruling and to make a finding that if Dylan felt coerced or pressured to say whatever he thought was helpful, to make the conclusion that he was basing that on being made to live with Dennis Benjamin and finding, well, things happened before he lived with Dennis Benjamin, I don't think it correctly addresses the argument being raised by Zach Adams' team. And I don't think it makes factual determinations on facts at issue.
And I don't know how this fits into all of it, but the fact that the recordings in that jail cell are Jason Kilzer repeatedly telling Dylan, you're being set up by the TBI. This is a setup so they can close the case because they want the attention off of them and they're manipulating you. Get a lawyer and stop talking to them. Stop. And then we can't call him as a witness because he was shot by an officer a few days before a hearing. Where's the body cam and dash cam footage? That's all I want to know right now. I want it. And I have a right to it. And we all have a right to it. Well, not you, but citizens of Tennessee.
Yeah, and Sheila Kilzer was interviewed, and then they start going to speak with Victor Dinsmore. I think that timing is very coincidental. So you have these federal gun charges where Jason Kilzer and Dylan Adams are both, they're co-defendants. They're both picked up. And then Sheila goes to Brent Booth, and then Booth and Dennis Benjamin are running very early on in 2014 to go speak with Dinsmore more than once.
And this is the same time period. It was March 4th of 2014 that Jeremy Inman, Guido Inman, one of the Decatur County Sheriff's deputies, brought Decatur County Sheriff's deputy hard drives into a computer place to be cleared and tried to list them under his own name as private property. But the Netties also had the Decatur County Sheriff's Department contract. So the computer IDs showed up as theirs. So they called the sheriff at the time, Roy Wyatt, to let him know. Roy Wyatt runs down to Nettie's, grabs the computers, and then lies about that ever happening. And when the TBI, when Van Hooser or one of the TBI agents gets a hold of him and asks about it, Wyatt acts confused and says he has no idea what they're talking about, despite multiple store employees saying, yeah, it was definitely the sheriff, Roy Wyatt, and he was just here picking up the computers. And they didn't have any receipts or documentation of it. And the investigator who went down there to asked if that was unusual for them to not have any written documentation. And the employee just is like, yep. Like, everyone kind of knows what's going on. The timing,
like a good old boys club.
Like that week, that week is when everything happens. I'm looking I have a timeline I'm going to put in the private chat when I find it, because it's helpful to alongside this to see exactly the dates of all of these.
Yeah, there's so much to keep track of. It seems like Bradbury could have used that help. So,
well, if I had been allowed to participate in the defense as...
Well, that's what I was going to ask you. Were you here? Were you in... You wouldn't have been in court for Alberto Davis, or were you still there for like the first day of the PCR hearing and then you were kicked out?
I wasn't there for any of it.
Okay, because I don't remember seeing footage, I don't think, of Alberto Davis.
Yeah, and I mean, I think that Zach had the right to have me there to assist. I mean, Doug obviously did phenomenal and knows what he's doing. That said, Doug had planned on me being able to be of assistance during that trial, and there was no reason for me to have been excluded that makes any sense. And the one that they suggested, they proved was not true by not calling me as a witness.
Yeah, and it also indirectly, it wasn't direct, but indirectly became we lost access, because something that maybe trial and error could have published as like, here's the proceeding that took place on this day. There's no footage, as far as I know, available, disseminated by any outlet of some of these pieces of testimony. These early days, there were some clips from court TV, but that was it that I saw. And I just don't remember Alberto Davis at all. So here what we're going to rely on is just what Bradbury puts here. Alberto Davis, career law enforcement officer with extensive training in firearms and ammunition handling, including work as a certified firearms instructor. He was contacted by post-conviction counsel and did not testify at trial. Drawing on decades of experience, Davis explained how he routinely uses a micrometer, an electric measuring device capable of measuring within thousandths of an inch, to check ammunition for safety and proper fit. He demonstrated the device and measured a .380 caliber projectiles, showing that their diameter typically measures around 350 inches, with normal variation between 340 and 360. So this is something that... This is the type of thing that I want to pin as we go further in the analysis, because we're finding here that this guy did not testify at trial, right? Jury did not get to see this. And we know that the prosecutor made certain arguments in closing. And to me, when a prosecutor leans on a certain argument, it shows that they think it's important to their theory of the case or refuting a defense theory of the case, which typically means that something that wasn't contested properly at trial or was improperly argued by the prosecutor at trial. You should take that into consideration when you look at the prejudice prong. Did it actually impact the outcome? Because if it was inconsequential, why would a party be leaning on it in their arguments in a closing, where every word counts? So this is something that the jury did not see. And we have closing arguments by the prosecutor at the trial, urging the jury to realize or to believe and conclude, trust us on our gun presentation. And then the testimony from Jennifer Nichols, didn't she say that this is where everything gets dicey, or is that the phone stuff? She said she didn't know guns. She gave some testimony that she didn't understand this stuff, which I think is also helpful in a very umbrella manner.
Well, yeah, because she was going back and forth saying both that she doesn't understand guns, such that she shouldn't be held responsible for any mistakes she conveyed to the jury, and she's sure she was right about everything. And even though she can't explain why or what she said, she's sure it was accurate. Hey, I sent you the timeline. I couldn't figure out how to attach it in here, so I sent the timeline on your phone. Sorry, I need to learn how to do things.
Okay. Okay, do you want me to do anything with this right now? It's long.
Yeah, no, it's super long. I didn't know. At some point, it might be. It's
scrolling.
Yeah, at some point, it might be helpful if you want to put it up aside. Just if you need to reference it with any of these, like Dylan's initial arrest and when everyone was charged. So I guess put it up or don't at any point. But just as we're going, it might be helpful to reference at certain points to just clarify when things happen in relation to
dates and times. Bradbury finds that Alberto Davis is credible. Particularly, we have a specification here given his professional background and live demonstration of the measurements. So he's upset earlier that we didn't have Walker give us any lab results for the hair analysis, that the microscopic analysis that was done, not the nucleic that wasn't done. He's like, but we didn't get any records. But here he's like, I like this demonstrative and I find it credible. I find him to be an expert because of his background in this thing that he's demonstrating. So I think this is helpful. This is helpful. We've got Mark Lewis, who I also don't remember us being able to see his post-conviction relief testimony. Mark Lewis, now the special agent in charge of the TBI's West Region, participated in the Holly Bobo investigation from the morning of her disappearance in April 2011. At that time, he was a special agent second and was promoted during the investigation to assistant special agent in charge. Although available to testify at trial, he was never called.
Can we, before we get into his content, can you go back up to what you just highlighted on the bullet issue? Yeah. he demonstrated the device and measured 380 caliber projectiles, showing that their diameter typically measures around 0.35 inches, with normal variation between 0.34 and 0.36 inches. Is he talking about
when you take it outside the casing, what it would actually go through and cause a defect?
So that's what, is he talking about when he says between 0.34 and 0.36 inches? Is he talking about the average diameter of the bullet, or is he talking about the average diameter of the wound defect that bullet creates? Does that...
I think I'm reading between the lines and assuming that we're talking about the defect, that like a 0.36, that this could be consistent with the wound in Holly Bobo's skull, which measured at 0.36. But he's not specifying. He's not specifying.
The reason that that's to me relevant is a bullet diameter. I believe those are pretty consistent, but I'm not challenging anything he's saying. I'm just trying to make sure I understand it correctly.
So this would be casing. This would be what actually is that. So that should be ejected, right?
Yeah. So in the little picture with the red circle on it, the bullet is like the copper colored, and then the gold around it is the casing. But I think the key that I just wanted to highlight in what he's saying or clarify, is he talking about the wound defect or the bullet diameter range, just from a like error standpoint? Is he says, my understanding is that the 380 auto has a bullet diameter of 0.355 inches. And I've never seen them presented as ranges. I would think if they were that much of a range, I don't know, that would surprise me. But the reason I'm rambling on about this is the wound defect in Holly's skull was 0.36 inches. And it's commonly misunderstood that
it's not the exact size is the exact size of the wound, because there'd be...
Well, people often think that the wound can't be smaller than the bullet. The wound can be bigger, but not smaller than the entrance wound. The idea that, well, if the bullet's bigger than the hole, it wouldn't have fit through. But they could potentially make a bigger hole than the bullet. Now, bullets are not, I know enough to know you don't really know anything, because you can talk about trends and what often happens, but bullets do weird stuff all the time. But one piece that's important when he's saying 0.34 to 0.36, he's going a little under the average diameter of the bullet, not over. And the reason for that is that often when there's a bullet wound defect, or I think if I'm understanding what he's referencing correctly, like skull tissue, bone tissue, whether it's skull or not.
This could be a medical variation range.
The skull expands when the bone expands in response to the bullet. So then after the bullet exits or stays, whatever, after that initial expansion to try to accommodate the bullet, it'll shrink back. So it's not uncommon for a bullet hole, an entrance wound, to be slightly smaller than the bullet diameter itself, because of the skull or bone constriction after the entrance wound goes through. And I think that's relevant because the state is suggesting that a bullet with a diameter of 0.312 inches caused a 0.36 inch diameter. And anything can kind of happen with a bullet, but that would be, from my read of a lot of ballistics literature that I went through a phase learning about.
Well, and isn't that why it's interesting the way that the teeth were or were not recovered? Because their argument was that it could be caused by penetrating through an angle. You could see like a wider diameter based on an angle of entry.
Yeah, there are so many factors that can affect the exact size of the bullet hole or wound defect versus a bullet. So I just think it's something where they can never really answer the question. It's always going to have some like, well, maybe, like, it's, to me, ballistics in this area is more of a like, is this more or less likely to have happened than could it have happened, because there's a giant caveat, it seems, about everything of like, oh, anything could have happened. But it seems like it would be highly unusual for an entrance wound that's like a clean keyhole shape entrance wound to be significantly larger than the bullet.
Well, and this is critical for a bigger reason as far as legal analysis, which the Court of Appeals could review de novo on several issues, right? Failure to call this guy at trial. The jury didn't see somebody like this explain this expertise. We had some didn't they try to have the medical examiner try to explain bullets, and Nichols was like, objection, not an expert in this. So problematic. But the state's argument on this was, look, you have this .380 auto casing that was found there that was just a hunting round. That's obviously the type of ammunition that you're going to find on hunting grounds, right? Just like the other ones that we didn't look at, we didn't include in the direct appeal order, because they need to bolster the story told by the only witness, supposedly, to the murder, to the shooting, Jason Autry. They need to bolster his credibility that this was some revolver that they got after some trade through Shane Austin and Dinsmore and Zach Adams going back and forth. They get this revolver from Shane. I used to see him have this revolver on his waistband, and that was a different diameter.
And I think
it wouldn't have left the casing.
I think it shows consciousness of guilt on the part of the state, because it's not a normal reaction to that kind of question being raised. The fact there's no curiosity, there's no concern of, oh shit. And I'm sorry, but and
we went back and asked you, could it have been a different gun? We have two knuckleheads. We have Brent Booth, and we have Dennis Benjamin going back to confront Victor Dinsmore, asking if it could have been a different gun.
They needed to force it, and the .380 didn't fit, and so they discredit it because it's not convenient to them. It seems like they just try to get rid of anything that's inconvenient. But if I was reading through, it was me reading through the crime scene report, and .380 auto pops out, and I'm like, wait a minute, that's not right. I'm not a law enforcement, like, these people know guns. They're in law enforcement. They live in West Tennessee. They know guns. If I recognize that something is not a hunting round, I guarantee that a large group of TBI agents that hunt in West Tennessee can identify whether a .380 is a hunting round or not. It just, I don't buy it.
But the state needs to exclude the relevance of that .380 casing. Because they need to be able to say that Jason Autry is telling the truth when he says, this is how we got the murder weapon, and this is the murder weapon I saw Zach Adams use when I noticed that Holly was still actually alive under the bridge. Because he's the only witness to it.
And
no physical evidence otherwise, technically, besides this rusty revolver that was dredged out of some pond, because even though Victor Dinsmore wasn't in possession of it, his wife thought they should throw it away. They discussed it, and, oh yeah, my wife threw it in a pond.
Meanwhile, in that same call, he offhandedly references the shit .32 revolver that he threw in his cousin's pond because he was afraid to shoot it. And then, lo and behold, look what shows up when they can't find the gun that they're all pretending to have. There's another piece to this. I'll probably just... I feel like you're giving this perfectly logical, organized analysis and review, and I'm just like jumping in with tangents.
No, but it's important. It's important because to remind that, and again, revolvers don't eject casing, so we couldn't have had, because didn't they try to argue at one point that a revolver could use different size ammunition, but then that still wouldn't, you couldn't have Jason Autry say, well, we use this and it could have caused this defect, even though typically it would be .32. But then you can't explain the shell casing. So you have to make the shell casing just, it's just there. It has nothing to do with the skull being there.
Yeah, here's the overview of it. There are two kinds of handguns, revolvers and pistols. Revolvers are the ones with the circular thing, the chamber that you put the bullets in the chamber, and there's usually like 6 rounds in it. And when you shoot that, the casing stays in that little chamber. It doesn't get ejected out of the gun. A pistol, and people often will use the term like pistol just to mean handgun, but technically speaking, a pistol is a gun like the Glocks that everyone think of or law enforcement carry, where it has the magazine that you put in, and as you shoot that gun, there's a casing. That casing shoots shoots out of the gun while the bullet goes forward. It ejects and flies, it's going to land within several feet of the gun somewhere. And so the fact that there's a casing there means that a revolver was not shot there, a pistol was shot there. It's also just evidence a pistol was shot there. And it's highly unusual to think that a victim was shot by a revolver elsewhere with a bullet that
and then the casing
isn't as good a match for the size of the bullet hole. And then they randomly dump her body later at a site that just so happens to have a bullet casing right next to it, that the bullet is a perfect match for the defect in her skull. The fact that
you thought she was already dead, but you were driving around with her in the back of the truck to go to this bridge, then realized she was still alive, shot her with a sound that was apparently like boom, 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 and it echoed. It was crazy. Boat guy heard it and everything.
And
but it was just this revolver.
Jennifer Thompson clarifies how they were carrying her and how they laid her on the riprap. She clarified it to the point that it is confirmed through his testimony. He's clearly describing her being shot in the front of the skull, and like she's face up, and he's shooting her as she's laying face up. It doesn't even match the bullet trajectory. The entrance wound was in the back of her skull, and the exit wound was in her left jaw area. And so in terms of the testimony about the guns, just to kind of lay out the course of what happened, Shane Austin, his family, they're gun people. They know a lot about guns. They had at this time, they had nice guns. And Shane Austin had this, it was a long barrel 357 Magnum. 357, so it's a revolver, and it's got like a longer barrel. It looks like a old Western gunslinger type gun. It's a pretty old, like Westerny looking revolver. And he had a hip holster that
I need you to listen to some testimony in the Rashawn Jones case relating to, you just got to watch that case.
All right. And so I'm interested. So Shane Austin would wear this nice 357 revolver on an external hip holster sometimes. So when Jason Autry's giving this testimony and trying to fit a gun into it, the only gun he can really think of, because if Zach had a gun, he wouldn't be telling people about it because he was a felon, and so he couldn't own one. Same with Jason Autry. So he's not going to be acknowledging, even if he has guns, he's not going to be acknowledging them. Well, he knew about this gun that Shane Austin had because it was a nice gun and he'd wear it externally. So it was the kind of gun that would stick out in your mind and you would remember it if you know anything about guns, thus making this whole story even that much more ridiculous in what happens. But so he originally says it was a 357. Well, the state can't work with that because that gun is in the Austin's possession. They have it. So they can't fake a shot out of that gun and have it be produced somewhere. And they also, I think, were concerned because a 357 is a more high, like that bullet hole wouldn't be a 357. I don't think they could make that case in court. And so, while this is kind of going on, Victor Dinsmore initially talks about this 38. And then what seems to have happened is behind the scenes, Victor Dinsmore was informed that Jason Autry said 357. And we know that is, though we don't have that.
Dinsmore's like, that can't be right. Dinsmore realizes when he's told that that's what Jason said, that couldn't be right. So he comes up with the way. Is this where we get the interchangeable?
They're already at this point. They're already willingly, knowingly making up a story. Neither of them think there's any gun. They're trying to match their stories. And Victor Dinsmore has just been told, after he already said a 38, that Jason saying a 357. So Dinsmore then has a story that, Well, it was this 38 with an interchangeable 357 chamber. And that is something that revolvers, I guess you can get a gun where there's it's a specific type of gun that you can interchange and use either bullet in them. So it's like he's trying to drift his story to be consistent with Jason's. Well, then that 38 that he's talking about never materializes anywhere. Which at that point has an interchangeable 357 barrel. And so basically what it seems happened is they gave up looking for it and went and got the 32 that Victor had mentioned he'd thrown in his cousin's pawn because he was afraid to shoot it. And that became the murder weapon. So once that
he identifies it at trial, even though there's rust all over it.
He identifies it at trial. There's rust all over it. And so after they've already committed to a 38 and then a 357 and then a 38 with an interchangeable 357 barrel, now both Victor Dinsmore and Jason Autry know a lot about guns. They're not going to be mixing up a 32 revolver and a 357 Magnum. Jason described 357 very in a detailed way in his initial statement because he probably liked.
Did that explain why he wanted the sound to be deeper in timbre?
Oh yeah, he was describing a 357 because at the time that he was giving that whole story, he was in his initial statement from February of 2017 when they went on the field trip. He described Shane's 357 Magnum, and he said shots, and then there was one. So he's like, "Oh, I think part of it was he said shots." And then kind of caught himself and said, well, because it echoed. But that would make sense with the 357 way more than a 32 revolver. But so basically, and Jason says this in the recant, he's like, they just said, I must have forgot. So like, whatever, I forgot. I mean, and his original statement has this whole side soap opera about Shane Austen and Dylan Adams being secret lovers. And it's like, Jason Autry was not telling a serious story. He was exercising a morbid sense of humor and trying to get out.
You just reminded me, I forgot about the side story about like Zach asked me to take Dylan out on a boat and murder him.
Yeah.
I forgot about that.
I didn't. And why, like, whoever, even just look at the two of them. At this, like, Zach is a skinny 130-pound, very small time dealer who's just selling enough to have his own and is wasting away in a drug addiction. Then you have Jason Autry, who I think anyone who's observed him or listened to him for 5 minutes he is a streetwise survivor. And he has Jason Autry's not being bossed around by Zach Adams. Like, come on. It just doesn't make any sense. And it's in those little details where going back to the revolver.
Well, and why would you want Jason Autry to be bossed around by someone who's arguably less intimidating than him, has no legal power over him, when you want to not allow opposing counsel to make the argument that there was pressure looming over Jason Autry when he made certain statements?
They had to work with what Jason Autry was going to give them, which was going to be a ridiculous story that checked the boxes. I think that Jason Autry, and I actually have a source who, it was an inmate who was in prison with Jason at the same time all this is going on, and his mother was visiting him and crossed paths with Jason's mom. And it was an open fact among the pod that Jason Autry was telling everyone, Zach and Dylan are going to hate me, but they'll thank me one day because this is a sham of a trial and there's no way they ever would have gotten a fair one. And at least now they can come back in several years when I admit what I've done and get one. And his attitude was if he didn't tell the lie, they'd have someone else do it, or they'd plant evidence or any other bad act to get what they wanted. I mean, it was an open secret, it seems, among those close to him, what he just didn't have any other options. But then he has to fit these details into the story once things are corrected that then just hang there making no sense when you really look at it. Like, I know we have West Tennessee people in this comment like in this chat and people that are just around guns and no guns. Shane Austin is like a big guy that comes from a family of people with nice guns. And Jason Autry's story ended up being that Shane Austin is wearing a pocket plinky 32 revolver as on an external hip holster that morning. And he remembers the side of the hip that it's on, but he can't remember that whether his his family member died that month or not.
Or that there was a gate at the house or not.
Exactly. But the gun story is just, it's like, if you follow it, you can see how it develops and how it capsizes on itself. But you have to have the patience to follow it through. And there's not like a 30-second punchline that makes all of it click. It's like,
well, and I think that time frame also makes it critically relevant, the possibility of any expectations of leniency, benefits conferred throughout that timeline, because of the postures of his federal cases at different points of those times, as he has to keep changing his story. So it's like, as soon as they realize that his story needs to change, he still has something that would be looming over him as potential pressure. So it's interwoven, it's intimately interwoven the entire time, something that I would call like a Giglio issue.
Well, and I think Jason Autry purposely picked the spot he did for this all to go down in the story, because he wanted it on federal land, because he needed federal immunity as well as state, and he's no dummy.
Yeah, so if I testify to this, you can't prosecute me.
Mm-hmm.
My goodness. We're going to do some speed reads. We're on page 8. We've got Mark Lewis. Mark Lewis, now the special agent in charge. He was promoted. We went through that. Now, this is about the palm print. Throughout the investigation, Lewis assisted in evidence review, vehicle processing, and forensic lab coordination. This is all the post-conviction exhibits. He confirmed that a palm print was found on the victim's car and discussed the ATM video admitted as the post-conviction exhibit 8. Lewis authored a 2013 digital evidence report cataloging 72 items, including CDs, DVDs, and flash drives. And that was submitted as an exhibit in the post-conviction proceedings. Item 48 in the report referenced an ATM video labeled V8-BP/ComSouth Bank ATM-April 2011.
That's what the video was labeled. The folder it was in did not say Community South ATM on it, or April 11th. It said BP video. Like, they're not saying the names of these folders, because if you show the names of the folders, it's obvious what they're doing.
When shown the video, he did not recall seeing it previously. He identified the vehicle in the video as a Silverado or GMC, but could not identify any distinctive features of the occupants. Lewis acknowledged that TBI collected bank records of co-defendant Austin, indicating an ATM withdrawal at Parsons at 11:12 a.m. on the day of the abduction.
That's not true either. There were not bank records collected that indicated the time of the...
Oh, yeah, it was just the dates, right? From Shane Austin?
Why, and I think that's important, because yes, the bank confirmed that the dates were accurate on the statement, but they couldn't provide anything that was time-stamped. So we did not have the timestamp of anything until we had that's why the ATM was so important, was because it was the only way that we could actually identify exactly when they were at the bank. And I do think it's relevant that before we had that information, by piecing all the other objective
why they were fighting it
of alibi information together, we were accurate within 5 minutes of exactly when they would be at that ATM, which I think corroborates the credibility of the other alibi evidence they have, that we were able to predict it within 5 minutes based on that.
Yeah, and I think guys, as we move forward through this is my guidance, and you don't need to follow my guidance, but just to, what I think is worth paying attention to as we continue to read is, my opinion is that we have a factual finding by this court that the evidence strongly supports, right? It might not be 100% absolute certainty, but this court, Judge Bradbury, seems to think to a very high bar, high high degree of credibility that Zachary Adams was, in fact, in Parsons at 11:12 a.m. It seems to be his finding that the factual evidence presented at trial and the post-conviction proceedings places him there, which is contrary to Amy Wyrick's closing argument at the PCR proceedings that we don't even know that he was there just because we see a truck. And I think Bradbury seems to not be agreeable to that counter explanation. Cool, the truck could be there, but that doesn't mean Zach was. I don't think he agrees, and I think that's very helpful. Maybe at not this point in time, but I think it's very helpful for future proceedings.
Well, and I just think, yeah, Lewis, I don't think Lewis acknowledged that. If he did,
we're gonna see more. We're gonna see more in his reasoning later. We'll see it when we get to it.
Did he mention, though, did I miss, because he says, but could not identify any distinctive features of the occupants? Does he not mention anywhere in there that the truck was appeared the same make and model, and it was going backwards through the ATM, which is consistent with Zach's statement prior to this unveiling?
Was that part of Lewis's testimony? Do you know?
No, it wasn't. You're right.
That's why we have an issue.
Yeah,
that's why we have an issue. And unfortunately, if that's going to come in only through the testimony of Zach, and Bradbury's not going to credit his testimony, that's where we have the factual determination issue. And even though maybe somebody else could have testified about it, because I do believe Doug tried to ask several people.
I have timestamped video footage recorded of him saying it prior to the video coming out.
Yeah, so I'm not aware of. That's what I'm not aware of Mark Lewis's full testimony, because it wasn't something that was recorded and published. But it could be something that maybe he did testify about that's just excluded from this reasoning here. This recitation.
When Kathy Ferguson subpoenaed my Zoom records and they were trying to arrest me for criminal behavior or whatever they were saying, that's what they were going after. They were trying to get the recorded footage of Zach making that statement that the truck was going through backwards before the ATM footage was discovered.
Is that anywhere in any reports earlier in time? Or is that only him telling you that before the post-conviction proceedings?
I mean, he remembers telling Jennifer Thompson that, but I don't know. I never saw it in anything. We have it video recorded and timestamped as him making the statements prior to the footage ever being released. I mean, that should be, I get sometimes things are relevant practically, but not necessarily legally.
Yeah, it's a lot. That's what I'm saying. This is there's a lot. There's a lot here. I would hate to have to figure out what we're going to put in a brief with character limits. And they've got petitioner introduced, PC Exhibit 23 through Lewis, though drafted by Agent Joe Walker. Okay, so this was some summary report or something. And emphasized that the report contents were proof that the state intentionally misled the defense about the ATM video. This exhibit states, a check of video recordings from that date is to be done when a player is obtained for the MAPCO and a BP video from Highway 641. The other places were not covered by our videos. BP video. And then that's cited to PC Exhibit 23. Then they move on. They move on to another subject. They say, regarding Terry Britt. This is kind of interesting to just leave this floating here, but okay. Regarding Terry Britt, Lewis testified that Britt became the primary suspect. However, no physical evidence connected him to the crime. Well, I mean... Yeah, next words, Katie. A hair? A hair recovered from Britt's home, according to Lewis, did not match the victim, and a wiretap produced no incriminating information.
Why?
I think this was disputed.
And it wasn't from the home. It was found on a piece of tape, a duct tape, attached to a rope
in the car.
In the van, one of the two vans that FBI-trained cadaver dogs hit on. In addition to a shovel, a pickaxe, a hammer, and another axe of some sort. FBI trained cadaver dogs. They hit on those twice because they hit on them in the shed, and then they removed them from the shed and placed them at random places throughout the property and switched out the dog handlers, and the dogs hit on the same tools elsewhere on the property with different dog handlers. And that van is where the hair was found. Get it right.
Hot mess. Yeah, was not found in the home, because it's definitely worse if it's found in the van, I would say. A hair recovered from Britt's home, according to Lewis, did not match the victim. Okay, I don't know if he's saying according to Lewis it was found in the home, or according to Lewis it did not match the victim, or both. So I don't know if he's challenging the version of events here or not. But he says it did not match the victim, and a wiretap produced no incriminating information.
That the wiretap produced a lot of incriminating information, but it's just Britt wasn't only incriminating himself in it is the problem with the wiretap for them.
So, but what I'm saying is I don't think that this is necessarily a factual finding. I think he's saying that this is what Lewis is testifying to. And then if we don't have any, because we'll have to see what he says, because he asked, there was, I don't remember who he asked, but there was more testimony. Doug did some lines of questioning about this later. So pin this, we'll see if we get more recitation here from Bradbury on this wiretap through other witnesses.
Yeah, I don't think I've ever seen Lewis's testimony. I don't think it was.
Yeah, and this is why this part's a struggle, because it's like I can't tell what is he correctly characterizing the testimony, because I can't see it. Sucks.
This is the kind of stuff that I think is relevant, that I was barred from being able to assist in Zach's case presentation, because I would have caught all these little factual errors that the TBI agents are putting in the testimony, and that's
you could have crossed on it right then and there. You deprived of an effective direct when it's, well, the state didn't really call too many witnesses, but still, if something was raised on cross and came up during redirect, you could correct it during a redirect of the cross. Either way.
I think a lot of Doug's witnesses were hostile, so even for the directs, not technically, but I mean, it just, I think the fact that the judge is in his findings of fact summarizing details in testimony that is inaccurate.
And you didn't have the chance to contest, correct, dispute in real time because there was no awareness, no reasonable way for Doug to or Crystal to be aware. Although I'm sure they'll argue that their counsel, there's two of them, they should have been able to do it themselves.
The entire time they were preparing, they had an expert consulting, a consulting expert, a non-testifying consulting expert that had an excellent command of the case and could have assisted. And Doug informed the court was essential to his presentation of the case. So whether Crystal
he preserved that record.
Whether Crystal could have done it, whether Doug could have done it, whether it mattered at all.
They were relying on you.
I'm not suggesting that Doug did or didn't catch all of those himself. I mean, I'm not suggesting that Doug doesn't know the case well enough to, I'm not in any way challenging his knowledge of the case. But when you have a resource available to you that you'd planned on using, and then you're deprived of that, especially
on a pretense, yeah.
And I don't think a non-testifying consulting expert should be allowed to be called it. Like I already told, like I wouldn't have answered any questions. Everything's privileged under press, if not for my agency with them. It was like multi-layered. It was just such a dirty move, but that's going to be my last tangent of this live.
He acknowledged discussions at TBI about how the crime might not have occurred if Britt had been in custody for an earlier unrelated offense. Still, TBI had concerns that an attempt to prosecute Britt might fail with Clint Bobo as the sole eyewitness. Clint had given inconsistent statements about the man he saw leave the house with his sister. Lewis acknowledged internal discussions about writing a letter to the Bobo family, expressing concerns about Clint's various statements. And this is post-conviction exhibit 21 through an offer of proof. And the footnote says that the state objected that this letter was not authenticated, and the court sustained the objection. No witness authenticated the letter, and the court has not relied on it in ruling. Lewis explained that in 2014, investigative leadership changed. Agent Joe Walker replaced Agent Dykus as the lead case agent because Dykus was viewed internally as having lost objectivity by focusing too narrowly on Britt. The breakthrough in the case occurred when Sheila Kilzer contacted TBI stating that she and her son had previously lied and that her son had heard information from Dylan Adams. So remember, she calls Brent Booth. She doesn't call the TBI office and just get funneled to Brent Booth. She calls Brent Booth. Lewis agreed Kilzer was motivated.
And she doesn't say that. And there's no evidence she said that. And it's hearsay to allow Booth to report what she's saying to him when it's not true.
So we're not going to rely on this offer of proof because there's no foundation for it, but maybe they'll argue that it's just showing what Lewis was doing at the time or what was happening at the time because of that belief, whether true or not. Lewis agreed. Kilzer was motivated by her desire to have her son released from jail, but said her statement redirected the investigation towards the Adams brothers. Lewis confirmed that searches of the Adams brothers' residence and vehicles, including Dylan's truck, uncovered no forensic evidence linking any defendant to the victim or her belongings. Nonetheless, follow-up interviews, including those with Dylan, led investigators to believe the brothers were involved. Lewis referenced statements made by Autry, although he noted that Autry's account did not match Dylan's in all respects. On February 28, 2014, Lewis and two other agents interviewed Zach, who did not confess but gave multiple inconsistent explanations for scratches on his body around the time of the abduction. Now, this is when we had the announcement. They did it from like a highway. There were like trucks driving behind that they were getting a search warrant. Right? That was February 28th. That was when all like the media exploded.
February,
TBI Director Mark Gwynn announced a search warrant issuance.
That day, February 28th, Mark Gwynn was on the news telling people that they hoped to bring Holly home safely. So there was not even a murder investigation per the TBI that very day. While they're exercising the search warrant, he was presenting it as though they were hoping it would lead to information to safely return her home. Zach was arrested that day, but not for the kidnapping, rape, and murder of Holly Bobo. He was arrested for kidnapping and assaulting somebody else who had been charged with Zach's girlfriend. It was his girlfriend's sister had been charged on this theft deal, and they were facing exposure to that. And over the course of them being charged with this large theft, they come up with a story that Zach kidnapped them. Valerie Trout just so happened to be the one investigating this supposedly unrelated theft situation. And then they come up with this story that Zach kidnapped her. Zach and his girlfriend had actually called the cops on her between the time that it supposedly happened, and she's telling the story. But she has this whole story about how he kidnapped her for some period of time, and then she was rescued. And then March 6th, after the Decatur County Sheriff's Department computers are cleared, they charge Zach with Holly Bobo's murder and kidnapping. And then the same day, about a month later, they charge Autry. The other kidnapping charge just like disappears out of nowhere, and everyone pretends it never happened.
I'm curious about this, and I kind of want to go back and watch Mark Lewis and like when they pulled the photos up at the trial, the 2017 trial. I want to go back and watch that. Like the discrepancy between the park ranger or Forest Services guy and then law enforcement showing up, and then this issue over Zach having these scratches and or marks, whatever you want to characterize them, on his body as presented at the trial, photographed closer in time to when Holly Bobo was abducted. But here he's saying that they interview him in 2014, years later, with other agents present, and he gives inconsistent explanations. So this is removed in time, and he first attributed, so I'm thinking they're not we don't know that Lewis was confronting Zach at this time. Like, this is what you told us back then. Was that true? If they're asking him an open question and asking him to fill in the blank, and he's just like, well, I don't know, I probably had a fight with Shane Austen or something. And then more questions, and he's like, well, I don't know, I was carrying marijuana plants. If he started talking about the time where they went because of grandpa of calling 911, and we have the whole marijuana plant story, maybe that's why he's giving inconsistent explanations. He's not giving inconsistent explanations because he's randomly changing his story. He could be trying to think back 3 years earlier and responding to new information coming from a follow-up question. So I have a pet peeve with this type of conclusion that just because something is inconsistent, that it's attributable to somebody lying contemporaneously. So
it's also, I think, just in the manner and style of questioning too. You're asking about, like, I have scratches on my legs. I don't know where they came from. I live in the country. If somebody asked me, I may say something that I think at the time, and then I may say something else if I'm asked 3 years later, how do you think you got those scratches on your leg? We don't know what I think the wording and something like that. And he's also, let's not forget, addicted to meth, and people tend to have scratches when they're using a lot of meth.
But he finds him credible. So the court ultimately found Lewis to be a credible witness. And interestingly, he doesn't compare it. I'm not crazy, right? He testified at the trial. Oh no, he wasn't. He wasn't called. So when his name was mentioned at trial, it was all just through other people speaking to what he wrote down somewhere. That's why his name was relevant at the 2017 trial. Because that goes back to another issue. We have a record at trial that it's other witnesses bringing in anything that they would have relied upon through Mark Lewis because he wasn't actually called himself.
So the question is, how did Zach initially come into the running of suspects? Or am I not following that right?
Sorry, where are you looking?
No, I think I just misunderstood. Well,
I think it's interesting that, because I can't see the exact exhibits, what's being referenced here. But I think we have, going back to everything's interwoven, we're having the court point out here for the purpose of this order, this decision, that he wasn't called at trial. So we can't compare his testimony at the PCR hearings to see if it's consistent with what he said at trial because he didn't testify at that proceeding. But there's other records that were, I swear, referred to that he had a role in that were discussed at trial. And that makes the stuff that originally would come back to him or have been steered in the course of an investigation because of his opinion, his notes, his findings. Any testimony about it would have been incorporated through somebody else at trial. And that's the problem with certain aspects of hearsay being rammed in. Oh, it's not for the truth of the matter asserted, because now we don't have this angle when it's relevant in the post-conviction stage to be able to compare it for the basis of a credibility assessment. It's only through cross-examination, which, again, strengthening your argument that his team here, Zach's legal counsel, had a consultant that was prepared to know this record and be able to point out inconsistencies, the post-it note on the fly, to clean it up, point it out during questioning, and that opportunity wasn't present either. So you can't compare it to a trial testimony because it's non-existent, and you couldn't correct it during these proceedings because you weren't allowed to be there.
Mm-hmm.
I don't know. Let's keep going. He finds this credible. So Mark is credible. We don't really have much to compare it to. He's just credible. Jonathan Reeves. Jonathan Reeves is a cellular network engineer with nearly 30 years of experience designing and optimizing wireless systems. He testified for the defense at trial and as an expert in 2G cellular technology. He analyzed call detail records of the victim and the co-defendants using AT&T tower sector information. Reeves' report indicates that Holly's phone traveled north from her home, then east, and then south between 8:17 and 9:25 a.m. This is coming from the trial and a post-conviction exhibit. Notably, at 9:01 and 9:06, her phone connected to a southwest sector near Zach's residence. I wish he was using the tower, like saying like he connected to tower 1136 or whatever, rather than just saying where it was located.
Wait,
At 9,
oh yeah, okay. It's been the Cox Tower.
okay. Yeah, I think it's just like easier to track that way.
It is.
At 9:10 a.m., Holly's phone and Adam's phone registered on the same sector, an overlap that occurred only once that morning. At 9:25 a.m., Holly's phone connected, which is kind of odd if your state's theory is the abduction happened earlier. But okay. At 9:25 a.m.,
clear trajectory where her phone is in motion, moving in a direction, and
his
Zach's
is
phone
not.
has been not all morning and has been stable.
At 9:25 a.m., Holly's phone connected to a Parsons area tower, while Zach Adams' phone remained on towers near his residence until 9:50 a.m. Then Zach's phone connected to the east-facing sector of the Birdsong Tower near the Tennessee River and I-40 bridge. Between 9:50 and 10:32, his phone made or received multiple calls and texts on the same tower sector. At 10:35, his phone switched to the west-facing sector of the same tower. At 9:42 a.m., Jason Autry's phone registered one call on the east-facing sector of the Birdsong Tower, leading Reeves to conclude that Zach's and Autry's devices were in the same general area near the Tennessee River. Reeves also confirmed that there was no correlation between Autry's phone and Holly's phone that morning. And remember, this is all available to Jason Autry before his proper field trip combo. Reeves further testified that Shane Austin's phone showed no activity until 9:23 a.m. when it connected to a tower serving the Austin residence. Dylan's phone showed no activity until after 4 p.m. Reeves explained that the location of a device is undeterminable during long inactive intervals.
Because I don't think he didn't have a phone. He was using his grandma's or I believe he was using his grandma's or something, and that's why there's no activity on it, which is.
Wouldn't that also explain why they were using caller ID cards? So he didn't look like grandma was calling when I'm using a phone? I don't know how that works.
That makes sense. I would think. I've never used
those.
I checked. So you can answer that question. And I ran all of the cell tower records for that morning and looked at I'm going to get the initials wrong. It's like IMEI and IMSI. It's where you can check whether the SIM
phone
card.
Device.
Yeah, the device and the SIM card have their own. There was no device that morning
that swapped.
That had inconsistent SIM card.
That's wild, because to me that is super incriminating had that been happening, and that just seems like these caller ID cards or whatever the insinuation was at trial. That seems to be what it was. You're trying to do something sneaky and hide who's calling to make someone pick up, or hide that you're the one using this device at this time to call this particular person. It just seems like, why would you go through the trouble of doing that unless you had something to hide? I think it's highly prejudicial. And then
exactly. And now that doesn't mean someone could have switched a SIM card like the day before and then had it. I didn't check whether they were all registered to the same phone, but no SIM card switches happened in any devices that morning during that time period. And like the things they're suggesting, doesn't that all go to premeditation? But this theory of the crime,
it was an accident. They had to deal with it really quickly because they realized they were going to get caught.
Which is it?
Okay, wait. A significant portion of Reeves' post-conviction testimony focused on the Birdsong Tower sectors and the plausibility of the route described by Autry in his trial testimony. Reeves created maps showing predicted coverage and disputed Autry's route. According to Reeves, considering the cell phone data, timeline, and terrain, Autry's route was not feasible. Reeves also analyzed the Parsons Tower data, which indicated that the phones of Austin and Zach were operating on the south sector at 11:16 a.m. This is in Parsons, consistent with the ATM video placing them in Parsons at 11:12 a.m. At the time of trial, Reeves never knew about the ATM video. Throughout his testimony, Reeves emphasized the limitations of the cell tower data, explaining that only a tower and sector can be determined, not a precise location or who was carrying the device, this is what the state really hinged on, which is typically like you see a defense attorney hinge on that when they're defending their client, when the state says their phone records put them here. Well, you don't know they were carrying the phone. In this case, the state was arguing, well, we don't know that just because the Silverado truck and this driving backwards through the ATM, we don't know that Zach was actually there with them just because his phone was also there.
Calling his mom and girlfriend and drug dealers and getting in a fight with his girlfriend on Facebook, calling her a whore. We don't know if that was someone else, a voice actor. Yeah. On this crime that was supposedly not premeditated even, but they had a voice actor ready with a phone to go through an alibi that he then doesn't give police.
Yeah, right. Like, you're not setting this up if it's something you don't think of to put in your back pocket, like a receipt that you'd put in a safe for safekeeping for a purchase. Reeves affirmed several key correlations. The victims in Zach's phones connected to the same tower and sector only once at 9:10 a.m. Zach's and Autry's phones appeared together near the river, and Zach's and Austin's phones appeared together near Zach's home and then in the Parsons area later in the morning. Now, I don't mean to detour, I don't mean to derail us, but the reason this is so important is because if we go through an analysis on appeal where it's, it's going to have to be like cumulative and overlapping issue, like failure to confront on certain testimony or introduce certain issues at the trial so the jury never gets to hear them contested or never gets to hear them at all, never gets to consider them at all because it's just not in the trial record. And then this idea that it's really Victor Dinsmore's brought in to corroborate Autry in some respect. But other than that, Autry, again, is the only witness. He is the star witness to what happened to Holly Bobo, how she was killed, what weapon was used, and how that all ties back to Zachary Adams. So if we see the judge here going, hey, he's reaffirming several key correlations. These are key correlations. Why are they key correlations? Well, because Autry says they get together sometime after 9:10 a.m. And then they go to this river. They're both here at this river at the same point in time. And then we're in Parsons. We know Zach goes to Parsons. I go see my girlfriend at lunch or whatever, wherever she worked. Or I don't know if it was a girlfriend,
Autry
whatever they were called.
Yeah, Autry was rushing back to have lunch with his girlfriend.
Well, and these are key correlations because the state fit their story to fit what Jason Autry was going to say happened that day.
And Jason Autry fit what he was going to say happened that day to the evidence he had available to him that were constraints he was trying to work within.
And all of that is important context, in my opinion, under, well, honestly, Napue with the duty to correct if you think something might be false testimony. And I would argue that if anyone made statements at a plea hearing, like any type of proceeding where somebody's under oath, that duty should be in place at that moment too, not just at a trial for Zach Adams. But also, like, even if you didn't know, if there was a reasonable possibility that you could find out that something was untrue, you still have the duty to go and correct that. Make sure it's right. Make sure it's not being put out in front of a jury when it's not true. So we have the court here saying that these are key correlations. And the direction he's going to go is this is what the state argued, this fit their theory, and thus there's nothing glaringly deficient about why this trial needs to be overturned. But I think it can be argued the other way because of the context Katie just spelled out. So, oh boy. Jason Autry, man. Innocent man walking. Reeves testified that unlike his previous experiences as an expert witness, defense counsel did not discuss his report before the trial, the 2017 trial. So this is going back to Jennifer Thompson, even though she had teammates. Trial counsel did not inform him about the claimed Autry route, nor did she question him about its plausibility. He mentioned that although he was present during Autry's trial testimony, he did not discuss it with counsel. The court reviewed Reeves' trial testimony and finds it's consistent with his hearing testimony. The court observed Mr. Reeves' demeanor and found him credible. And to me, I think this is very helpful. We didn't have certain confrontational questions, subject matter asked of Autry, or really anyone, I would say probably even Booth, who would have testified to looking at these movements.
You know what's really interesting? I don't recall any recordings, and everyone said they didn't make any. I recall no recordings of any aspect of that whole field trip that Jason went on with his attorney and the prosecutors and the investigators to tell his story. And that happened in February of 2017. And then the report was not written until Kathy Ferguson wrote it, and it was written on June 30th. So several months later, supposedly she's quoting things. It's a specific report, and she's supposedly going off of memory, and they're going to deny any recordings. The statement that he gave, unless I'm forgetting, I really don't think I am. I don't believe it went through the actual specific route, but it referenced that they went on that route. Like they went through the specific route, but it didn't have the streets named. And then that came out in
because then you could contest. You could contest what the route actually was.
And Autry's Cross is when that came out, when Thompson asked him the specific roads and got all of that on record, and he walked through it. But I bet there's a recording somewhere the TBI has that goes on a route that is different than the one Autry described to Thompson, and that's why they've been so shady about that. There's no way.
Well, and it'd be awesome if there was post-conviction statements from Jason Autry that could have been considered as part of this record for the post-conviction proceedings. Because I think that's he's the star witness. He's undeniably the star witness, and something that would be so critical to this decision has not yet been heard by a court. So that's, to me, that's a big issue.
And he was going to show up for a Zoom hearing, but the Bureau of Prisons just couldn't connect him that day. And then we find out later that he was on a ventilator after being found unconscious, supposedly of a drug overdose, when he was just transferred, held in federal custody, had no money on his books, no contacts anywhere, and was in administrative segregation. But somehow Autry, who has spent an entire lifetime knowing how to do drugs, just randomly has such a serious overdose with drugs that he doesn't have anything to buy it with, and ends up on a ventilator on the day he's supposed to show up in court.
This is new to me. This is a new one, Katie. I don't think we had footage of Bradley Strawn post-conviction. I remember the name.
I don't remember him. I don't remember him at all, and I don't think
I remember Doug saying the name in argument. That's it. So, guys, this is new. Bradley Strawn did not testify at petitioner's trial, but appeared at the post-conviction hearing and testified about his interview by agent Brent Booth. Strawn explained that Booth had asked whether he had sold a .32 revolver. So he's going in specifically. Booth is asking a specific question of Bradley Strawn to Austin and showed him a photograph of a gun. Strawn stated that he'd never seen the gun before. Strawn consistently denied selling Austin such a weapon and maintained that it was not possible that he did so. And is he going to credit this guy? Let's see. On cross-examination, Strawn acknowledged being close friends with Austin in high school, but they eventually drifted apart when Austin became involved in activities which Strawn opposed. Strawn explained that he inherited a large gun collection from his uncle and stored it at his grandmother's house. He told the TBI that the only way Austin could have obtained one of the guns was through him or by stealing it. He did not believe that Austin stole one of his guns. The court observed Mr. Strawn's demeanor and found him credible. He acknowledged that the limits of his knowledge and his testimony was straightforward and consistent. So the state, if this is some issue on appeal, the state could lean into, we don't have testimony, we can't rule out that the gun was stolen. But yeah, I think largely helpful, because this would have been helpful testimony at trial, I would say.
Well, and even so they're going to say the gun is stolen, but that wasn't what the state presented. The state presented that
it was a drug deal as like an IOU between the boys. And also, I think maybe helpful in a way, if this transcript reflects, and it's not just how I'm interpreting the way it's being written by Judge Bradbury here, but if this transcript reflects a witness saying, Brent Booth came to me and specifically asked me if I sold a .32 revolver, that means that is an agent likely trying, depending on the date of this question, trying to confirm and get corroboration for Jason Autry, to which this corroboration was not found. And yet I don't remember the state introducing this at trial. I feel like the state should want to introduce this and discuss this and get this on the record in front of the jury. And the jury is not aware that agents had doubt about how the story of how this revolver was obtained. They just don't know that was in the air.
Well, I think we have to be really in the context of other things that came out and were played in open court. I think we also have to just be cognizant of how many of these facts and witness accounts are coming in through Brent Booth, and what weight should those have?
Let's see. So he's credited. Paul Dillon. Paul Dillon's the driving guy. Private investigator Paul Dillon was hired by post-conviction counsel to test the plausibility of Autry's travel route, using the route depicted in Trial Exhibit 184 and entered as, so this is the map that Jennifer drew out, I think, right?
I think so, yeah.
Jennifer Thompson. And entered as...
I think he's probably showing some like Rever route maps.
Okay.
Or the record, because he recorded it too.
Yeah, but something that was introduced at trial here. So whatever he testified to at these post-conviction proceedings.
Oh, sorry.
He's using a trial exhibit in his post-conviction testimony because he didn't testify at trial. He was brought on after the fact. So he's referencing something that was an exhibit during the trial, a route that was depicted.
Autry was drawing it. That's probably what it was, his drawing of it.
That's what I think, right?
Okay, yeah.
And entered as PC Exhibit 30. Dillon drove the full path multiple times. His fastest average speed was 43 miles per hour. A dash camera recording of his final drive was entered as PC Exhibit 32 and his written report as PC Exhibit 29. While acknowledging that he did not know the 2011 road conditions, Dillon's fastest time traveling Autry's route in 2025 from the I-40 bridge to the CB&S Bank in Parsons was 43 minutes and 42 seconds.
I don't know what this is fast. What does this mean? His fastest average speed was 43 miles per hour.
I think it's a rough measurement because it doesn't really. It's hard for me to know what that means without knowing. Are there stop signs? Are there traffic lights? Like,
well, that's it. It's like the route by the river when you're essentially like off road. The roads are very different than in Parsons. And so going 43 miles an hour during certain parts of that trip would be irresponsible, whereas other parts it would be like normal. And so I think the point is just that Paul Dillon was driving as fast as was feasibly, not even legally, but feasibly possible to see how fast
it'd be nice if this included max speeds reached. Because I think average waters it down to exactly. The impact. But I do think, Parsons was 43 minutes, 42 seconds, and we're crediting this. So we're crediting this. And this was not presented at trial. And it was not contested by the state, which is another reason why he's crediting it. But I also think it's interesting just in a bubble that it wasn't contested by the state. Jim Simmons. James A. Simmons, an experienced death penalty attorney, was appointed as the first chair defense attorney when the state filed a notice seeking the death penalty. His role was to handle the penalty phase of the case. He believed the ABA guidelines required death penalty attorneys to actively seek a settlement, which influenced his overall approach to the case. He deliberately refrained from sitting at the defense table or examining witnesses during the trial in order to preserve his credibility with a death-qualified jury should a sentencing phase occur. Simmons testified that early in the case, the defense expected Dillon to be the state's cooperating witness. He believed Dillon's TBI statement was unreliable and uncorroborated, and at that time, petitioner's case was defensible. The defense sought a false confession. This is great, I think, because what does that mean? Who became important? Who became the star witness?
Not Dillon.
The defense sought a false confession expert to rebut Dillon's statement. And the reason I keep emphasizing that, you guys, is if there is any issue found in relation to Jason Autry, if there's all these other witnesses that would be like, but for Jason Autry, this was totally defensible. Jury, it would be unreasonable for the jury to be able to reach the conclusion beyond a reasonable doubt without Jason Autry. Well, if any appeals court, federal habeas, if there is an issue with Autry wasn't properly cross-examined, something wasn't brought up, there was a cumulative error effect on, issues with his deals coming forward, it's harder to argue that there wasn't a harmful error. It's harder to say it was harmless when we do have, from this order, from this court, more than once now in this case, pointing to Autry very critical. Key findings. This wasn't defensible when it was just Dillon, but then what happened? I think it's pretty important. So, but they say the defense sought a false confession expert to rebut Dillon's statement. Is that you?
No. No, that's in the trial.
Okay.
I think.
Yeah, because it should be, because Simmons, if Simmons is saying this, it had to be trial phase. The case shifted dramatically when Autry became the state's primary witness. Bingo! Oh my God, he says what I was thinking out loud. I don't know. Now that I'm giving this a more in-depth read than what I did yesterday, I don't know. This looks like very strategic can kicking.
I think what the judge's demeanor does not match the outcome. So I think that's a possibility.
When I see phrases like this that I just highlighted in green, that's when I'm like, hey, that matches the read, like what I felt like I saw from the judge. And he did have a kind of like stoic poker face at other times, but other times he was very much like eyebrows would be raised, lean back, like seemed notably observable. But then we've got Simmons testify that Autry's account, unlike Dillon's, could be corroborated. And unless Autry's account could be thoroughly refuted, it's very important that it's thoroughly refuted, the likelihood of a conviction was high. However, Simmons did not investigate Autry's timeline or route, relying on co-counsel Jennifer Thompson and her guilt phase team for that work. Had Simmons known Autry's version was physically impossible, his advice to the defendant would have been different. What an interesting thing to say and to include in this decision. Accordingly, Simmons pursued a settlement. His position put him at odds with both Zach and Thompson, who remained committed to a full innocence defense and taking the case to trial. Simmons described a schism within the defense team. He believed the ABA guidelines required him to pursue a resolution in light of what he perceived as a likely conviction and a death sentence. However, Zach Adams maintained his desire to go to trial and never admitted guilt. The rift led Simmons to file a motion to withdraw from the case, which he discussed the defense team's disagreement and expressed his expectation of a guilty verdict. And then they cite that was entered as an exhibit in the post-conviction proceedings. When I say PC, I want to say probable cause so badly. It's post-conviction. Once Zach's decision to go to trial was clear, Simmons shifted his efforts entirely towards mitigation. He sought assistance from a mitigation expert, and there was an exhibit entered there at the post-conviction proceedings.
But he's saying that he felt like it was his ethical guideline to encourage Zach to consider a deal, and because he wouldn't, he withdrew. Like, to me, isn't there space between your ethical guideline to inform a client of what your recommendation is, and then if they don't agree and they want to make a reasonable decision for themselves, which I would think anyone who is innocent of murder going to trial to show you're innocent should be a reasonable choice. I mean, that's all right. It just seems like if that was his only reason, then why did he withdraw when it didn't happen?
I don't know. And then also, not for nothing, but if you had all this time before Jason Autry like gets his records, gets his time to review the discovery, you're not preparing for mitigation, which should be like that whole earlier time period. You're just like twiddling your thumbs and hoping Zach changes his mind, is how that kind of seems.
Especially, I mean, Thompson could have used a little help on the guilt and innocence, and he doesn't have to sit at the table and get the credit for it, but he could have been helping more, it seems. I never talked to Jim Simmons, and I don't know that he wasn't doing that just like for sure, but I think that a lot of weight fell on Thompson.
Yeah. And then we know how long Doug said it took him to look through the case, and he said 18 months or something, I think was his number. So, they say Simmons stated that the defense believed the ATM video could have been crucial in establishing Zach's location and timeline by irrefutably placing him in Parsons. They tried to get the footage through subpoenas and direct requests to the bank without success. Simmons could not articulate a strategic reason for stopping the search, other than that they thought this video simply did not exist. I think that's important. He never personally saw any ATM video and was unaware of any such footage in discovery. When shown, and this is also important, that they tried to get it. When shown the video in court, Simmons could not identify the individuals or the vehicle. The court carefully observed Simmons' demeanor and testimony. He was straightforward and not particularly guarded or defensive. The court credits his testimony. Joe Walker, the other Walker, which we did see, this is where we had like about 9 minutes worth of his testimony provided between commentary through court TV. I'm not sure if he was only on the stand that long. It seemed like there were parts missing. Joe Walker, retired TBI agent with about 20 years of experience, became involved in the investigation early on and remained involved through the trial, although he did not testify. He described the case as complex, with many leads, tips, and inconsistent witness statements. According to Agent Walker, many people falsely claimed responsibility for the crime, which he said is common in high-profile cases.
Real quick, to add on what he said, Joe Walker was the case agent when Terry Dykes came off. Joe Walker became the case agent, and in the 600 plus witnesses the state put forth, he wasn't on the list.
They didn't want anyone to discover communications about discovery.
He was not put on the witness list to testify in the trial of this case that he was a case agent on.
Womp. So he testified that investigators relied heavily on records to establish timelines and corroborate the movements of the suspects. So investigators, but who is that? Who was doing this work before him? So he stated that there were numerous conflicting accounts from witnesses, including the co-defendants. He acknowledged that several statements were later determined to be untrue, while others, such as certain aspects of Austin's statement, were corroborated by bank and cell phone records. Agent Walker reported on the results of a subpoena for Austin's record, in relevant part. This is coming from Exhibit 23, which we saw him reference earlier. The transactions for April 13th, 2011 were as follows. $120 from the ATM at Community South Bank, $22.02 from Shell Service Station in Holiday, $10 from Napue, store number 2012 in Parsons, $9.84 Shell Service Station in Parsons, and $6.78 from Sonic Drive in Parsons. A check of video recordings from that date is to be done when a player is obtained for the Napue and a BP video from 641, the highway. The other places were not covered by our videos. So this is the part we saw referenced earlier. Based on cell phone data and bank records, he believes Zach and Austin were together at the bank in Parsons, which was consistent with the timeline investigators had developed. Agent Walker did not find significant inconsistencies with Zach's statements during his own interviews, and stressed that while consistency is important, accuracy matters most. He admitted that despite extensive searches, no physical evidence directly linked Zach to the crime.
That's weird. That statement is weird. But it's very weird that he says, while consistency is important, accuracy matters most, because there's a specific letter that was written regarding an internal document with the TBI. I can't remember if it was Van Hoosier or Walker or Booth, but it was an internal document that was circulated about this case. It specifically said that it's not accuracy they care about, it's consistency. And that was like a moment. It was a moment in the trial. It's weird. It's so weird that sentence, like the reverse of that, is written here. It's so weird.
Well, it's reminding me of the pink panties. We had all this talk about the panties, Dylan. Oh, somebody found panties in the road. Panties, panties, panties. Big scary thing that mind automatically jumps to something intimate of nature when you hear the word panties. And this is a case where there's a abduction and rape allegation of a young girl. And you hear all this. Everybody remembers the panties. Oh, and there's this little detail that has no tie to Holly Bobo whatsoever.
And has DNA of
from someone else, another
female
female.
and male on it.
Like,
and can we take a step back and ask ourselves, what are the possible reasons why a pair of panties that is the same style and general color as Holly's were, but not her panties, finds itself on a road that is then discovered by a friend of Brent Booth's who, like Boat Guy, had Brent Booth's personal cell phone on him to call and report some panties. And then when they show up and collect these panties that don't have anything to do with Holly, but are the same shape, like style and general color, they find evidence that actually is Holly's. Like, I think that's very odd.
Well, they found evidence that other belongings were also found in the area, is what you're saying. Like, so that's, they go there because they find panties in the road that they aren't Holly's, but that's their trigger to go there. But then there's this random, like, was it the torn piece of paper?
It was two things. And like Brent Booth and like walked right up to it. And like the agents, I think it was Terry Dykes and Brent Booth. It was Brent Booth and another agent found them themselves while they're collecting the panties that weren't Holly's.
Yeah. Yeah.
That was found by a friend of Brent Booth's.
That was a whole weird, the whole panties thing is just like a whole.
And that's
like, it just screamed dirty.
Using. That's ultimately what they're using to tie Shane Austin to it, because it was on a road by Shane Austin's house. And this was after Drew Scott said that Shane Austin should be looked at because he's creepy and works at an adult bookstore.
I was going to say it's prejudicial because it makes him look creepy, and then we had the whole sock thing. Like, so it
notably, he says nothing about the coon hunt where Shane was supposedly stalking Holly. I would think that if he was actually concerned about Shane and that happened and that story had already been in
it'd be contemporaneous notation.
Yeah.
And there isn't.
Notably absent.
Crazy. And it all seems off. It all seems like the panties to me are like this, like, oh my God, how horrible. You have these sick perverts. And there was a girl missing, so it must be these groups of this 4 guys. No physical evidence. So he admitted. I do like this language. He's saying he admitted. And to me, that signals, I don't know if you can like read this absolutely, but to me, that's Bradbury being like, hey, Walker didn't want to seem to admit that, but he finally admitted that despite extensive searches, no physical evidence directly linked Zach to the crime. However, some of Zach's prior statements, including those about scratches and alibis, were contradicted by other witnesses or records. Agent Walker described how reviewing the accumulated evidence in 2014 revealed the names of Zach, Dylan, Autry, and Austin had appeared repeatedly in tips and statements, and this is in quotes from day one, but had not been pursued adequately when Terry Britt was the investigative focus. Agent Walker testified that Tennessee Highway Patrolman Warren Rainey saw Zach washing a mattress and cleaning his truck after Holly was abducted. Agent Walker stated that wasn't the washing from the guy that was in the woods?
Yeah, Warren Rainey was in the woods with binoculars spying on Zach.
Oh, I thought Warren Rainey had 2 guys go in the woods, but he wasn't with them the whole time, and it was one of the guys that actually saw the washing of the back of the truck. And
you might have that right. I might have it wrong because I haven't watched that in a while. By recollection, I thought I remembered he was somewhere in the woods with binoculars, but I could be
Yeah, I thought it was like 3 guys total, and he
That sounds
leaves
right.
the
Yeah.
2 in there, and then like the random other guy sees like this longer expanse of time, but it's relayed to Warren Rainey, which means it's being relayed to Agent Walker, but Walker's saying like, well, Warren Rainey personally acknowledged that.
I
Um,
also, why do they're saying washing a mattress?
Team of
Like
5 maybe.
they were, I mean, it was a leaf blower that he was blowing leaves off of it. And to say washing a mattress is like hosing it down. Like, are they implying that he had a blood soaked mattress and he went to such lengths as to hire a voice actor to pretend to be him on his phone elsewhere, but then was just washing a bloody mattress in front of everybody while the whole town's looking for Holly? It's a leaf blower. I think that's misleading to say washing. I said I would not make so many tangents, and I'm going to do better.
Well, although it misleading as far as it could be Agent Walker's testimony,
Yes.
not
Not
a
his
factual
writing of it.
finding by. But this is the thing, like this is such a long order that like there could be so much page space, real estate taken up by just like, hey, so and so said this, but this was actually refuted by this other thing that was not included in the credibility assessment by like these one-offs would take up so much space to write these all out because we've out loud just on gut instinct are like, hey, here's like a dozen examples where that's actually refuted. They say that Agent Walker stated that the floor at Austin's house had been painted. He also learned that Autry's original alibi that he was at work was false. Well, okay, so that means your star witness is lying. Walker stated Autry's later account was ultimately deemed credible and partly supported by cell phone data.
The
He
cell
admitted
phone
that
data he was placing it around.
because he knew he had to correct it. His early thing is false. We have to correct. Now we have cell phone data. We could work from that. Like, this is like the ultimate can kicking. Like, it's right there. The problem is right here.
You know what the biggest tell to me, just the subtle things in someone's testimony, that Autry is basing all this on cell phone records, is he's talking about the details of something that happened years ago. And people anchor by events like, oh, it happened before I went here, there, whatever. And he goes, then at 2:15, because the cell phone records have him calling at 2:15 and he's memorized this. So as he's like, you can picture what someone's picturing in their mind as they're recalling an event by the details they're including.
It's like
Like
playing a murder mystery board game where the murder
yes.
mystery gives you the cards of the information and you have to use that to figure it out.
Yeah. And it's like he you can tell by how he's just, it was a 2:15. It's like you can tell he's not picturing the scene in his mind. He's picturing the cell phone record that he was staring at and memorizing in his cell that said 2:15 on it.
Crazy. He admitted that Autry's statements, like others in the case, contained inconsistencies. Agent Walker explained Terry Britt had been thoroughly investigated but was ultimately ruled out as a suspect because no evidence tied him to the crime. Also, Britt's known patterns of behavior did not match the circumstances of this offense. Still, Agent Walker acknowledged certain ambiguous statements made by Britt could be interpreted in different ways. Agent Walker participated in the PowerPoint presentation by Agent Dykus. According to Agent Walker, no one from TBI nor the prosecution team agreed with Dykus' theory. Agent Walker acknowledged that Dennis Benjamin, a civilian investigator for the Bobo family, assisted the TBI with the case. Agent Walker claimed to have never personally met Benjamin and received information about him through other agents. That's odd because if you took over after Dykus was out, shouldn't you have had closer contact with this person who was woven throughout this story and doing visits that were relied upon?
He didn't come in until I think November of 2013. I might be a little off. It's on the, I'm pretty sure it's November of 2013. And so Dykus would have, I think Dykus was brought off the case in May of 2012. And then Walker would have taken over from there as a case agent. And then months, like, it was weird. Like, nothing really happened in 2013. It's like they kind of just forgot about it and came around again big. Yeah, I want to take it.
They say, but Agent Walker reported telling.
I'll be right back. I might have a.
An inmate at the Tennessee Department of Corrections, Morgan
I'll be right
County
back.
Corrections.
Oh, all right. We'll pause. We'll pause if Katie needs us to pause. But Agent Walker reported telling a Candace Johnson. So he told somebody. He seems like he was confronted with this. Benjamin was a good guy and that he had helped the Bobo family and TBI in the case. And whatever this was, the statement seems like it was admitted as an exhibit during the post-conviction proceedings. Yeah, literally, the chat's on it. Through his testimony, Walker acknowledged several investigative shortcomings. He admitted he did not review certain videos, including the ATM video. And that's referring to Exhibit 8, which was earlier. Despite having written in an investigative report that some locations were not covered by our videos. I think this is important for appeal because if you're writing in a report that this was not recovered, why should the defense reasonably have been able to discover it in discovery in the folder upon folder upon folder upon folder, the like 7-layer nested folders after the renaming of the title of the video to not have the phrase ATM in the folder name? Why would we expect to find it? Hey, Katie.
Hi. Zach thanks everyone for the support, and I don't think he's up for saying hi, but he's thankful for the support and for everyone continuing to pay attention to the case.
Well, chat was excited to hear that you got a call come in. So next time you speak to him, relay that to him.
I will. I think he might. Yeah, he might say hi at some other point, but I was hoping that he might today. But I think it's a tough day.
I think everybody understands. So I think the idea that none of us are the one personally losing our freedom over this, but I feel like I had a visceral reaction. I saw others express that they had like a visceral, physiological reaction to the news. Like I think the chat will understand.
Oh, yeah.
But love how the chat very quickly was like, oh my God, hey, Zach. So,
yeah, I think he's taking it pretty well, just all things considering. It's like the hope that you have to cycle through and
Now keep this up. Look at Kinsey up on the screen with some good words here. And while we were paused, I was just highlighting here that, like, we have another recitation here that in this investigative report, it was represented by counsel, officers of the court, investigators, agents of the state, right? All part of the state. Whoever, whether it's law enforcement, whether it's a prosecutor. You have this stuff turned over in discovery. And sure, maybe this ATM video was in there buried somewhere through these nested layers of folders. But you have an investigative report by the case agent saying that what would have been a bank, whatever it was called back then, these other businesses, if it's not here, it wasn't covered by our videos. And the investigative report spells out other businesses, but does not discuss ATM surveillance at this bank. And that's something that a defense attorney could reasonably rely on as a representation by the state. So could it reasonably have been discovered by the defense in the context of where it was located in these folders, how it was named or not named, and what they could have seen if they were reading the investigative reports, that we looked and this is all we had. And then we know that Simmons said, look, we tried to make sure, we tried to subpoena it ourselves just to be sure. We tried to do extra diligence even in spite of this. So we tried, and we didn't come across this until later.
And Walker didn't just randomly put that in a report. It was in response to knowledge that the defense was trying to get these videos. That's why it was written. It's like, it's not just what's written, but why is that the thing that's being written? They knew full well. And they want to, I mean, you can't have it both ways. It's like, oh, of course it's right here in these 7 subfolders. I mean, anyone could find it.
Yeah.
But it didn't exist until you got caught with it.
And then can you put in the chat where to send letters or cards maybe, and I'll update the description after this, but if you have it handy, or if Kinsey maybe has it handy.
Yes.
Let people know where they could show some love.
Absolutely.
And again, replay crew, if you're like joining in the middle of this, I'll update it after the stream. Not a very good multitasker. He confirmed that at the direction of a prosecutor, he supplied at a prosecutor. We just have a prosecutor. He supplied discovery. I hate when we do not want to name the names. I hate when we do not want to name the names. Say the name. Whose direction was it? He supplied discovery material, and especially since this same prosecutor is a testifying witness and was asked about this line of questioning, I think it's critical that she should be named here. And yet we do not have this named here. So I always have a pet peeve about that, but I think it would be especially apt to actually name the prosecutor here because we're going to make a credibility finding on her later. But he says that at the direction of a prosecutor, he supplied discovery materials to Autry's attorney before Autry became a cooperating witness. When asked whether learning he might have missed reviewing a relevant video troubled him, and we got to see this, we watched these clips, he stated he would want to be certain before drawing conclusions, but agreed it could be significant if accurate. So if it's actually out there, he didn't want to concede that it actually is out there or could represent what the defense seems to think it's going to represent, but he couldn't just flat out say, no, it wouldn't be insignificant, which I think is very helpful, especially to say reluctantly.
And I'm sorry, when you're going through those videos, it's so monotonous and miserable, and you're just like kind of fast forwarding. It's obvious when you see a truck circle or like go the opposite direction of all the other vehicles. It's just not the kind of thing that anyone who's awake is gonna not notice.
Well, it just shows that, like, oh, they're gonna make the argument and only show a still frame because they know that you can't discern that. A common sense viewer couldn't discern that from a still frame that's zoomed in, cropped in, where you can't see like the vantage point of where the surveillance camera is, or like any lane markings. Some ATMs will put like the arrow painting to say you should be moving this way.
Yeah,
like if we're so cropped in and zoomed in, we just show a frame.
You can tell when you look at it that it's the passenger side of the vehicle that's facing
where the window would be.
But yeah, someone's not going to think of that on their own. Like, that's not the kind of thing that you know.
Or it could be like, I don't know if this is like a reverse image, the way it's being taken. Could be one explanation. But when you see like a car visibly, what you're saying, exactly that, compared to 24 other cars do one thing and one does this is the anomaly. This one car moving in this direction is the anomaly. Like a car going the wrong way down the road.
And it was like it to the investigators, it would have been obvious because what's in the actual file is it's like a video of still frames where it's like shots, like a flip book. And so you're still fast forwarding through it like a video, and you see the flips, like the flip book shots of all the vehicles going in one direction and then now going in another.
The flip book.
Yeah.
But yeah, you can see the visuals move frame by frame. It doesn't take away the understanding of what every other car is doing just because it's not actually a moving picture.
Yeah, like it was basically, I think it would have been more obvious to the investigators than how it was presented to us.
Yeah, especially if they just looked quick and didn't actually think to look at them in order. We've got James Austin. So this is the father of co-defendant Shane Austin. I don't believe we saw his testimony at all. He testified regarding his son's firearm ownership, drug addiction, living circumstances, and associations. He confirmed that Shane owned a .357 handgun, a photograph of which was entered as an exhibit in the post-conviction proceedings, Exhibit 55. Mr. Austin discussed his son's long-term morphine addiction. During cross-examination, he admitted that he did not know everything his son was doing during the height of his addiction, but it would have been impossible for his son to have guns without his knowledge. Mr. Austin testified definitively that Shane did not own a .32 revolver. The court found this testimony credible. I think that's important because, again, this to me is that cumulative credibility question on Autry. I almost said Austin, on Autry, right? Because it all comes down to how do we put this gun in Zach Adams' hands? Well, this gun has to be something that Shane had the opportunity to access, and that Jason Autry was aware that that's where it came from because that's what his statements need to conform to, and so on. Brent Booth, you guys ready for this one? Brent Booth, a veteran law enforcement officer who joined TBI in 1996 and recently retired, testified for the state at trial. He was involved in the investigation from the outset. Booth described participating in multiple key investigative steps, including a February 7th, 2017 reenactment in which Autry guided investigators along the route he claimed to have taken on the day of the crime. So Booth testified about this field trip. Booth recalled Autry identifying the weapon used as a revolver, possibly a .357. Booth remembered seeing video footage showing a truck passing through an ATM in Parsons. According to Booth, he and Agent Dykus viewed the video in May of 2011. The vehicle in the footage was not identifiable, and Booth did not prepare a report documenting the video because it had been collected by another agent. Despite knowing the video existed, he never corrected another agent's report that stated no such video existed. Booth believed investigators had informed prosecutors about the video, and he understood that it generally aligned with bank records reflecting Austin's activity in Parsons that morning. Regarding the suspect Terry Britt, Booth acknowledged swearing out a search warrant, asserting probable cause existed that Britt had committed the crime. Booth testified that he initially considered Britt a viable suspect, but changed his view after wiretaps and searches produced no evidence. The shift in opinion was based on the totality of the evidence, or lack thereof, gathered during that period.
Okay, so he's saying that he had probable cause to believe this, and what shifted his mind was a lack of additional evidence on a wiretap that starts off with Britt telling people, don't say anything on this phone, I'm probably tapped. And Britt, a skilled criminal, then doesn't say, and frankly, I think there are a lot of things on the wiretap that are, if not incriminating, certainly concerning. And
the full circle on the point you just made is that Doug has to question to ask witnesses like Brent Booth at these post-conviction proceedings if they're even privy to Brent Booth, if they were contemporaneously aware that Britt was telling people, hey, watch what you say. They were not, they did not seem to have contemporaneous awareness.
That he has said that?
Yes. Which to me, if you don't even know that, if you're not listening to the first things that people are saying on the calls, how much of it are you really listening to?
Yeah, I think that how they seem and what they knew are two different things. I think that there are some things on that wiretap that will explain why nobody wanted to touch it. And it's not a lack of any evidence. It's some shit that Terry Britt was saying that nobody wants published.
Oh, well, that's why you got to ignore the whole thing. Ignore the whole thing.
Nothing to
Just
see
crazy.
here.
Just crazy, because again, this is the exact type of thing that if the vision, if the target was actually on Britt, you would not hear the end of a prosecutor stating, he told everybody, watch what you say here. He was well aware. He had like the foresight to prepare for consciousness of guilt, like to warn people not to say anything incriminating. But here they're not going to harp on it because they just want to say nothing to see here.
Now, to be accurate, I don't know that he had the foresight to give him that credit. If by recollection, I think it was actually in response to a family member asking if they found any blood in
the van, one of the vans,
on the couch inside or something. Something where it's like,
yeah. What was the part where he said something to the effect of, "Well, they shouldn't have found it in," and then he gave the specific van. One of the vans.
The cadaver dogs hit on the red and white van, and it's like not funny, but it's just, it kind of is in just how crazy it is. And he was saying, well, maybe it was the scrap meat he was hauling, and Janet's like, well, no, they said the dogs are specific to human decomposing flesh. It wouldn't be animals. And he goes, well, I know there ain't no fucking decomposing human flesh in that old red van. And then there's
very specific
awkward silence. And Janet's like clearly thinking the same thing I am, knowing that they've already discussed that they think the phones are tapped. And then Janet's like, well, either van. And he's like, oh, yeah. It's like, he just like it is on his testimony on the stand. It's just, I mean, he's talking about if they found some boots. No, he shredded them and had them hidden in the back. And then I found some pictures of some boots in the back, kind of tucked under that match the description that Clint gave. So there's stuff on it that I would consider not
I want to be clear.
exonerating.
Not that I would root in general for Terry Britt, but on the grounds of a constitutionally fair trial, fair prosecution, I would love in a parallel universe to watch the state to try him for all of this based on the way this has just been butchered along the entire way. And I think it's the problem is if the jury gets to hear that he's the creepy guy, they're going to convict, but I don't think it would necessarily be because the state would prove their burden at a trial against Terry Britt because there's all these other issues. There's all these other issues.
They would never prove their burden. They wouldn't
and it would just come down to the jury convicting on an emotional plea. Who else could have done it? Whatever. So, and I really think that's important.
That one would have been such an easier one. That doesn't it make you wonder, what did Terry Britt have on somebody with influence in this case to possibly, because whether he was guilty or not, we know they don't care. They were going to set somebody up. So even if Terry Britt wasn't guilty,
we'll use the jailhouse witness that says that Holly was in a well.
Why would you, if you were going to set somebody up, why would you pick Zach and Dylan as troublesome as Zach was? I mean, as somebody who is a representative of wrongful conviction injustices, I'd have a hard time not just finding Terry Britt guilty whether I thought he did it or not. It'd be hard because look at it. I mean, his past is so disturbingly bad.
Yeah.
That if they set someone up, it's just from a strategic standpoint and like getting in their head, it's like, Terry Britt.
That was Jennifer Nichols' testimony in the PCR where she's like, well, we would have issues taking him to trial because of rules of evidence, like character evidence and stuff. We wouldn't be able to use that stuff at trial, so we'd have trouble prosecuting him. And while I 100% agree with her sentiment, it still struck me because it's just like, it seems like such a selective application of that sentiment. You don't care in other cases, so to hear you admit in this context that you suddenly care,
it's how they convicted Zach that he was a bad kid or bad guy and he had done this and that and he was dealing, like, isn't that entirely what they did to Zach? But they're saying, well,
what they had Earp come testify to. Yeah,
I mean, that's what they were doing. But then with Terry, it's like, well, we couldn't bring up any of his past predatory sexual behavior that followed a similar MO. So I don't know, we're at a loss.
Yeah. So, I mean, and again, I would love to watch in a parallel universe, like a simulation, to see how this would play out and be able to watch the state try to rehab a piss poor investigation. But, all right. So they say according to Brent Booth, his view on Britt being a viable suspect changed. And it's kind of interesting that, again, his testimony seems to focus, like, he prepares this probable cause affidavit, but it wasn't really the insistence of others, like go try to like wiretap. And Booth's just like, I believed it was Britt so much because I want you to believe that I eliminated a possible suspect. It was my suspicion, and I had to confront my own confirmation bias, which is such a hard thing for humans to do. But it was so obvious after listening to this wiretaps that it obviously couldn't have been this other person. So I made the decision to change my mind. It's like very interesting to me that he takes this grandiose accountability for the whole suspicion of Terry Britt. And I personally do not believe that he was 100% gung-ho and then changed his mind because he was confronted with the obvious that it couldn't have, that these wiretaps exonerated somebody.
You know what I've always been real suspicious about? I just find it odd. Terry Britt was so central to the investigation, and Brent Booth is all over this case. And I don't remember of any interviews that I've seen of Brent Booth with Terry Britt. And if there were any, it's very it's limited compared to, it's like he really wasn't involved in the Terry Britt aspect directly in terms of the interactions. It didn't seem like he was interacting much with Terry Britt directly, whereas he clearly seemed to be the boots on the ground guy that was interviewing everyone else. And
making sure that this probable cause and wiretaps, he handled that stage of Terry Britt.
It's like he's handling the Terry Britt investigation from afar, but not interacting directly with him. And then he's acting like, well, this Terry Britt guy that we discovered on sex offender registry, Brent Booth and Terry Britt go back to the 70s and 80s. Like, Terry Britt was a frequent stayer at the Henderson County Jail, where Brent Booth worked from 1985 to 1995 when he went to the TBI. And there is a lot of back history between Terry Britt and that department. They knew each other real well. And it's curious why a TBI agent who has such a history and goes back with such knowledge and common mutual connections with a suspect wouldn't be used to interview that suspect when he seems to be interviewing everyone else.
Oh, and he says the shift in opinion was based on the totality of the evidence or lack thereof gathered during that period. Booth highlighted the challenges of the investigation, noting that many witnesses provided inconsistent or false statements and that the case lacked physical evidence. For example, Clint Bobo made multiple inconsistent statements. Booth discussed information from Sheila Kilzer, okay, who claimed Dillon had described involvement with the victim. He ultimately determined both Kilzer. Why are we saying that? Right?
Kilzer?
We're just like changing her name here.
Oh.
So just note that if anyone's going to do like a quick search on Page to look at what was discussed of Kilzer, it's spelled multiple ways here. And her search was unreliable and acknowledged that their account conflicted with Autry's version of events. He could not determine which, if either, was true. Okay. Booth acknowledged inconsistencies between Autry's account and cell phone records and travel times. He agreed that aspects of Autry's story, such as time spent in certain locations, did not align with available records. He expressed doubts that events occurred exactly as Autry described, particularly given distances traveled, timing, and the potential presence of witnesses, and law enforcement activity. Booth explored a theory that the body was hidden at Austin's grandmother's house, and under that scenario, Autry's statement would be untrue. According to Booth, although a .32 caliber weapon was recovered, some witness accounts reference different caliber weapons. He stated he was unaware of certain ballistic evidence, specifically a .380 casing found near the remains, until much later. Oh, he's the first guy everybody calls, except for this little tidbit. Booth discusses interviews with Victor Dinsmore, a key state witness. I love this clarification. Someone's key, and if something that they say is disputable, we have an issue then on
a key state witness. That's
prejudice prong. Yeah, so he's put key a few times, and I think it's interesting because to me that points to a harmless error analysis. If someone's critical, and recordings show Booth was using interrogation techniques that included suggesting facts or applying pressure to elicit information. So this is coming from the recordings. So these are the exhibits that we got to listen to, the recordings, 58 and 63. So he's suggesting facts or applying pressure to elicit information. He acknowledged using such methods, but stated his intention was to obtain truthful statements, not induce false ones. Booth followed up with Dinsmore to ensure he had not prompted untruths. Oh man, I hope any appeals court listens to those exhibits themselves. The court carefully observed Booth throughout his testimony. At times, he was defensive and insistent. Nevertheless, he testified consistently with his trial testimony, which was credited by petitioner's jury and by this court. So he's saying that the Judge McGinley credited his trial testimony, right? He's saying was credited. This is very interesting if you ask me. We're in like yellow territory.
That's very interesting wording.
Compared to all of the others, because this is witness K. This is like the whatever letter in the alphabet K is, we've gone through that many other witnesses so far. And we're crediting.
It's interesting what would happen given that he's not saying he personally found Booth credible. He's saying he found Booth defensive and insistent. Yet the trial...
It was consistent. And what do we have about consistency?
We love consistency. It was consistent with what the trial testimony was, which was credited by petitioner's jury and by this court. It makes me wonder how...
It's not a new fact finding.
And what would
This
happen?
to me is not a new fact finding.
What would happen if it became clear that Booth was definitely lying, given that?
That means the jury heard things about a key witness, because testimony about Dinsmore and how Booth looked at things was Booth testified at the trial in front of the jury that convicted about his steps to corroborate these critical issues between Victor Dinsmore and Autry. This is what I'm saying. Like, I think this is like, it pisses me off when the can gets kicked. I don't know why I was optimistic that Bradbury wouldn't be like every other judge and kick the can down the road to the appeals court. But I think his wording was interesting. Or maybe it's not even that. Maybe it's not like the strategic can kicking, but when you want to hold on to something as being true so badly, but there's like a glaring deficiency where you can't even in your gut just be like, I don't see a problem with that.
Mm-hmm.
You'll find a way to say something like, well, at times it was defensive and insistent, but I don't know, the other court, someone else says it was true. And you'll hold on to it through that like very hedging type of way to not have to say out loud, like, something doesn't seem completely true about this.
And
I think this wording is extremely interesting.
I agree with you entirely on that. And I do think that is something that if somebody, like, if you're writing an ethical report or you're putting your findings down ethically, you're not going to, you're going to write the things objectively that argue against what you're saying. And there's no that doesn't support his ultimate finding. It just sits there in contradiction with it, where I guess he's saying the totality of everything else.
Yeah, and I think this wording really stems on this. He recordings show that Booth was doing something, right? That to me is like a recording shows. That is a fact finding. This recording showed is a fact finding. That is the court interpreting that he's using techniques that involve suggesting facts or applying pressure, and then he's reciting the testimony that Booth gave to explain that. Yeah, but I was just trying to obtain truthful statements, not induce false ones, and then I was just trying to make sure the next day that he wasn't giving me an untruth the next day. And I think paired with this ultimate look, he was consistent with testimony that somebody else made a determination on. We're missing a factual determination by Brent Bradbury for what's all encompassed by the PCR record. The most we have is him just saying, well, he came off as defensive and insistent, and the recordings kind of contest that. I think this is so critical because of how this is worded and because it pertains to the credibility of a witness who corroborated star witness Jason Autry. So next we have up Art Viveros, Mr. Arthur Viveros. A special agent with the FBI for approximately 27 years, he became involved in the Holly Bobo investigation on the day of the abduction and remained on the case until his retirement in March of 2012.
His name's not Arthur, it's Arturo. It's just another factual error.
Nope.
They add up.
That's hilarious because I have a friend who named her dog Arturo. I think that's like the only time I've heard that name besides Viveros. We've got was involved the day of the abduction, remained on the case until his retirement in March of 2012. He worked closely with agents Dykes and Booth, conducting interviews, gathering intelligence, and assisting with investigative strategies. Agent Viveros testified for the defense at trial. Early in the investigation, Viveros concentrated on suspect Terry Britt, a convicted sex offender who, in his assessment, fit the physical description provided by Clint Bobo. He believed there was a strong circumstantial case against Britt. He described Britt's demeanor as nervous and evasive during questioning. For example, Britt insisted that his wife come home from work to retrieve a receipt from their safe, documenting an alibi for the morning of the abduction. Viveros helped initiate the wiretap and other electronic surveillance targeting Britt. Yeah, see, now Bradbury's adding this layer, like, this is what Booth testified to, but then here we're going to say Viveros helped with that thing that Booth just took all the credit for. Technical issues resulted in incomplete recordings, but Viveros documented critical conversations and notes and reports. He recalled Britt believing the state was trying to pin the case on him and denying even knowing Holly. He said Britt made odd remarks to establish an alibi and that Janet Britt, the wife, said all kinds of women's hair would be found in their van. And it's a reference to Exhibit 82 from the post-conviction proceedings. According to Viveros, a hair found in the van was microscopically similar to Holly's hair. Despite his focus on Britt, Viveros acknowledged other leads existed and he was not involved in the investigation after his retirement. Viveros had minimal contact with Zach. He recalled that Zach denied involvement in the case when asked by members of Holly's family. Viveros interviewed Clint Bobo and Holly's boyfriend. He recorded statements from other witnesses who claimed Zach had made threatening or incriminating remarks about the victim. Importantly, right, so we're getting it importantly, Viveros interviewed Carl Statler, who testified that he had heard Zach say, "I let Shane hit it, and you'll end up like Holly Bobo, bitch." Viveros and Booth also interviewed Victor Dinsmore, who heard Zach threaten his girlfriend, saying he would put her in the ground like Holly Bobo. Viveros received a trial transcript. Go ahead.
I think it's important to note the connections here that Carl Statler was in a relationship with Victor's daughter and was essentially his son-in-law. So these aren't like random people coming together that just have consistent
independent corroboration.
Most of the witnesses that had these, like, Zach said this, Zach said that, have one degree of connection away from Victor Dinsmore.
And that's all like an issue of like, even if it's not an intentional getting our story straight, it's you hear the chatter and you're contaminated, your memory, your recall is contaminated by the gossip because you're all talking about it within a familiar context. So that your recall from that chatter could correlatively, not causally, seem to corroborate what the other person's impression of a case is. So.
And someone just asked, isn't it Carl who supposedly told Dinsmore the gun might have a body on it? No, that was Jamie Darnell, who is the brother of
Was that the guy with the house issue?
Yes, the guy with the house issue that is the brother of Danielle Darnell. I'm sorry, Danielle and Carl Statler are siblings, and Danielle and Jamie were married.
So many names.
They're all like very closely connected.
Okay, and this is important too. So then the next thing Bradbury recites is that Viveros received a trial subpoena from Jennifer Thompson, but never spoke to her until after the trial began. Even then, Viveros called Thompson to inquire whether he would be called to testify. She asked him to come to court the following day. Viveros stated that Thompson called him as a witness without discussing his testimony. We're gonna green that because I think. Go. On cross-examination, Viveros acknowledged disagreements with other investigators, particularly regarding the timeline of events. He maintained his belief in Britt as the primary suspect based on the evidence available during his time on the case. Agent Viveros was calm and consistent while testifying. His testimony during this hearing is consistent with his trial testimony and is supported by documented proof. So we don't necessarily have this documented proof qualifier for the others. We're getting a crediting here, and we're getting this additional particularity here that it's also supported by documented proof.
Oh man, I want to know what
Beth
he says
Boswell.
about Beth Boswell.
Beth Boswell. Beth Boswell is the former assistant district attorney that prosecuted this case until August 2014 when she transitioned to being an AUSA. In that capacity, she prosecuted Dillon in federal court. Initially, though, Boswell collaborated closely with TBI, advising on investigative steps and participating in discussions leading up to potential indictments. She relied heavily on law enforcement for factual development, including cell phone data, which she did not independently analyze or reconstruct. Boswell explained that Terry Britt emerged as a significant suspect, and by early 2012, investigators believed they had probable cause to pursue more intrusive investigative measures. She reviewed and approved wiretap application on Britt's phones and home. The wiretaps, along with searches of Britt's home and vehicles, forensic testing, and surveillance, produced no evidence linking Britt to the crime. Ultimately, Britt was excluded as a suspect. Boswell testified that Clint Bobo's multiple statements presented challenges. Clint initially believed the man seen with Holly was her boyfriend based on the voice he heard, but voice identification attempts varied. Clint described the suspect's appearance as matching both Austin and Britt. These inconsistencies reduced Clint's reliability as a witness. Boswell described notable disagreements among agents, especially surrounding Agent Dykes' work. Dykes once presented a PowerPoint that Britt committed the crime. It's so weird to me that their position is all that, like, Dykes was the only one looking at this guy, but then they also at the same time want to have their cake and eat it too and say, we all looked at him and eliminated him because it was just, there's so much evidence showing that it wasn't him.
But
no evidence at all.
Everyone thought Dykes was wrong. No one can give any actual information for why the investigation shifted, other than, well, we didn't find anything on the wiretap that he knew we were listening to, per his own
that Dykes and Viveros had to advocate for, even though Brett's trying to assume credit for it.
And I think it's even more suspicious for them to say everyone thought Dykes was wrong, given the senior investigator from U.S. Marshals and the lead FBI agent consulting on the case all very much agreed with what Dykes is saying. So why is everyone in TBI
3 agencies
disregarding?
Yep. Well,
if he doesn't say anything about how many bottles of water she drank on the stand, I'll be disappointed even more than I already am.
Oh, and the misstatement of a prostitute's purse. They say that Boswell describes notable disagreements among agents, especially surrounding Dykes' work. Dykes once presented a PowerPoint that Britt committed the crime. The elected district attorney, TBI supervisors, and Boswell were in attendance and were unpersuaded. By 2013, the investigation shifted away from Britt. Boswell attributed this change to accumulated leads, including a statement from Sheila Kilzer, spelled correctly now. Well, not really. Sheila's spelled wrong.
Dang.
Directing attention to Zach and the co-defendants. You had like months, Bradbury, get the spelling right. Boswell testified Dillon's statement was significant in helping solve the case because he provided unknown information. She believed Dillon's statements when given, but agreed it was fundamentally different from Autry's testimony. And we need Autry's to be correct because that's what the jury heard. You see the catch-22 here? Dillon's plea agreement in federal court resulted in his release. According to Boswell, Dillon did not want to return home, and he requested to live with Dennis Benjamin. She maintained that the living arrangement with Benjamin was for Dillon's protection and not to influence his anticipated testimony.
For his protection, as in its witness protection?
And not for nothing, but why should anybody go live with somebody who's working for the victim's family if they're going to be a testifying witness?
If they had any concern whatsoever that Dillon may have anything to say about the Holly Bobo case, if they had any ethical basis to their decision-making whatsoever, the last thing they would ever do is place him in the home of a retired Memphis cop who's working as an unlicensed PI for the Bobo family at the time and engaging in a lot of inappropriate relationships around this case. It is the last thing they would do. They would say, no, we don't want to taint our evidence with this clear and blatant, obnoxiously ridiculous ethical violation and conflict.
I want SCOTUS to weigh in on this, on the Dennis Benjamin, everything's honky-dory.
It's so bad. It's
Boswell drafted, it's like a violation of several constitutional rights, I would say. But the before, during, and after of it all.
A man who documented testing results from school, a clear documented history that makes him vulnerable to manipulation and pressure and confabulation, where he is saying things that are not true. It's like you have the perfectly designed victim for this. Almost like
and then the co-defendant can't confront it meaningfully.
It's almost like someone named Dennis Benjamin showed up into town as a fixer, found his victims that he was going to allegedly set up for the crime and then finished cooking the one that they couldn't get to tell the story accurately enough, allegedly.
After Victor Dinsmore said go for that one. Boswell drafted an immunity agreement for Austin, which was never finalized because he did not provide the location of Holly's remains. The court observed Boswell through her testimony and credits the same. It's interesting that that's the only information we have about conference of benefits. That's the only thing that we recite from Beth Boswell's testimony is in relation to Austin. To me, that signals that makes Jason Autry all the more important, and we're not going to make factual. I think that's problematic because I think the leniency issues, which Boswell played a critical role in, any kind of communications about state versus federal cases, pending time, benefits, she was literally titled in the two positions through the timeline of this case. I don't know, but he finds her credible.
Now, is that what observed? But the court observed Boswell throughout her testimony. And
I don't know what this means.
I don't. Does that say? Because that to me, that's like with all due respect. When I'm responding to Amy Wyrick in an email, I'm not telling her how much. I'm just saying the amount that is due, and the rest is left open. That's how that sentence reads to me.
We'll yellow it for interesting language. I don't know.
Dylan
it looks like he deleted something.
Dennis Benjamin, just FYI for the chats.
So yeah, but the problem here with this is, first of all, this is the type of thing that I think we would need clarification. It looks like a mistake. It looks like something was typed here and then lost in reformatting or just like removed and not reworded. You know, you ever do that when you're like working with a Word document? You like remove a sentence and don't put something else back.
Yeah.
It to me, it reads as incomplete, but it's a critical finding. I don't really feel like this is an explicit. Is this really a crediting of Beth Boswell? And why that's so critical is Brooklyn's asking right here. So is this a lie? He didn't request to live with Dennis Benjamin. We're going to get there, but he's going to make a finding that Dylan is not credible. And I would assume that it necessarily relies on Beth Boswell's testimony that no, he said he wanted to go live with that reason. Wanted to go live with Dennis Benjamin. And so if we don't have a finding, an explicit finding, whether to credit her or not, we're crediting the same, but what is the same?
Well, I'm sure they have
her
something
testimony
that Dylan signed that says that he requested it. I'm sure that I haven't seen it, but I wouldn't be surprised at all. Like, look at the situation. Does anyone possibly believe that Dylan requested to live with Dennis Benjamin, who he didn't know who he was until he?
I think it's an unreasonable fact finding. You mean, like, would this be a rare instance where we get into arguing the reasonableness of a factual determination? Because I think that's
Dylan didn't even know who Dennis Benjamin was.
So, yeah. And I don't know. So I think he's saying that he observed Boswell and credits her testimony, but it's kind of weird that he gets a little more specific with observing demeanor and body language, but doesn't do that for Boswell. So to me, the absence of something.
It's like it's implied and we're left to determine what the implication is.
Yeah. Then we've got Jerry Gonzalez. Attorney Jerry Gonzalez testified that he joined Zach's defense team just before the trial at the request of Jennifer Thompson. According to Gonzalez, Thompson needed additional support because she and co-counsel Jim Simmons were no longer speaking. Gonzalez repeatedly asked Thompson for clear guidance on the defense strategy, but never received any. So he prepared on his own with little direction. He focused on the medical examiner's testimony and reviewed medical literature and consulted forensic experts. He questioned whether the fatal injury could be definitively attributed to a specific caliber bullet. He emphasized the uncertainty in determining a gun's caliber from skull damage and maintained that a .380 weapon could not be excluded as the murder weapon. Gonzalez confirmed the defense was aware that Autry would testify, but did not recall detailed strategy sessions about his testimony. Gonzalez described the trial environment as very tense, with significant friction among defense attorneys, prosecutors, and the judge. Thompson's conflicts with the co-defendant's attorneys and with prosecutor Jennifer Nichols caused her great stress. According to Gonzalez, prosecutors did not provide notice of the next day's witness list. We got to hear that when we watched the trial, forcing the defense to request time to retrieve witness files. And then Thompson had to continue her cross of Jason Autry until like 7 at night when the AC was, everyone's like fanning themselves. And the judge is apologizing about, oh, we're sorry you have to stay so late and it's hot and uncomfortable in here.
But this
And
bad lady's making you.
Yep. Then Thompson would hurriedly search through paperwork during direct examination instead of engaging with the witness's testimony to prepare for cross-examination. Gonzalez stated he had no meaningful discussions with Thompson about whether petitioner would testify and recalled her general stance that defendants should not take the stand. Gonzalez created a PowerPoint presentation for Thompson's closing argument, including audio clips of testimony. Thompson did not review it and deviated from it during her closing, prompting Gonzalez to stop the presentation out of frustration. After conviction, Gonzalez initiated discussions with the prosecution. I don't even remember. There was a PowerPoint up there on the screen. Did we not see that on the camera angle?
I don't remember that.
Yes, it says he stops the presentation out of frustration some point during her closing. After conviction, Gonzalez initiated discussions with the prosecution to resolve the penalty phase without the states seeking the death penalty. The discussions progressed quickly, and after consulting the victim's family, the prosecutor agreed to a sentence of life without parole. On cross-examination, Gonzalez acknowledged receiving some discovery materials, particularly related to the medical examiner, though he criticized the overall organization and accessibility of the evidence. The court observed Gonzalez's demeanor and found his testimony credible. We don't mention the football. Terry Dicus. Terry Dicus, a former TBI special agent, served as the lead investigator for about 2 years beginning the morning Holly disappeared. He testified for the defense at trial. At the time of the evidentiary hearing, he was practicing law. Early in the investigation, Dicus coordinated the review and documentation of vehicle traffic and surveillance footage from various locations. He relied heavily on cell phone activity between 9:05 and 9:40 a.m., and focused on identifying vehicles that could be relevant. He reviewed the Parsons ATM video, but did not recall seeing a Silverado after 11 a.m., nor had anyone told him about it. When shown the video in post-conviction, not probable cause, post-conviction Exhibit 8, Dicus could not identify the type of truck. Dicus initially had concerns about the accuracy of Clint Bobo's account, but those concerns were resolved once cell phone data confirmed Clint's timeline and supported his credibility. Dicus rejected suggestions from other agents that Clint was lying and opposed the use of aggressive interrogation tactics on him. By mid-2011, Dicus viewed Terry Britt as the main suspect. He based his suspicion on inconsistencies in statements of Britt and his wife, the wife's unscheduled absence from work on the day of the offense, conflicting cell phone records, and a neighbor's report about Britt behaving oddly. Dicus participated in wiretaps, searches, and surveillance of Britt's property, noting cameras and multiple vehicles, including vans, on the property. Although no solid evidence linked Britt to the crime, Dicus continued to believe Britt was the most likely suspect. He asked Marshal John Walker to interview Britt and believed Britt's statements would have been admissible evidence. Dicus described cell phone tracking as a key investigative tool. Working with Marshal Walker and AT&T engineers, investigators mapped the likely route of Holly's phone as it moved through the country. Dicus identified PC Exhibit 5 as a map of the route and agreed PC Exhibit 15, a demonstrative aid created by post-conviction counsel, recreated the same map. Dicus believed the direction of travel could be determined with reasonable confidence, even if precise locations were less certain. He also noted that none of Holly's belongings were found along the early part of the route, which he considered a sign that she was still alive and well at that time. Discarded items were discovered along the route after a period of no cell movement. Dicus believed Holly was killed during that period. Dicus said he and other investigators repeatedly examined and cleared Zach and the co-defendants. He cited cell phone data placing them elsewhere, alibi statements, and physical descriptions inconsistent with the abductor. He specifically noted Autry's height and work alibi, and information placing the Adams brothers at home. Although he acknowledged some inconsistent statements, he did not consider them significant enough to implicate the group. Dicus described growing disagreements with TBI and other agencies by late 2012 over whether Britt should continue as the focus of the investigation. He presented a PowerPoint outlining evidence against Britt, but supervisors and prosecutors were unwilling to pursue charges. He felt increasing pressure to shift attention away from Britt. His involvement in the case ended in mid-2013 after internal disputes, including his resistance to treating Clint Bobo as a suspect. He was removed from the case and resigned from TBI within a few months. On cross-examination, Dicus admitted he did not share all the information he'd gathered with prosecutors, focusing instead on what he believed could be used in court. He maintained that Britt was the most likely suspect and that Zach and the co-defendants were never credible suspects before he left the case. When Dicus reviewed Autry's subsequent trial testimony, he did not believe much of Autry's story was true. Dicus testified consistently at trial and in the evidentiary hearing. The court credits his testimony. Kathy Ferguson.
I was writing a long message into the chat that I think got erased because it was too long with the address. So I'll resend it. But
Okay.
Did I miss something in my mental? What did the stuff that Gonzalez said about Judge McKinley?
No, they didn't say anything about the football or the pistol on the hip or anything like that. And again, this being a death penalty case all the way through until that resolution, to take death off the table post-conviction is a critical piece of context here. And then you have Jim Simmons. Oh, I basically did nothing but twiddle my thumbs because I thought the ABA wants me to just seek a settlement, seek a resolution, and not go to trial. And every time my client walks in through the door, McGinley stands there with his revolver showing, whatever he carries. I don't know if it's a revolver, on his hip.
We could look up
in and out of the courtroom.
We could look up the arrest records where he was out with it at the airport.
Oh, Judge McKinley.
Wow.
But yeah, nothing of that was mentioned from Jerry's testimony. So Kathy Ferguson, a TBI agent who became more involved in the case over time, has served as the lead case agent since 2018, which was after the trial. She did not testify at trial. Ferguson confirmed that the early investigation attention focused on Terry Britt, but internal disagreements within TBI and among prosecutors. But you know what's critical? He said more than once that he's crediting the trial court. So if he's ignoring this issue and not addressing this issue where someone says, look, the trial court clearly wasn't even paying attention, you're relying necessarily procedurally, that's what he's supposed to do. You're relying on the trial court. Your factual determinations are couched in something that has been refuted and unaddressed. Because you're finding Jerry Gonzalez credible, but you're not addressing certain things that he testified to. So I don't know. I think, again, but that's like, there's so many, you could get lost in the weeds trying to decide what to argue in a brief as being an issue. But I would make it at least a small argument that anytime if I'm going to raise a reasonableness of any factual finding here, maybe on Dylan, I have to go and see where it's obvious that Judge McKinley is not paying attention. But just because there's out loud football playing at two moments, and we only hear it at those two moments, doesn't mean that he's not likely not paying attention in some other moments if he gets caught those two times.
And it's about whether he was paying attention or not. The jury heard that and they saw that. And what message is that sending to the jury that the supposed 13th juror, who should be modeling the type of focused attention and critical reasoning one should be weighing throughout, is watching football? Like, that to me is the message that sends to a jury, I think, is mistrial level. Like, how do you...
And then telling them, I want to see if I can help get you tickets to a game. Oh, my goodness.
Couldn't any more blatantly have communicated to the jury that he was ready for this guy to be convicted and didn't need to hear anything else.
And it's just plainly unaddressed. Jerry Gonzalez's testimony about that issue is plainly unaddressed. So
KDR makes a real interesting point that you can't, like, when you go back and you watch the trial footage, that his face is glued to his eye, like glued to an iPad.
Looking down, like you can tell.
That he's not watching the witnesses.
So you can't make a credibility assessment on demeanor, body language. So.
And signaling to the jury that it doesn't matter for them to pay attention to it either.
Crazy. Kathy Fergs. TBI agent, who became more involved in the case over time, served as the lead case agent since 2018, which was after the trial. She did not testify at trial. Ferguson confirmed that the early investigation attention focused on Terry Britt, but internal disagreements within TBI and among prosecutors resulted in a shift away from him. As the case progressed, Ferguson helped organize evidence and prepare materials for the prosecution. She worked closely with the Bobo family, who were frustrated with the pace and direction of the investigation. Ferguson acknowledged there was a group within TBI that questioned Clint Bobo's reliability. While she shared concerns about inconsistencies in his statements, she did not believe Clint was responsible. Ferguson was aware of private investigator Dennis Benjamin contacting witnesses. After hearing recordings of Benjamin's interactions, she found his tactics troubling, noting he made false claims and applied pressure in an apparent effort to elicit statements. All right, so he's incorporating Ferguson's testimony. I'm putting this in yellow. He's incorporating someone else's testimony here, right? He's just reciting it. This isn't like exactly a factual finding, but it's something that he's saying I'm going to consider later somehow in an analysis. But pair that with earlier, where he states that when it comes to Brent Booth and Dennis Benjamin are like tag teaming to get Victor Dinsmore to make sure he's giving truthful statements only. He says, hey, the recordings show he was using, that Brent Booth was using tactics that apply pressure and elicit statements. So he's incorporating Ferguson's interpretation that Dennis Benjamin was doing that. And he said, hey, recordings show, undisputably, that Booth was doing that. I think that's very interesting. It says she did not know whether his actions were officially sanctioned, but acknowledged that Agent Jack Van Hoosier brought Benjamin into the investigation. Well, that's an interesting discrepancy, isn't it? Wasn't he just a citizen private investigator? Van Hoosier was the assistant special agent in charge at the beginning of the investigation and later became the special agent in charge.
Jack Van Hoosier and Dennis Benjamin are longtime buddies. They're good friends and have been for a long time.
Well, let me take a break here because Sheriff Chuck is heading out on us. And big thank you, Sheriff Chuck, for all the way back from the beginning of this case for helping us discern the relevance of like anything gun related. Very helpful. Anything with cadaver dogs, searches, very helpful all along. And of course, your insights even outside of things that you have like a niche expertise in. Thank you for providing all that. You say you're getting out of here, and I want to make sure I show some love because you gifted a ton of memberships here. We had 15 gifted memberships coming from Chuck. So big thank you. I don't want to save this to the end because you might not be here. We got some other stuff to do. So big thank you for gifting these 15. And look at this. We are almost a year. Almost a year. We're at 11 months. And don't thank me. Thank you. Big thank you. All the love in the world to Sheriff Chuck. Sorry to speed through that, but I wanted to thank you before you got out of here. So big thank you. And I see everybody saying their salutations here. Oh, goodness. There we go. We got the A Sheriff up on the screen. Ferguson identified the statements of Dillon and Autry as major turning points. Although the statements were inconsistent, Dillon's admission of rape prompted additional charges on all co-defendants as well as the potential for the death penalty. Ferguson believed both statements were... Do we leave out the part about... What were the brothers' names?
The Piercies? Jeff and Mark Piercy and their video of somebody else having consensual sex.
Well, and then they were charged, right? Weren't they charged with rape?
They were charged with... I think they were charged with, like, tampering with evidence.
Okay. But that all stemmed from this time period, right?
Yeah.
Because here we're only getting co-defendants. Which has so far only been described in the context of this filing as being the four of Autry, Austin, Adams.
I'm told the way they got the indictment was they told the grand jury that they had a video of the sexual assault.
Yeah, with someone being named Holly.
Different Holly. Maybe that's who the panties were belonging to.
Oh my god. Lord. Another saga where questions need answers. Where was this? Okay, wait. They prompted the additional charges as well as the potential for the death penalty. Ferguson believed both statements were self-serving, and at least one left out critical details. So, all right. So he's incorporating that she found that it was turning points, but she had suspicions. This to me is retrospective, though. I think contemporaneously it does change the tide. It was necessary to evolve the stature of the case, but I don't believe that she was doubting this as she was hearing it. Because if you were truly doubting it in that moment, why were you evolving the case off something that you thought was not true? But if you say it now, you're showing, hey, I wasn't operating in a vacuum and we were checking things out to make sure it worked. Trust us. Trust us when we say that our final theory presented to the jury in 2017 was fully fleshed out, accurate, undisputable, because we were always trying to make sure we were aware when something Dylan or Autry didn't say added up, and we made sure we got it right. That's why I think she put that testimony, made sure she testified to that. They say that according to Ferguson, multiple witnesses described different possible murder weapons, a .357, a .38, and a .32. A .357 caliber Ruger was seized from the home of Dick Adams, Zach's grandfather, and a .32 caliber gun was eventually recovered. She acknowledged these accounts did not align, but did not raise those inconsistencies at the time. Ferguson conducted, see, that's what I'm saying. What I was just pointing out, it seems like Bradbury is aware that that doesn't pass the smell test, but what is he ultimately going to end up concluding? But it's like to point out what he thinks is relevant to incorporate, to me seems like it doesn't pass the smell test for him. Someone saying like, oh, we noted inconsistencies, but we evolved the case anyway.
I think Bradbury is a reluctant wheel in a cog, or a cog in a wheel in a machine that is traveling nowhere fast.
Ferguson conducted testing which suggested a .32 caliber gunshot would sound. When did she conduct that testing? Are we going to skip that part? Which suggested a .32 caliber gunshot would sound more like a sharp crack than the boom described in Autry's final testimony. See Exhibit 99. She did not view the test results as undermining the case. Ferguson explained that early cell phone technology was limited. Location data could only approximate a phone's position within a broad area, so investigators relied on those records cautiously to track general movement rather than exact locations. Ferguson acknowledged conflicts between cell phone data and witnesses' accounts. For example, Holly's phone appeared to move while Zach, Dylan, Autry, and Austin were reportedly elsewhere. Despite this, she expressed firm belief that Zach and the co-defendants were collectively responsible for the crimes. She expressed equal certainty that Britt was not involved. Other investigative points from Ferguson include, 1, that there was a login to petitioner's Facebook account at 8:39 a.m. on the day of the offense, but it was not possible to identify the person who logged in. I don't know. Seems like she knew she couldn't identify.
So it's not possible to confirm who typed Zach's password into his computer and called his girlfriend a bad name and then apologized to his mama for saying the bad word when his friends are responding. And this was not a premeditated.
We thoroughly vetted everything else. We don't look into this detail. That's very important. That could be very important. This one we ignore. They say 2, that a palm print was found on the victim's vehicle but never identified. And 3, that nothing corroborated petitioner's account of seeing Sheriff Weaver at a gas station on the morning of the offense.
Weber, and that's where his cell phone places him.
The court found Ferguson's testimony was credible. Dennis Benjamin. Dennis Benjamin, a retired Memphis police officer with 24 years of experience, testified that he became involved in the investigation in 2013 at the request of Karen Bobo, Holly's mother, not Jack Van Hoosier. So we're crediting the recitation above that it was really Jack Van Hoosier brings him in.
Well, and the Bobos thought it was the Bobos because Dennis Benjamin was pressuring law enforcement contacts he had to introduce him to the Bobos as this retired agent that just really wanted to help them and maybe could catch something. Van Hoosier and Karen hated each other, did not get along at all. And I think that that's Van Hoosier was using Dennis Benjamin to control Karen.
Oh. So he comes in and he says that he came in 2013, which would be prior to the living arrangement. Let's make that clear. So Bradbury finds that when we get to Dylan, just pay attention to that. Because it's going to be living happens after some statements were already made. Couldn't have been contamination by Benjamin or pressure from Benjamin because he didn't move in with Benjamin yet. But he was already involved intimately with this case by 2013. Benjamin had undergone multiple brain surgeries before working on the case and acknowledged significant memory issues. He described his recollection of this case as similar to remembering a dream. Benjamin received numerous large binders compiled by Karen Bobo and concluded that the investigation at that time was disorganized. Although he communicated with TBI agent Jack Van Hoosier, he emphasized the relationship was one-sided. Benjamin forwarded information he discovered to TBI, but TBI did not provide him case details or access to their files. Benjamin's efforts focused on Zach and his associates. He traveled twice to Indiana to interview Victor Dinsmore, recording their conversations and turning them over to TBI. And we have a footnote here for this exhibit from the post-conviction proceedings. The state objected to the admission of Exhibit 103, an audio-recorded interview between Benjamin and Victor and Sandy Dinsmore. To the extent the recording proves the interrogation techniques used by Benjamin, the objections overruled. To the extent the recording offers statements of the Dinsmores to assert fact, the objection is sustained as hearsay with no applicable exception.
I think that's totally fair. I'm understanding he's saying he's admitting it to show the interrogation style Dennis Benjamin is using, but the statements made by Dinsmore and Sandy are not being considered for the fact of the matter.
I think that's helpful because it's stuff that the jury didn't get to hear either.
Well, and
it's not considered here.
And it's not that because Victor Dinsmore's admitting things that Zach did that, are part of that false confession. And so I think he's saying he's not taking the statements Victor Dinsmore's making as truth of the matter. That's how I'm reading it. Maybe I'm reading it wrong though.
No, I don't think you're reading it wrong. But what I'm saying, there's really no fact finder has made a factual determination on these statements.
Oh yeah,
that's what I'm saying.
Yeah, because it wasn't a trial.
Yep. Mm-hmm. And that could also be a failure, a deficiency to introduce these if we had these in our possession, to introduce these or confront select witnesses with prior statements. So, yeah, I think that's interesting because that's a gray area where we don't have a court that's looked at to make a factual analysis and the jury didn't see it. Where did this footnote come? Okay. He admitted using various interrogation techniques to encourage Dinsmore to talk, including exaggerating his knowledge, discussing potential reward money, cultivating a rapport, and blowing smoke to gather information. Benjamin acknowledged threatening Dinsmore with the possibility of the death penalty. There you go. You were talking about that earlier. If he withheld information about Holly's whereabouts. Benjamin also became involved with Dylan after law enforcement expressed concerns about Dylan's safety upon his release. Benjamin allowed Dylan to live with him and his wife. He testified that he was reimbursed for minimal expenses, such as clothing and basic needs, through a state witness fund, but not paid for investigative work. Was any of this ever produced?
No, and I think we need to find that state witness fund, and that's got to be public records, isn't it?
Yeah, and I remember vague testimony, like, it was like Doug was trying to get at, like, he would go to TBI to pick up a check. Did anyone remember seeing him go pick up payment somewhere in TBI? And would you really need to do that if it was dispersed by a witness fund? Couldn't they just mail it to you? I don't know. So I think that's interesting.
Very.
Benjamin claimed to develop a close bond with Dylan, describing him as emotionally fragile and fearful of his brother and others involved in the case. While staying at Benjamin's home, well, I mean, maybe one informs the other. If someone's fragile, maybe you can make him fearful. While staying at Benjamin's home, Dylan made a significant statement. He admitted to raping Holly Bobo but denied killing her. According to Benjamin, no questioning or pressure prompted the disclosure. It was offered voluntarily, out of respect. Benjamin immediately contacted Agent Van Hoosier and brought Dylan to the TBI office the next day. Now, this is that, like, September 2014 timeline. That, like, I don't know, like the discovery and announcement Memorial Day weekend, right?
Mm-hmm.
Or, yeah.
This was September 17th of 2014 was his interrogation, and they're saying it was the next day. If he promptly brought him to the TBI the next day, why was the interrogation at 9 o'clock at night?
I remember Holly's skull was found September 7th.
It was 10 days after.
Oh, and remember, there were additional items found near her skull that were not found at the same time, because they do that, like, well, like, Jeff Jackson found something on his own, and then we have, like, the line walking.
They brought the forensic unit, Laura Hodges' team that she testified about, to, they spent 2 days combing the property or the area around where the skull, and they found all the other things. I found it odd that after the most expensive investigation in the history of the state, they would find partial remains like that and just quit after 2 days and not maybe expand the perimeter a little more if they didn't already know what there was to find there.
Yeah.
Among a lot of other unusual things. The purse, it was part of the 2-day, so the skull was found on the 7th of September, and then that was I think there was a Saturday or Sunday or something involved, because then the search was the 9th and the 10th, like not the 8th, but the 9th and the 10th. And on the first, I think it was the first day, everyone broke for lunch, and Jeff Jackson just happened to find the purse alone while everyone else was at lunch, which means the pink purse that was sitting right across from the skull in a ravine poking out of the soil. People went hours not noticing that until they all went to lunch, and then Jeff Jackson just saw it. It's a weird set of circumstances.
And it remains in place for years while this is waiting to be found, when other things were, like, clearly moving down the waterbed. Benjamin immediately contacted Agent Van Hoosier and brought Dylan to the TBI office the next day. Benjamin denied coaching Dylan or attempting to shape his testimony. He encouraged Dylan to be truthful and follow his attorney's advice. Benjamin acknowledged, however, being emotionally invested in Dylan's well-being and recognized the unusual nature of housing a key witness. The court has significant concerns regarding Benjamin's credibility. Though these concerns stem from his prolonged avoidance of subpoenas, medical excuses, prior brain surgeries, and his own admission that his recollection had deteriorated. So it's like the all-encompassing problems. The court did not determine what parts of his testimony could be untrue, but does not give much weight to the testimony overall.
This is where the problem is. The court should give a lot of weight to his testimony. A lot.
Because it's going to contest Dylan's.
The court should give a lot of weight to his testimony, not for the truth of it, but for the lack of credibility to it and what that means in terms of, he's an agent of the state, and he was communicating directly with Dylan's attorney while the TBI agents are telling Dylan what to say to his attorney. I mean,
well, if you have significant concerns about his credibility, his contemporaneous contamination is problematic. So just because you don't want to weigh on, by the time he actually testifies in front of the PCR, to me, you're finding that any representations or any of his involvement earlier on, as it was happening, could be credibility issues.
Bingo.
And
He was
you can't explain everything. You can't explain everything just by the medical excuses. But if someone's avoiding subpoenas, I mean, if you just have memory issues because of medical reasons, is that a reason to say why you avoid a subpoena? Avoiding a subpoena is something that exists outside of, especially a former cop. Like,
and he's
this
not
is just
saying,
like a layperson that doesn't want to speak under oath.
He's not saying medical limitations or medical conditions. He's saying medical excuses. And the prior brain surgeries were before all of this happened. They aren't. They were like, he already had the brain surgery.
Yeah, because he said that was part of why he wanted to go up to Indiana too, right? Like a follow-up or something with his daughter being, I don't remember.
There's some mention of it.
Yeah. When does Dylan? Okay, so pause here. When's Dylan? Dylan is so far away. Guys, pin this Dennis Benjamin and the significant concerns, but we're not going to make specific findings about what parts are credible or what isn't. And remember, again, pair that with, for Brent Booth, the recordings show that Brent Booth was using certain techniques that could pressure or elicit certain statements. Paul Hagerman. Paul Hagerman, a seasoned Memphis prosecutor, joined the case after the state had already filed notice seeking the death penalty. He approached the case with significant skepticism because he was aware of the theories involving Britt and internal disagreements with the TBI. Hagerman explained that he reviewed Dylan's recorded statements and found them unreliable, incomplete, and at times impossible to reconcile with the objective cell phone data. He said Dylan's timeline conflicted with known facts and cell tower activity and appeared to leave out significant details. These omissions made Hagerman unwilling to rely on Dylan as a primary witness, which explains why they might want to go to somebody else to rely on them as a witness. By contrast, Hagerman described oh, there we go. All right. So how is Bradbury going exactly where my mind is going, but he doesn't go to the outcome that seems like the obvious outcome here? He's like, hey, obviously, Hagerman obviously sees that Dylan isn't there, so let's go over to Autry. And this, by contrast, to me, is a characterization by the court here. The court is noting the contrast. That, oh, we're going to steer directions over to Autry's 2017 proffer as a turning point in the case. He said Autry provided a clear, chronological account which prosecutors compared against cell phone data. Hagerman felt any discrepancies could be reconciled. Key elements of Autry's story were supported by phone records and other circumstantial evidence. And remember, Paul Hagerman is the guy that spoke at Autry's sentencing, where we have that back and forth exchange where McGinley's like the most credible witness, compelling witness. And Hagerman's like, it was really helpful.
And he said that Autry specifically answered a lot of questions for the family and investigators that were up until then left unknown or open in the case. And you can watch Nichols' face contort while he's saying it, like she knows.
Because it's harmful error. If you discredit Autry, it is clear harmful error for a prosecutor to say that we needed him to prove our case beyond a reasonable doubt.
So much so. I mean, you don't even need anyone to say whether they needed him or not. Look at the deal he got. Are you going to give someone who's admitting to participating in a kidnapping, rape, and murder and has an extensive criminal history already, 8 years concurrent with essentially a time served if it wasn't critical?
Key elements, we have the word key. All right, so key elements of Autry's story were supported by phone records and other circumstantial evidence. Though not perfect. Oh, okay, I didn't see that. We'll put a little... Though not perfect, Autry's account was the most detailed and corroborated version that the state possessed. This is huge because I would argue... Yeah, by design, but also if you find an issue with it, or if he's able to properly recant his statement and have it be considered on a record by any court, then how do you fix this? You'd have to show that he's recanting out of self-interest. And maybe you could argue that. Maybe you could argue he wants to undo his stuff, but his sweetheart deal was based on he would be violating his plea agreement by changing his story, wouldn't he?
It did not help him in any way, and it was not helpful to him in any way. So much so that Nichols, I think, kind of slipped because it conveys the logic contradiction. Nichols acted like it was my fault his attorney withdrew because it was so problematic that he recanted that his attorney withdrew from the case. Now, the reason his attorney withdrew is because his attorney previously represented Terry Britt in his federal deal. And when I asked the attorney if that was a conflict or why it wasn't, he said, I need to withdraw, and then withdrew from the case. It's shady.
I mean, this is where I think this is teed up for a very strong argument on the prejudice prong. He added that the state's case against Autry was relatively weak, which made Autry's cooperation particularly valuable. A central theme of the testimony concerned Autry's credibility. Hagerman acknowledged entering the proffer session with healthy skepticism, but said Autry began at the beginning of the story and went straight through the end, almost like he was telling a story from point A to Z. Autry remained consistent each time he recounted the events. Oh, so his consistency is we can trust it because it's consistent. We don't look for accuracy, we just look for consistency for Autry. Hagerman denied ever having been told by any TBI agent that Autry was lying. He said if a trusted agent had raised such concerns, he would have reported it. Regarding concerns about subornation of perjury, Hagerman testified that his co-counsel, Jennifer Nichols, had listened to Agent Booth's interview of Victor Dinsmore and was not impressed with how Booth handled the interview. However, Hagerman denied that Nichols ever said Booth had suborned perjury. Her criticisms related more to interview technique than to accusations of intentional misconduct. Hagerman described ongoing discovery issues throughout the case, including inaccessible files, missing attachments, and a voluminous 4-terabyte hard drive of evidence. He confirmed that defense attorney Thompson persistently raised these problems and frequently identified gaps. The prosecution eventually held joint evidence review sessions with TBI in Nashville to ensure the defense had access to all materials. And this is where Nichols was freaking out about recording. A significant portion of the testimony focused on disputes about Holly's location and the location of her cell phone on the morning of the abduction. Hagerman acknowledged that the cell tower data placed Holly's phone stationary from approximately 8:26 to 8:56, and later moving towards Gooch Creek. First time we've heard that one in this opinion, where items linked to her were recovered. The state believed Holly and her phone were separated sometime after her abduction, but before Zach and Autry traveled to the Tennessee River. He agreed that some portions of Autry's testimony could not be matched precisely to the cell tower times, and that the state relied on the idea of why tower covered circles rather than pinpoint GPS data. Circles
means they were choosing. Seems like they were choosing to look at what tower it was on, and not. So we had, because the pings were GPS coordinates. They were hits. They weren't like general areas like the other stuff was.
They were properly triangulated. But am I mistaken that when he's looking at the phone records where you only look at like the sector and you're available in the sector, that's
a
forget,
wedge.
like yeah,
and there were
wedge,
several
perfect.
times when people were on a tower and they would make a point, well, they're on the same tower. But it's like, yeah, but they're in another sector of that tower. And I think that's what he's saying, is that they're purposely kind of interpreting it as but even if you interpret it that way, still doesn't really work.
Yeah, I don't know. So I think it's interesting that we have circles and quotes here. Rather than pinpoint GPS data. So the state's relying on the idea. Well, I think that's actually important separately. That if Hagerman's saying, like, look, we vetted these inconsistencies. We thought that Autry was great, but we only looked at these circles, which isn't even as precise as it should be for the phone record data, which should be looked at as the wedge parts of where are you likely in this sector, which direction. And then saying that we didn't even look at the pinpoint GPS data, but why not? Because you had that information available, and it would go a long way to corroborating the possibility of the routes. And I think the answer I'm looking for is in the question I just stated. What I'm saying here, and I'm leaving a space here for a reason. How do we... The state is saying here that they had information that could have corroborated or not corroborated, and they didn't even look at it. So clearly it wasn't presented to a jury. Clearly it wasn't part of actually vetting out what's notably somewhat dicey and inconsistent about Autry's timeline, but it makes enough sense if we don't look too closely, it can't be disputed. I think this is huge, actually.
Yeah, I agree with that.
Because it makes the route much more important. The possibilities of the routes and this precise route. So if Mr. Dillon narrowed down, we're going to try to speed on these certain routes because based on the information we have from the GPS, this route wouldn't be possible because we have a specific ping. Then the state has to move into a territory where they're saying, well, the guys split up and they were all doing different things, but how is that possible if Jason says Holly was with them? This is so stupid. Hagerman acknowledged the existence of apparent timing conflicts. Yes, raised during cross-examination, but maintained that the overall movements were consistent with Autry's account. Hagerman also addressed the ATM surveillance video showing a truck resembling one owned by Dylan Adams. He said he likely had seen the video before trial and agreed that the truck in the image looked similar to Dylan's. He had no clear memory of the moment he first reviewed the video. Regarding plea discussions, Hagerman testified that no formal agreement existed with Autry prior to his testimony. However, there were internal prosecution discussions anticipating that Autry would not receive much additional prison time if he testified truthfully, especially given the weak case against him. We got that repeated emphasis. He said the internal discussions were never communicated to Autry or his attorneys, and that only a general statement was given that truthful cooperation would be considered at sentencing. Hagerman described the trial as a close, and this is just hard for me to believe when we have recordings of the dynamic duo going back to get Victor Dinsmore to become more truthful in the sense that it would align with what Jason Autry was saying. To me, this doesn't comport with common sense. Hagerman described the trial as a close and hard-fought case, with both sides presenting competing theories. The state relied heavily on Autry's testimony, corroborated by circumstantial evidence such as inconsistent alibis, statements attributed to the defendant, and observations of suspicious behavior by Zach on the day of the disappearance. The defense, meanwhile, highlighted the lack of physical evidence, the self-tower timing conflicts, investigative missteps, and alternative suspect theories. Hagerman consistently maintained that Autry's testimony filled critical gaps answered questions left open for years, and provided the most coherent explanations of events surrounding Holly Bob's death. Okay. Oh, these typos. And then the court credits Mr. Hagerman's testimony. Valerie Trout, a former, and thank you for uploading her testimony because I think that's the only way it was able to be viewed over on Trial and Error podcast. Valerie Trout was a former TBI agent. She described her involvement in the investigation beginning as a polygraph examiner and later as an investigator who reviewed evidence and conducted interviews. She did not testify at trial. Trout listened to wiretap conversations involving Terry Britt and found his behavior unusual, noting persistent whispering and loud music. She considered such conduct inconsistent with normal conversations inside a home. Trout discussed because you're being listened to. Trout discussed a significant shift in leadership and direction in the investigation. Agent Jack Van Hoosier replaced Special Agent in Charge John Mayer, and according to Trout, a different atmosphere emerged. Trout described a less cohesive and more adversarial investigation, especially toward the Bobo family. She testified that at one point there was a discussion within TBI about dropping the case. Trout testified that the names of Zach Adams and his co-defendants had rung from day one. So that's two people in the PCR proceedings saying that these names, maybe they got lost in the sauce, but Zach Adams and the other three, their names were there. People were sending in a tip from day one. Very vaguely testified to. She interviewed Victor Dinsmore and Rebecca Earp. She stated that Dinsmore did not reveal to her information about Zach hiding a truck at the Dinsmore home or that Dinsmore identified a particular weapon used in the crime. She expressed concerns about Agent Booth's sloppy paperwork, but did not believe he tried to influence witness statements. Well, the recording seems to show that. I love that we have that verbiage about the recording. I just love that that was in there.
I love that.
Worded as it was.
I think if
Trout
there's
recalled-
anyone right now who could give a really amazing perspective on what was going on behind the scenes, it would be Victor Dinsmore. Because he was right there, right behind. I think he was really close to getting charged himself.
Which would just be wild because, like, how would he fit the theory? Like,
Well, none of them did. They just add him to the story that they made up.
hold on, wait, I have a clip for this maybe. Do I still have it? Do I still have it? I don't know if I do.
One lick was exchanged. Zach hit Shane. Dinsmore pulls up. Dinsmore comes outside.
Just that accidental slip of the most credible witness of all time.
Mm-hmm.
Trying to remember what you have to say and not actually visualizing what happened with personal knowledge.
Mm-hmm.
So we've got Trout recalled encountering Dennis Benjamin in a TBI conference room. She learned that Benjamin was working with the Bobo family, but was not informed about his role. She described confusion with the TBI about his presence and activities. The court observed Trout's demeanor and found her credible. So we don't really go into anything she said about speaking with Earp or any of that. That's pretty sparse. Zach Adams. Zachary Adams testified that in April 2011, his life was dominated by heavy drug use, unstable relationships, and spending time with his brother Dylan, Shane Austin, and Jason Autry. He claimed he did not know Holly Bobo and denied any part in her kidnapping, rape, murder, or the disposal of her remains. He described April 13, 2011, as an ordinary day except for a call from Austin about taking Xanax together. Zach and Dylan picked Austin up in Dylan's Silverado, bought gas, and traveled to Parsons. Zach had not remembered the ATM withdrawal where Dylan backed into the drive-through lane until reviewing discovery for the post-conviction hearing. He provided innocent explanations for the scratches on his body, his regularly cleaned vehicles, and cleaning a mattress outside his home. He acknowledged making crude or threatening statements to various individuals, but attributed them to efforts to cultivate a reputation as a dangerous drug dealer rather than admissions of guilt. He rejected as fabricated or exaggerated the testimony of multiple witnesses, both acquaintances and jailhouse informants, who claimed he made incriminating remarks. Well, and disprovable, like the whole Wells statement. On cross-examination, the state confronted Zach with extensive phone record evidence showing numerous calls and texts on the morning of April 13th, including frequent contact with Autry and others. Across multiple interviews over several years, he had not disclosed the communications, the Parsons ATM trip, or that he'd been with Autry that morning. The prosecution challenged his explanations for his movements and highlighted contradictions between his recollection and the testimony of multiple trial witnesses. He continued to deny those witness accounts and insisted they lied or misunderstood him. Zach testified that he often went to the river to fish or use drugs, but he did not remember doing so on the day of the offense. He acknowledged that phone records placed him at the river that morning. He did not remember the many phone calls he made that day and suggested they were likely related to drug activity. He did not remember going to Victor Dinsmore's house, but recalled being there on other occasions, including a time when he had a fight with Austin. He maintained that nothing about that day stood out to him, and his lack of memory should not be interpreted as evidence of guilt. Addressing various statements attributed to him by witnesses, Zach denied confessing to the crime. He denied making specific incriminating remarks or explained that if he did, they were exaggerated, sarcastic, or intended to intimidate others in his role as a drug dealer. He claimed he had built a reputation for being dangerous so people would fear him and pay their debts. He acknowledged making threats or crude statements in general, but insisted they did not mean he was involved in the crime. He denied making confessions to jailhouse informants and suggested any conversations they claimed occurred were either misinterpreted or fabricated. He emphasized that he did not know those individuals well enough to confide in them about something so serious. Zach discussed his interactions with law enforcement, stating he spoke to officers whenever they asked, and he contacted authorities on one occasion after learning they were looking for him. He admitted he did not always provide complete information, especially about his drug use or associations, because he did not want to implicate himself or others in drug activity. Now, this part was corroborated. I think at trial, you had two different witnesses say that he spoke willingly, like the guy that took the photographs. The only guy he didn't really want to deal with was the guy that wouldn't get off, Rainey, when he was just like hanging around.
Probably shouldn't have, yeah. I mean, what the hell with that? And he even let Karen and Clint in his home to speak with him. That just...
Zach stated he wanted to testify at trial, but was advised by Jennifer Thompson not to do so. He said his mother and cousin strongly influenced his decision, and he felt he had to follow their wishes. When confronted with the transcript of the Maman hearing, PC Exhibit 116, petitioner said he did not fully understand that the final decision was his to make and believed he had to follow his attorney's advice. However, he also said his decision not to testify was solidified when he promised his mother and cousin he would not. According to Zach, had he testified, the jury would have heard explanations for many of the statements and circumstances used against him. Zach criticized his trial representation, describing Thompson as disorganized and claiming he lacked full access to discovery materials. He said he was unaware of certain evidence, including the ATM video, at the time of trial. He contrasted the experience with his current attorneys, stating there was a day and night difference in their level of organization and communication. Zach acknowledged a long history of criminal conduct, including drug offenses, theft, and assault, but emphasized he never committed a sex crime. He addressed an incident in which his mother was shot, explaining it was accidental and the result of reckless handling of a firearm while under the influence of drugs. Additionally, he rejected Autry's trial testimony and denied asking anyone to harm his brother. He attributed the case against him largely to false statements by others, particularly his brother, and to misunderstandings or exaggerations of his own behavior and words. The court carefully observed petitioner's demeanor throughout his testimony. He was adamant in his statements, even during cross-examination. The court recognizes the testimony as self-serving to the petitioner and not credible. So that is the factual determination that we have for Zach's testimony. Factual determination. Jennifer Nichols. Jennifer Nichols, a seasoned prosecutor and now sitting circuit judge, testified about her role in the prosecution and her perspective on the case. She described her philosophy as presenting all available evidence to the jury, even if some questions could not be fully answered. Yeah, just show them the panties that don't belong to anyone charged in this case. Nichols joined the case in November 2014 after the district attorney's conference requested assistance. She could not recall certain procedural details, including whether a death penalty notice had been filed when she became involved. She did not recall reviewing voluminous evidence, including Dylan's statements, which she found unreliable. She believed Dylan minimized his role and offered an account inconsistent with other information. Because the statements would not have been admissible against the other defendants, she viewed them as having limited prosecutorial value. Yeah, because then you'd have to show the jury that video. According to Nichols, the case file was enormous, hundreds of thousands of pages and thousands of investigative reports. She worked to provide full access to the defense, organizing evidence reviews, and providing materials upon request. She noted that defense attorney Jennifer Thompson was particularly thorough, frequently asking for materials that were subsequently provided. Nichols insisted, well, there was some stuff that she was asking for that was provided to Jason Autry, but not
to her.
Yeah, how about that part? We can talk about that. Nichols insisted we didn't actually have that, and we went through Joe Walker already, and we didn't have that discussed.
And thank you, KDR. Exactly. No one else gave self-serving testimony. Why is it only the defendant in the case who's supposedly self-serving? Everyone that was on that stand had a motivation somewhere. And I mean,
Lauren, whole mess. She noted that defense attorney Jennifer Thompson was thorough, frequently asking for materials that were subsequently provided, and Nichols insisted she was unaware of any exculpatory evidence being withheld. Regarding the ATM footage that appeared to show petitioner and Parsons, well, if you can conclude that something was being withheld and you're just going to determine that it wasn't exculpatory, does that mean that you didn't necessarily provide stuff and you just made the determination that something wasn't exculpatory? Regarding the ATM footage that appeared to show petitioner and Parsons, Nichols said she did not consider it significant because the state already had other evidence placing him there. I mean, we have argument. I know argument isn't always evidence, but this is interesting because Nichols is saying we didn't consider it because the state's already placing him there, but they argue that that evidence doesn't show that he was actually there. She similarly downplayed any importance of any cell phone location discrepancies, pointing to uncertainties about exact times and movements. Nichols frequently expressed limited memory of specific interviews, recordings, and evolving witness statements.
And evolving witness statements.
Yeah, I have interesting language. Another interesting language. When confronted with inconsistencies, particularly regarding Victor Dinsmore's multiple accounts. Again, this is tying in. I would tie this in with the recordings show that Brent Booth was using tactics that could pressure or elicit certain statements. Not really the most kosher tactics. Pair that with this, particularly Victor Dinsmore's multiple accounts. Nichols characterized them as additions or refreshed memories rather than contradictions. She acknowledged that Agent Booth may have led Dinsmore during interviews, but described it as an effort to jog his memory, not an attempt to manufacture testimony. Well, she rejected suggestions of her own misconduct, insisting she would never knowingly allow false testimony. I would never lie to a jury. Mr. Bates. Nichols placed significant weight on the multiple witnesses who said petitioner had confessed to them, although their accounts differed in detail. She viewed them collectively as powerful evidence. She also believed that Autry's testimony strengthened the case by filling in gaps, even where timelines were imperfect. So I gotta pause here because what do you think about this? We have a fact-finding, a credibility assessment by this court that Zach's post-conviction relief testimony is not credible. But we're also relying heavily on his statements to others that testified at the 2017 trial, that the statements themselves were internally consistent, and then details of those statements, when taken at face value, are controverted by other evidence, physical evidence, how Holly was found, where she was located that day. So if we don't credit his post-conviction relief testimony, how do we not have an issue with what he supposedly said to others during this time period?
That's such a great point. It's like his own words in court under oath are not to be determined credible, yet
but hearsay of his words.
And it's because it's self-serving, but here we're supposed to trust hearsay of his words to other people while he's not under oath, when he's clearly defined the self-serving nature of it. He was dealing drugs and wanted people to be scared of him.
Well, and also the self-serving interests of most of the others, the vast majority of the others who presented these statements, the jailhouse informants specifically, and or relatives of Victor Dinsmore, who was being threatened with the death penalty himself, and his first degree connections are the ones coming in. Well, I heard something interesting too, knowing that there was this pressure, or likely knowing, having access to knowing that Dinsmore was being told he could be facing the death penalty. I think this is a big deal.
I agree with you, and I don't think I would have caught the full weight of it that I see now.
Because it's like 20 pages removed from, like, if you have to like keep circling back, like, remember this thing was also, he recited specifically that this recording showed something. It's a lot. It's a lot. Man. It says she also believed that Autry's testimony strengthened the case by filling in gaps. So it's important, even where timelines were imperfect. For her, variations in witness accounts were expected in a complex case and were matters for the jury to resolve. She dismissed the idea that Terry Britt confessed, describing his comments to Marshall Walker as sarcasm rather than an admission. I mean, I can agree in a bubble, but I still take issue. Why would you...
Why does one suspect make a confession and it's sarcastic and another one does, and it's to be presented to a jury as the truth?
I can picture, oh, you got me on that one. You're so smart, aren't you? Being a sarcastic way to say it, but not followed up by, here's what I want. I want you to leave my wife alone, and this is what I want. I'm worried about my age. I don't want to be in certain facilities with other racial demographics because I just don't enjoy that. I want these specific terms and criteria.
And under 20
You
years.
don't,
And then
you don't do that as a sarcastic call out. You don't do that when you're calling someone's bluff.
And then you end up with exactly what you sarcastically asked for.
Which adds credibility to Marshall Walker saying that that's how the conversation happened and had to be relayed to TBI. But it's dismissed by Jennifer Nichols.
And no evidence. So this suspect that's gotten so much attention from everyone at TBI and has been this focus, you have a U.S. Marshal put in a report that is documented that says he wants to confess. He confessed and he wants to talk to an agent and make a deal. And they're suggesting that just no one followed up on that. Like that alone. I mean, what explanation could you possibly, even if you thought he was wrong, even if you thought Walker was the most ridiculous dumbass out there who had no idea. I mean, you've got a senior investigator with U.S. Marshals who's working the case who says this guy confessed and needs a TBI agent to come talk to him and no one shows up. No.
What other case would that ever happen in?
It just doesn't pass a smell test.
And if nothing else, even if you think it's going to be BS, you rush to get in there before a defense attorney gets wind of it.
Exactly.
So a defense attorney for an alternative, someone that would put forth an alternative suspect theory is what I mean. You want to get in there and then you want to be the filter through which, well, we're not going to take any notes on these questions. We're going to ask certain things. We're going to get in there. We're going to have the leverage, the home-based advantage, if you will. So even if they didn't want to rush in there because they thought they were finally going to get what they needed to prosecute someone they wanted to prosecute, there's the option if you want to get in there to get the information just to thoroughly do your job and or to make sure the case file is complete and that there's no holes left unturned. If you think Terry Britt's about to lie to you for whatever reason, wouldn't you want that information to find out, hey, look, this is what he's saying. This is how it's not true. And this is why someone else won't be able to use it at trial to exonerate their client.
Even if you just thought the U.S. Marshal was crazy, wouldn't you want a follow-up so that doesn't leave hanging open in the investigation as something that was never followed up and addressed? There's like no possible reason I can imagine where that could be explained and our response is going to be, okay, that's reasonable and not highly suspicious.
Or if you think you messed up on another case where you failed to call a witness who was in your custody, a complaining witness who was in your custody to testify against Britt, so you have to drop that case. Wouldn't you want to pursue something where this guy's going to volunteer incriminating information because you don't want to have an excuse for him to get out and do something else again? Like, leave no stone unturned.
And I don't really think Britt would be the kind of case where do you really need to like wheel and deal so much to get a plea? Like, you really thinking a jury's just gonna be so sympathetic to him? It's weird how much they're so nervous about getting Britt a deal and not letting him go to trial when I can't imagine anyone in the world less likely to get a fair trial at this point than Britt. And I like whether they can bring in officially his record or not. People know who he is.
Yeah, and the prosecution's going to try every excuse in the book if they wanted to prosecute somebody with bad character evidence to get it in through some other means that would get through the lines of the rules of evidence. But again, it's just a selective application.
Brad Boomer, I like that's funny.
We got Nichols. Interesting language here too. Nichols stood by the state's theory that a .32 caliber revolver was the murder weapon. She acknowledged conflicting witness descriptions, but said she relied on the medical examiner's conclusion that the wound was consistent with the .32 caliber bullet. She maintained that her closing argument accurately represented the evidence. Yeah, well, who's going to admit that? How is that not self-serving?
Right.
Nichols expressed confidence in the jury's verdict and maintained her personal belief in petitioner's guilt. She praised Jennifer Thompson's dedication and deep knowledge of the case. Oh no, she praised Jennifer Thompson for being effective counsel because she knows that that's going to be an issue raised on appeal. Like the critical relevance of Jason Autry and how you have Paul Hagerman stating out loud on the record at a sentencing hearing, he filled in gaps that we wouldn't have been able to fill in otherwise. So she praises Jennifer Thompson out of the goodness of her heart, calling her more familiar than any other attorney involved. I mean, I think that is agreeable, because everyone else was brought in late. Although she disagreed with Thompson's conclusions, she believed Thompson's strategy regarding Britt as an alternative suspect was sound and consistently executed. And of course, the reason that Nichols, former prosecutor and now a judge, wants to give the opinion and reinforce and embrace the opinion that Thompson had a strategy is when you have a strategic reason, a reasonable strategy, you use that to argue against an ineffective assistance of counsel claim. Well, I would have made a different strategic decision. Doesn't matter. That's not the standard when you do a Strickland analysis for ineffective assistance of counsel. It needs to be either no strategy whatsoever or an objectively unreasonable strategy call. Like, we're going to just parade elephants through the courtroom because it'll be fun and the jury will vote for our client. That's a dumb strategy. It doesn't make sense. So that's why, of course, if you want this conviction to stick and you anticipate ineffective assistance of counsel being an issue, you want to say, it was a great strategy, best strategy ever. I love the other Jennifer. She's amazing. It was amazing. I would do the exact same thing. It's reasonable. So, after the conviction, Nichols met with the Bobo family to discuss sentencing. She supported removing the death penalty from consideration because the family wanted finality rather than a prolonged and emotionally draining appeals process. The court credits Judge Nichols' testimony.
There it is.
And that's it.
It is.
It's short too. No body language, no.
With all due respect is what I read there.
Yep.
It's conspicuously omitted all, like he makes a point everywhere else of saying that he watched body language and demeanor, consistency, supported with the documentary evidence, and then Nichols, that looks like, feels like an order under duress. Just how it feels to me personally. That is
like
no
you can't, like, you've got to spit it out and you don't have it in you to say any more than these 1, 2, 3, 4, 5, 6 words. It reads
to me like you are doing what is being forced upon you and not an inch more. Just, that's personally how it feels reading that.
The other Jennifer, Miss Thompson, a criminal defense attorney licensed since 1996, was retained by petitioner's family in early 2014. Although experienced in some serious criminal cases, she had never tried a death penalty case. Thompson testified that she assumed petitioner was likely guilty because prosecutors repeatedly stated that DNA evidence was forthcoming. She brought in... I like that this is included, just because maybe anybody reviewing this decision, it could kind of hone them in to know that this is there. So prosecutors were making the representation early on that the DNA evidence was forthcoming. And this is also critical to her request for certain continuances before the trial was kicked forward at one point in time, but then she asked for a continuance because of testing on the gun, right? On the revolver that was now identified, that was previously not identified because we had to change which one it was. And that continuance was denied. So she brought in the second request. She brought in veteran capital attorney Jim Simmons based on his experience resolving such cases. They agreed that Thompson would handle the trial and Simmons would handle sentencing and mitigation. Discovery consisted of a voluminous 4-terabyte hard drive with thousands of unlabeled and non-searchable documents, audio files, and videos. According to Thompson, the only inculpatory evidence was statements petitioner made about the victim and or the crime. Is this the Zach Stupid Words folder?
Yes.
She dismissed those as wild and crazy. That's in quotes. Even though Thompson hired a computer expert to assist in the process, she struggled with the discovery up to the day of trial. Early discussions of a joint defense with co-defendants, counsel quickly deteriorated. She described feeling undermined or marginalized. Disputes arose over how to jointly review discovery, particularly during sessions at the TBI office. Thompson insisted on reviewing all the materials while others preferred selective review. Eventually, Thompson was no longer convinced that Zach was guilty. She immersed herself in the case, eventually dedicating most of her practice to it. She spent significant time reviewing evidence, investigating alternative suspects such as Britt, and studying technical areas like cell phone records. She found no physical evidence connecting Zach to the crime and believed that Dylan's statement was unreliable, inconsistent, and heavily influenced by investigators. Also, I want to say that even if a defense attorney here didn't have this like, well, I assumed he was guilty, which is a pretense I kind of hate someone to go in like, oh, the state's saying they're guilty, so I'm just going to go in and represent them like they're guilty. I hate that. But moving that context aside, I think that these arguments for relief, no matter the defendant or no matter the counsel deciding one way or another on innocence or guilt, I still think that these arguments need to be raised either way. So she spends a significant time. She studies technical areas like the cell phone records, but can't properly qualify an expert. She found no physical evidence connecting Zach to the crime and believed that Dylan's statement was unreliable, inconsistent, and heavily influenced by investigators. As a trial date neared, she had Dylan's statement transcribed. She expected to undermine the prosecution by exposing contradictions. However, Dylan did not testify, and she introduced none of this at trial nor sought admissibility under any rule of evidence. This is deficiency, guys. This is going to first prong of Strickland. First prong of the Strickland analysis. She planned to do something, and when she would have pivoted, she didn't seek to do something else to still get this critical thing admitted. And you can't explain that by, like, you should have at least tried some other ways where this seems to be going. Thompson met with petitioner roughly 10 times. She felt his lengthy history of methamphetamine use affected his ability to provide useful information, but he consistently denied involvement. Thompson did not thoroughly review the voluminous discovery with Zach and generally advised him against testifying for risk of exposing extensive impeachment material. As trial neared, Thompson remained overwhelmed and requested a continuance, which the trial court denied. She began experiencing depression and anxiety during the case, resulting in treatment and medication. She did not disclose this to the court or her client. She disclosed the trial environment as hostile and admitted substantial shortcomings in her trial performance. She failed to effectively cross-examine key witnesses, did not highlight contradictions in testimony, and did not challenge shifts in the state's theory. And also, by the way, to reemphasize, from my reading of case law in Tennessee, the trial court can make this finding of deficiency de novo, which means they're not just going to look at, did he make the correct decision? They can kind of evaluate the underlying, like the bubbling context of that and give it a fresh eyes interpretation. So as we're going through this, if you're sitting here like, how could anybody not find this to be deficient? That's where I have some optimism that the Court of Appeals, and I think Bradbury is going to get through the deficiency prong on some of these aspects, but whether it was impactful. So if you're sitting there and you're reading this and you're asking, would this deficiency be so impactful that it's could it change the jury, the outcome, the verdict? Was it harmful? Was there actual prejudice by this deficient performance?
Like both, is it deficient? Like, is this less than, worse than the average person would do, significantly so? And did that deficiency result in some negative outcome that otherwise wouldn't have? Like, it also has to matter. Is that?
It can't just be like, well, that one thing sucked, but there was so much other stuff going on and she did everything else great, and like it wouldn't have changed the jury's outcome. We still have confidence in the verdict. But if it's like her whole trial she's drinking wine, we have that little tidbit earlier recited from was it Walker? I think it was Walker that said that.
Yeah, it was Walker.
Marshall Walker.
Mm-hmm.
And then we have like, she's depressed, but she's not informing the court of it, not informing her client of it. And then she's scattered at trial. She fails to get a critical witness admitted as an expert, and the jury doesn't get to hear his analysis. They never get to hear their analysis as part of their conclusion. Does that add up to prejudice, actual harm. So they've got she failed to effectively cross-examine key witnesses, did not highlight contradictions in testimony, and did not challenge shifts in the state's theory. She missed opportunities to introduce exculpatory evidence, including digital alibi records. Now,
He just called that exculpatory.
yes, and if it's exculpatory, is there any strategic reason to leave it out? There might be arguments like, hey, if you testify, you could be impeached on something, but if there's other records, digital alibi records, timeline inconsistencies, there isn't this idea, well, maybe you strategically chose, you didn't want your client to testify because other information could come in and it could outweigh itself. It could net neutral or be worse. But all these other, what strategy, what reasonable strategy exists to miss an opportunity? You have the opportunity. When you say you missed an opportunity, the presumption's there that there would have been a way for you to get this in front of a jury had you just done the thing. What reasonable strategy would lead any attorney performing competently to not introduce exculpatory evidence of digital alibi records, timeline inconsistencies, and witness coercion? So she did not object to certain prosecutorial arguments, so failure to object, or evidentiary issues, including mischaracterizations related to the caliber of the murder weapon and the size of the .380 projectile. Now, this is following on the heels of our one sentence, other Jennifer's credible.
Mm-hmm. Is not even that he doesn't say she's credible. He said she is credited, right?
Credited.
Like,
I mean, to me, I read that the same. I read that the same way. It's credited for the purpose. I'm taking what she said. I'm reading into it as I'm taking what she said as testimony, and I'm going to rely on it kind of at face value, what at least I've repeated here in my analysis later on in this.
Mm-hmm.
But right on the heels, we have this .380 projectile issue right after, ending with the other Jennifer. She maintained in her closing that she relied on evidence and didn't mischaracterize anything in her closing arguments to the jury, specifically about this. So, and then we're highlighting she didn't object to certain prosecutorial arguments or evidentiary issues, including mischaracterizations. So we just had Jennifer Nichols says she doesn't mischaracterize the caliber information. And then we have this, I didn't object to certain mischaracterizations relating to that caliber. So which one is it? Which one is it? Which one is it? Thompson attributed these failures to a combination of factors: lack of preparation time, overwhelming discovery, late evidence disclosures, and her deteriorating mental health. The court observed Thompson's demeanor, which was reserved and mostly deferential to post-conviction counsel's questioning. Ms. Thompson did not appear to mislead the court, who finds her testimony credible. That's an interesting thing to put in here. Don't you think that's interesting?
Yes.
Why would you specify this when your other Jennifer analysis was like devoid of any particulars? This is much in contrast, Ms. Thompson did not appear to mislead the court, just like the previous person I wrote about. But then again, I don't know if Bradbury wrote this in order. He could have written some of these witnesses and organized them in order, but that might not have been the way that he prepared this document. But still, that's very odd to me.
I definitely think there's a contradiction between Nichols' credibility statement and this. And how do you, I mean, he's saying all these things, and it's like he's giving the underlying facts that are needed to win and the credibility discretion that would be needed to win. And he's presenting a legal argument that would maybe be appealable based on the facts that are included.
Man. Oh, Forrest. Dang, we're already up to Forrest and Frizzell. All right, so we are getting into the state's case in chief. So Forrest Richardson, an investigator with the Tennessee Comptroller of the Treasury, testified about his review of Jennifer Thompson's billing records, reflecting her representation of Zach Adams. The prosecutor in this post-conviction case requested that he review Thompson's time records and prepare a summary for the court. Richardson explained that he investigates allegations of fraud, waste, and abuse of state and local funds. In this case, His role was limited to summarizing how Thompson documented her time spent on the Zach Adams case. He had no opinion on the quality or sufficiency of the work. According to the data submitted by Thompson, she logged 2,870 hours on the case with extensive time reviewing evidence and trial prep. The court credits Mr. Richardson's testimony based on his demeanor and the documentation of his analysis. Michael Frizzell. Michael Frizzell, the assistant director with the TBI, and this is actually one of my favorite witnesses to watch. Doug did cross because this was called by the state. I thought it was a great turning of a witness that the other party calls. Assistant director with TBI, 27 years of experience, testified at trial as the state's expert in cell phone call detail record analysis. He began with TBI as a field agent and was later assigned to the Technical Services Unit, where he handled cell phone tracking, surveillance systems, and digital forensics. He was also a member of the FBI's Cellular Analysis Survey Team, a specialized group trained in cell phone-based location analysis. At the evidentiary hearing, Frizzell testified that he prepared a cellular analysis report in August of 2017 covering the morning of the offense. The report, PC Exhibit 151, examined the cell phone activity of the victim, petitioner, and co-defendant Autry. His analysis relied on AT&T call detail records, which show when a phone connects to the strongest available cell tower and identifies the sector of the tower used. He emphasized that these connections provide only a general area, not a precise location. According to his analysis, all 3 relevant phones showed activity throughout the morning, including communications between Zach and Autry beginning around 8:19 a.m. And I think this is kind of important because this was used at trial. And so you had said earlier, like, you know, Dylan, we're not looking at any phone activity. I guess maybe the absence of Dylan's phone activity could be something you say you look at. We considered the absence of his activity. But again, as far as like seeing any information where somebody's device, a device belonging to somebody was moving, specifically what the jury saw was for these, limited to these 3 devices.
There's the next episode that we put out on the podcast, we're going to go into a lot of cell phone data that was omitted for reasons that don't make any sense.
I can't wait.
I'm looking forward to sharing it.
Yeah, I can't wait. He emphasized that these connect. I'm sure there's like a different sense of sharing it after this decision decided to come down on Friday night. So Frizzell emphasized that these connections provide only a general area, not a precise location, and that all 3 relevant phones showed activity throughout the morning. So Holly, Zach's, and Jason's, including communications between Zach and Autry beginning around 8:19 a.m. Holly's phone showed a sequence of tower connections indicating movement across a wide geographic area. Frizzell testified that the data could reflect movement in the directions of north, east, then south, but he stressed that such conclusions were limited by the size and variability of tower sectors. The court credits Mr. Frizzell's testimony based on his demeanor and the consistency of his testimony with his previous trial statements. Mitchell Hayes, boat guy.
Oh, I want to know what he says about boat guy.
Mitchell Hayes, a welder, testified about his activities on the day, I don't think you're going to love this one, on the day of the offense. His usual routine was to take his children to school, and then if he was not working, spend time fishing or hunting. On the morning of Holly's abduction, Hayes dropped his children at school between 7:30 and 7:45 a.m., and then drove roughly 20 miles to the tie yard boat ramp near the interstate. He launched his boat and traveled north for 30 to 35 minutes to a preferred fishing area. He did not observe anyone else in the area and fished between 30 and 90 minutes before hearing a loud, echoing gunshot to the north of his location. Hayes found the gunshot odd because it appeared the shot came from a federal game reserve where discharging firearms was prohibited. Despite this, he did not stop fishing and did not connect the gunshot to any crime.
And this is on the day that everyone's looking for Holly.
Yep. On his drive home from fishing, that's when he hears the Amber Alert on the radio for Holly Bobo. At the time, he did not believe the alert was related to the gunshot he'd heard. Hayes did not realize until the trial that the gunshot might be connected. He became convinced of its relevance after watching trial testimony, which would be 2017, suggesting no one had been in the area that morning. After realizing the potential significance, he approached Agent Booth and reported what he'd heard. Now, cross-examination. Hayes acknowledged.
I just can't. There's something so key there. If he didn't recognize the relevance or importance of the gunshot, he never would have remembered it. You don't remember things like that are so like not attributed to like anyone who lives out in the country like I do. Like, tell me about a time 4 years ago when you heard a gunshot. Tell me what day it was and what time of day and whether it echoed. No, it's ridiculous. I'll carry on.
Well, and then the only way to credit that would be like out of habit. Like, I know that my kids' school started at 8 and I would drop them off 15 minutes before. So that's like critical part of like, make sure, you know, we got to get what your routine was like, because your routine can establish some type of timeline where we couldn't reliably expect you to remember otherwise if you didn't have this routine to just randomly know what you were doing when you didn't think about it earlier. But if you're hearing the gunshot, there's no way that he would just remember like, hey, I heard a gunshot that morning. If you didn't think it was significant after hearing the Amber Alert, if you didn't think it was significant with the very prevalent news of a girl going missing when you have kids yourself, and your wife is part of a Search for Holly Facebook group, which I'm not sure if we're going to even have discussed here. Oh yeah, we do. I see it on the page. You don't think of this? You don't think of this?
Exactly. It's just not something you'd remember 4 years later if you didn't recognize any relevance at the time. That would be like asking him what he had for lunch that day that he heard it. He's not going to know.
And during cross-examination, Hayes acknowledged that he had not reported the gunshot earlier, even though he discussed his presence at the tie yard with others. He also confirmed it was turkey season, meaning gunfire in surrounding areas was possible, though he could not say whether the shot came from private land or federally protected property. Hayes acknowledged his wife was a follower of a Justice for Holly Facebook group. He also admitted to social connections with individuals linked to the case, including Agent Brent Booth and mutual acquaintances of the victim's family. What do you think, Katie? You want to read this paragraph? Go ahead, Katie.
The court observed Mr. Hayes' testimony as he recounted events from 15 years ago. Although Hayes appeared to testify truthfully, the state failed to corroborate Hayes' testimony through Agent Booth. The testimony is not given much weight, whether credible or not. I actually find that answer beautiful.
Why didn't they just call Brent Booth back? I know he's retired, but that doesn't matter. When you're retired, you get roped back up to come testify in trials. It's just part of being retired law enforcement. But why didn't you call him back until after? But when is the timing of the boat guy being discovered to the state?
I think this, to me, speaks volumes. That this is saying boat guy's full of shit, is how I'm reading it. I don't like...
But it's not saying, it's not giving that concession. It's can kicking.
It's can kicking. That's exactly it. I think
it's can kicking, but it's not a stalwart. It's not like a buttress to help the state have a good argument on appeal. It's not destroying their opportunity to continue arguing. Well, it's just his memory that made him not remember that this would be significant until later. But it's, to me, this specific thing, you could have corroborated with Brent Booth. But the problem, and it was what Doug questioned and realized, I'm going to ask this question on cross-examination. I'm just going to wing it. I'm going to get up there and I'm going to ask, do you know Brent Booth? That wasn't part of his plan, right? He just was like, let me just wing it. Let me take the gamble.
He just recognized the scent. Yeah.
And I think the significance of that gamble is not lost on, the outcome of that gamble is not lost on Bradbury, although he didn't want to explicitly opine on why.
Mm-hmm.
Oh, man. All right, guys, so this is where we're going to get into, so now we've gone through who's credited or who's not, right? And so for the most part, the denials across the board of, I find someone not to be credible, are really Dennis Benjamin, Zach Adams, and Dylan Adams. There are some other, like, there's memory issues, or I didn't give this much consideration, or we got, like, omissions. We don't say why we're crediting somebody, or we're saying we're only crediting them because the previous court did, right? So there's, like, gray areas there. But those are, right, I think that's the right count. Those are the only three I remember that were, like explicitly stated, I'm not crediting. Because I read into that as this, but it's like I'm not giving it weight either. So
I agree.
Then we've got post-conviction standards, right? So what do we look at here? So Tennessee's Post-Conviction Procedure Act permits relief only when a conviction or sentence is void or voidable because of a constitutional violation. These are the parameters. Tennessee Code Annotated 40-30-103, a petition must include a clear and specific statements of all grounds upon which relief is sought, including full disclosure of the factual basis of those grounds. And then 40-30-106, Section D, petitioner bears the burden of proving these factual allegations by clear and convincing evidence. That's more than just more likely than not. It's not quite reasonable doubt. It's below that, but it's more than just a more likely than not, 51%. Clear and convincing is higher than that. And this is according to both Tennessee Code Annotated 40-30-110F and Superior Court Rules, I think it's Superior Court Rules, 28 Section 8D1. A jury verdict as approved by the trial court resolves all evidentiary conflicts in the state's favor. That's coming from State v. Jones. The jury is the primary arbiter of witness credibility. A petitioner may not relitigate a previously determined issue by presenting additional factual allegations. He also may not raise an issue which could have been raised on direct appeal. And remember, we already had the direct appeal. The decision for that came down in 2022. It was 81 pages. It was nope, conviction is affirmed. A claim is waived when it would have been raised earlier and was not. That's important, right? Because we're going back to the beginning of the stream. We talked about look for the buckets. We're getting into the bucket sorting. A claim is waived when it could have been raised earlier and was not, unless petitioner shows that either 1, a newly recognized constitutional right requiring retroactive application. So why should we look at this now? Or 2, that the failure to present the ground was the result of state action. The state got in the way of this. It's not the defendant, it's not the claimant's, not the petitioner's fault. A claim is previously determined if a court has ruled on the merits after a full and fair hearing. There is also a rebuttable presumption that any claim not raised previously is waived. Failure to explain why an issue was not raised earlier requires dismissal. These principles govern the structure of this order. Claims already available at trial or on direct appeal are addressed as procedurally barred. And claims unsupported, which means if it's procedurally barred, the court here is not even going to analyze the merits of the issue, right? And claims unsupported by testimony or proof at the evidentiary hearing are deemed abandoned. So we're not going to get into the merits because there isn't really stuff for us to weigh in on. Ineffective assistance of counsel. So what's the analysis? What are our guidelines here as judge here at the Hardin Circuit Court? Tennessee Supreme Court applies a Strickland v. Washington holding. This is something, it's a like SCOTUS federal case. You'll see it come up in, like, anytime you see an ineffective assistance of counsel issue, you'll see Strickland. And then Davidson v. State, which is a Tennessee case, it's state specific. To obtain relief, a petitioner must establish both. These are the 2 prongs. You've got deficient performance, meaning counsel's representation fell below an objective standard of reasonableness. And also has to be 2 prongs. Prejudice, meaning a reasonable probability that but for the counsel's errors, the result of the trial would have been different. So reasonable probability based on a deficient performance, the result of the trial would have been different. Tennessee courts presume that counsel's conduct falls within the wide range of reasonable professional assistance. Strategic decisions, especially those made after reasonable investigation, are virtually unchallengeable. That's a high bar. If there's any sensible strategy behind it, you can't just be like, well, I would have done something different. Reviewing courts must resist hindsight and evaluate counsel's decisions on the circumstances at the time. The failure to ask particular cross-examination questions does not by itself establish deficient performance. When alleging that counsel failed to investigate or present witnesses or evidence, petitioner must present those witnesses or evidence at the post-conviction hearing. So there's a few areas where this is going to become relevant, but again, who was someone that the defense wanted to produce for the post-conviction proceedings, particularly if a prior recorded statement that was obtained after the conviction would not be admissible in a vacuum, and we needed someone to testify in person for the admissibility. Who would be a critical person here? Speculation about what an uncalled witness might have said is insufficient. Many of petitioner's claims later addressed in this order failed for this reason. All right. So prosecutorial misconduct. Brady claims. Sorry, there's subsections here for issues that could relate and how we're going to analyze issues raised by the petitioner that relate to prosecutorial misconduct. So under the umbrella of Brady claims, again, that's SCOTUS. You hear that in cases all the time. The state must disclose material evidence favorable to the accused, including impeachment evidence. This includes any promises of leniency or favorable treatment to witnesses. Now we've got some Tennessee case law, State v. Spurlock. Evidence is material only when there is reasonable probability that the result would have been different had it been disclosed. And we've got Nunley v. State. We've got State v. Edgin. Evidence is favorable if it could assist in impeachment, challenge the investigation, or support a defense theory, and it need not be independently admissible. That's from State v. Jackson. We've also got Jordan v. State. And then Napue and Giglio claims. Under Napue v. Illinois. Again, these are two federal cases. These are SCOTUS holdings. The state violates due process if it knowingly presents false testimony or fails to correct it. A petitioner must show that the testimony was false, that the state knew it was false, and that the falsehood may have affected the verdict. I think that there is some argument here to be made on the proper test here on this bullet point. Because I believe, in my opinion, if we look at Glossip, if there's also like a reasonable probability to suspect that it might be false, and then you got to look into it before you just let it be presented all willy-nilly, uncontested. I think Glossip established new holdings, and Glossip was decided in 2025 when these post-conviction proceedings were already underway and the petition had already been filed. So I'm interested. It would kind of be like new ground. Glossip is new holdings. And it kind of reinforces that the holdings in Napue aren't like the strictest gray-lined, high standard, high burden to overcome. So interesting. We'll see if that is something that comes up in any further appeal filings. So then we've got, if such a showing's made, the burden shifts to the state to prove harmlessness beyond a reasonable doubt. So look, if something false was presented, now the state has to say, look, this would not have changed beyond a reasonable doubt. This falsehood would not have changed the jury's mind. And that's coming from Bagley and State v. Morse as a state case. Petitioner's later claims involving Autry, Dinsmore, and the ATM video are evaluated under these standards. All right. And then actual innocence claims, which I think is always a really high bar. Tons of statewide case law. It can vary across states. In Tennessee, this is important. This is probably the most, in my opinion, Tennessee-specific case law of relevance to see what Bradbury does here. Tennessee recognizes a freestanding claim of actual innocence only when based on newly discovered scientific evidence. This is the Dellinger case from Tennessee, 2009. Evidence such as recantations, videos, or impeachment material is not scientific and therefore cannot support a post-conviction innocence claim. And what that would mean is, when we go back to those 4 buckets we talked about at the beginning of the stream, is it cognizable? If it's not cognizable, we're not even going to get into the merits of it, right? And because something like Autry speaking in a recorded video somewhere, recantation, it's not cognizable as a Dellinger claim. That this is an actual innocence claim. Look, Jason Autry said that he put his story together, wanted to make sure his story, I had the discovery in front of me, wanted to make sure it fit what was there. And I could paint this nice, neat story. It's not actually going to play here under Tennessee case law. Specifically, it's got to be newly discovered scientific evidence, even when considered alternatively on the merits. So, right? What he's saying here is this would make it non-cognizable. We wouldn't get into a merits analysis. But even so, even when considered alternatively on the merits, a petitioner must present clear and convincing evidence, leaving the court with no serious or substantial doubt that he did not commit the crime. So high bar. That's what Dellinger requires. That's what Clardy requires. Cumulative, speculative, or previously available evidence cannot meet the standard. Under this controlling authority, as later explained, petitioner's claims based on Jason Autry's 2023 statement. This is the recanting video uploaded by the Trial and Error podcast, where he's speaking with Katie and I should know, I've been avoiding saying the other name. I want to say Hannah, but I don't think it's Hannah. I don't think Hannah's the name. But it was two of you guys doing great work there. But under this controlling authority, Bradbury is going to explain later that petitioner's actual innocence claims based on this 2023 statement and on the ATM video are both non-cognizable and insufficient. All right, so I'm going to highlight this in blue because I think this is an area that many, many pages could be devoted to for an appellate argument on, looking at this with fresh eyes. And not particularly under the frame of an actual innocence claim, but through a layering of, so not actual innocence, but on a layering of Brady claim issues and Napue, Giglio. And there's other case holdings where we talked about it earlier. If a prosecutor, if someone from the state is making a representation about something, the other party should be entitled to rely on those statements. So if there's representations from the state that, hey, look, we don't have this footage from other establishments, other businesses in the area, they're not there, then even if there is video, ATM video, from a business, it makes more sense why, even though it was available to the defense, had they stumbled upon it, maybe looked a little bit harder, it's also watered down because they're entitled to be able to rely on the representation from the state. So if they're told that something shouldn't be in there, just because it does happen to be in there, it weakens the argument that, hey, that was available to you, and because you didn't go ahead and rely on it, and we have this very strict new scientific standard for raising an actual innocence claim for something that hasn't been brought in, this issue that isn't cognizable under a plain reading of what's required to bring an actual innocence claim in under Dellinger, I think is complicated by these layered issues as it relates to Brady in relation to the ATM video, and in the context of Giglio when it comes to challenging the recanting of Jason Autry when maybe it wasn't properly explored and or properly disclosed and or honestly disclosed under Napue, if there were any promises of leniency or strong, elbow nudging to Jason Autry for that moment in time where suddenly the posture of the case switched dramatically because we can't rely on Dylan's statements, but suddenly we've got Jason Autry, and his is corroborating itself with this timeline evidence, right? So even though he's carving out that this can't come in like under a Dellinger analysis, he's going to spell out, I think his Dellinger analysis is going to be strong and kind of hard to dispute. There's other issues relating to both Autry's statement and the ATM video under these other frameworks. So then we've got petitioner's claims. All right, so petitioner raised claims of ineffective assistance of counsel, prosecutorial misconduct, and actual innocence. Several claims are presented under alternative theories, and those claims are addressed together. For clarity, the court has reorganized the claims. The numbering used in this order does not correspond to the numbering in petitioner's filings. Each claim listed includes a parenthetical reference to the pleading from which it came. The court has reviewed all of the petitioner's allegations and finds that none warrant relief. All right? He's saying, I went through all of them and find none warrant relief. Why? So first he's going to go through a waiver, claims that are waived because they were known at the time of trial but were not raised earlier. All right, so that's not a merits analysis bucket. That's procedural. Section 6 addresses claims deemed abandoned due to petitioner's failure to support them with evidence. right? So you didn't call certain witnesses at the post-conviction proceeding, and there wasn't anything admitted that was admissible for me to consider that supports these claims. So even though you might have raised them, you didn't support them, and we're going to find them abandoned. Section 7 covers claims alleging petitioner's actual innocence, or in the alternative, ineffective assistance of counsel or prosecutorial misconduct. Section 8 evaluates petitioner's ineffective assistance of counsel claims on their merits, right? That's that fourth bucket where we look at the merits, right? So his analysis, right? There's layers of this analysis, and his analysis can be reviewed, and that's what the Tennessee Court of Criminal Appeals is instructed, guided, required, and constrained, quite frankly, to reviewing, unless there's a super unreasonableness about a fact-finding issue, is your analysis of putting these claims, these issues, in a specific bucket. Was your analysis of how you sorted it proper analysis? And then if we get to a merits analysis, was any prongs that need to be followed for you to evaluate that type of issue, for example, ineffective assistance of counsel, did you follow the proper Strickland guidelines for analyzing that issue, right? That's how the appeals court is going to look at each of these things. So waived claims, that's our first bucket. We've got pursuant to the law set out in section 3A above, the court finds the following claims have been waived and therefore dismissed. Okay, so this is not going to get to the merits on Shane Austin's letter, his pro se petition. Petitioner provided no explanation for failing to raise this issue on direct appeal, even though available at that time. The claim is waived. Even if it were not waived, petitioner failed to address the issue at the evidentiary hearing. He neither questioned the prosecutors or his trial counsel, nor introduced the letter or any other evidence on this issue. So we're going to say it's also in the abandoned bucket. By failing to present or argue this claim at the hearing, petitioner effectively abandoned it. And this is very insulating because on the Court of Appeals can go, look, we think we might not find that it was waived, but we do find that it was abandoned, and then there you go. Your analysis is good. So they don't need to agree with all of the bucket placement, but if at least one bucket was correct, it's a strong way to let this decision from Bradbury live on. On the merits, the trial transcript confirms the letter was never admitted into evidence. Although petitioner did not cite the record, the court reviewed Rita Austin's trial testimony. During cross-examination, prosecutor Nichols attempted to introduce the letter, and Miss Austin identified her son's handwriting. However, trial counsel Thompson objected, and the court twice ruled the letter was hearsay. The letter was not admitted as evidence or shown to the jury. No confrontation error occurred. The claim is denied. So there was probably a confrontation issue raised in relation to Sean Austin's letter coming in lieu of him being presented as a witness to testify. Not only is he no longer alive, but he also would have been a co-defendant that, unless he agreed to cooperate, couldn't be made to be forced to testify, which would deprive Zach Adams of the opportunity to confront him. Alleged false testimony from Victor Dinsmore. Proposed supplement. Petitioner provided no explanation for failing to raise this issue on direct appeal, even though available at that time. The claim is waived. Even if it were not waived, the claim centers on the allegation that Agent Brent Booth coached Victor Dinsmore's testimony and that the state was aware Dinsmore's testimony was false. At the post-conviction hearing, trial counsel Thompson testified she received recordings of Booth's interviews with Dinsmore before trial and described these interviews as significant. According to Thompson, Brent Booth was absolutely telling Victor Dinsmore how to testify. She cross-examined Dinsmore on his prior statements, but did not object to or request a mistrial when Dinsmore testified. The court finds that petitioner had access to all relevant information at trial. Under Tennessee law, a claim not raised at trial or on direct appeal is waived and generally cannot be revived in post-conviction proceedings. Alternatively, the court finds the allegations to be without merit. At trial, Dinsmore, he's addressing all the buckets. At trial, Dinsmore testified that petitioner and co-defendant Austin had argued over who was going to hit it first. That petitioner hid his white Nissan truck in Dinsmore's shop after the victim disappeared, and that Dinsmore received a .32 revolver Austin traded him for drugs. Dinsmore also detailed the morphine purchase from him by petitioner, Austin and Autry. Dinsmore stated that he disposed of the .32 revolver because he feared it had been used in the murder. The pistol was later recovered from a creek near Yellow Springs Road. Dinsmore obtained both federal and state immunity for his firearm and drug involvement. He implicated a third party in the burial of Holly Bobo's body and acknowledged memory lapse tied to trauma. He also admitted initial inconsistencies in describing the truck's location and type of revolver. Thompson cross-examined Dinsmore thoroughly, highlighting the inconsistent statements about where the truck was hidden, the interview with Booth, and the varying caliber of the gun he received from Austin. At the evidentiary hearing, petitioner argued that Booth coached Dinsmore by putting words in his mouth about the truck being hidden at Dinsmore's property. The recorded interviews show Booth suggesting that Autry would testify to this fact and encouraging Dinsmore to nail this down. Dinsmore and his wife both denied that the white truck was kept in their garage and only conceded it could have happened, according to petitioner, after pressure from Booth. However, Booth returned the next day so that he wasn't the one putting words in your mouth. That's a quote. At the evidentiary hearing, Booth testified he disclosed Autry's expected testimony to Dinsmore as an investigative technique, asserting that his goal was to elicit the truth. He stated, I didn't know it was untrue. I still don't. And said he was trying to get the truth. Prosecutor Jennifer Nichols testified she was aware of the interviews before trial and attributed Dinsmore's shifting statements to drug use and refreshing a memory. She stated, I would never suborn perjury. That's in quotes. Prosecutor Hagerman confirmed he had no indication that Nichols believed Booth suborned perjury. Dinsmore did not testify at the evidentiary hearing, so the jury's verdict stands as an endorsement of his trial testimony. And so this is being placed on the petitioner, right? You didn't call Dinsmore. So, let's see. This court finds that petitioner has not shown by clear and convincing evidence that Dinsmore's trial testimony was false or knowingly employed by the state as false. Booth's interview methods, though suggestive, were aimed at uncovering truth, and both prosecutors testified they did not believe Dinsmore lied. However, his trial testimony was corroborated by co-defendant Autry, and the jury credited it despite cross-examination. The claim is denied. Abandoned claims. Pursuant to the law set out in Section 3A above, the court finds the following claims were abandoned because petitioner presented no proof, failed to introduce the referenced evidence, or did not question trial counsel about the claim. These claims are therefore dismissed. In some claims, the court offers alternative rulings if the claims are deemed to not be abandoned. For those claims that no alternative ruling is provided, the court finds that petitioner provided no evidence of deficiency or prejudice. So if you do get to the merits bucket, I'm not finding that we meet the Strickland prongs. The court cannot assess the significance of unpresented evidence, and petitioner has not overcome the presumption of reasonable professional assistance. The claims are denied. So first up, ineffective assistance counsel in relation to the issue of pretrial publicity and venue. This is coming from the pro se petition, which Doug Bates incorporated. Petitioner failed to plead a complete factual basis for this claim and presented no evidence at the evidentiary hearing. The claim was abandoned. Even if not abandoned, the record shows trial counsel raised this exact objection in the amended motion for new trial. Petitioner has not overcome the presumption of reasonable professional assistance. The claim is denied. Ineffective assistance prior to trial. And here we've got a list, all right? So for those claims enumerated in Section 6B1 through 4, petitioner failed to plead a complete factual basis for the claims, failed to question trial counsel about the claims, and or failed to present proof through witnesses or exhibits supporting the claims. The claims are abandoned. Even if those claims enumerated in 6B1 through 4 were not abandoned, petitioner has not overcome the presumption of reasonable professional assistance. So this includes failure to utilize forensics expert, failure to utilize expert on memory, false statements, and false confessions, failure to request fingerprint analysis of a cartridge, failure to seek recusal of the court and court officer Anthony Alexander. And I believe this was someone that was like friends, maybe, I think if I have it right, it was like a friend of someone, like they knew the Bobo family, but they were also in daily contact with the jury. So that was raised in the petition, but not something that was developed or like really argued at all, I don't think, at the post-conviction. Unless, was Jerry Gonzalez asked about that? I don't remember. I don't remember. Next, we have failure to test a palm print. Petitioner failed to plead a complete factual basis for this claim. Although post-conviction witnesses Mark Lewis, Joe Walker, and Kathy Ferguson, her name spelled with a K here, acknowledged the existence of a palm print on the victim's car. No evidence connected it to any individual. Petitioner did not question trial counsel on this issue or introduce forensic evidence. The claim was abandoned. Even if not, oh, I'm sorry, I didn't realize Katie was back. I'm just going. Hey, Katie.
Hello.
Hey. Even if not abandoned, trial counsel elicited testimony from Agent Booth that petitioner and co-defendants were excluded from the palm print. Petitioner presented no proof establishing that additional testing would have yielded exculpatory results. He has not overcome the presumption of reasonable professional assistance. That claim is denied. Oh,
Sorry.
Don't die. Failure to utilize a handwriting expert or lay testimony regarding Dylan Adams' statement. Petitioner failed to plead a complete factual basis for this claim and produced no expert testimony. The claim was abandoned. Even if not abandoned, Dylan testified the handwritten statement ascribed to him was not in his handwriting, but petitioner did not demonstrate the statement was admitted at trial or explain how proving it fraudulent would have aided in his defense. It's to show the coercion that Dylan was experiencing when you're acting like nothing happened before the move-in timeline. I didn't read this part yesterday. Right, was that not the purpose of introducing?
Yeah.
Like, people are signing off on your behalf, and then we're contesting, like, you're making statements that contradict yourself.
I mean, he's testifying that he knows he didn't write it because he can't spell that well, and he couldn't read what it really said.
Yeah, so if we have issues like, hey, well, you said this before you moved in, but we can't even verify the statement's actually organically from you. So I think this is misguided. This isn't addressing the issue, the specific issue raised. Right? And this isn't just like, this isn't an analysis that I'm just disagreeing with. This is, you're not giving the analysis to the issue as it was raised. And I don't think it should be abandoned just because a handwriting expert wasn't brought in. Like, if you have somebody saying that that's not their handwriting, that they can't spell, I mean, shouldn't you credit that unless it's contested? I mean, testimony is evidence, so it's.
I guess he's saying he didn't find Dylan credible.
Yeah, that's true. Yeah, but he's not. That's not. Let's see. With no proof supporting deficiency or prejudice. But he doesn't incorporate that.
Yeah.
That's kind of interesting. He's saying that the issue is specifically, how would it have changed the outcome? How would it have been harmful? Because it's not like the trial. I don't know.
He's saying that Doug didn't explain how showing that Dylan was coerced in his confession was fraudulent, that it was never explained how that might affect the outcome of the trial.
When it goes to the credibility of the entire investigation posture of the case and how it moved forward when Dylan wasn't reliably giving them what they needed, and why Autry became so important. I mean, it is I get like it's layered. It's like you have to get through multiple steps to see what the inclusion of this testimony for the post-conviction proceedings is actually getting at. But I think this analysis pointing as if the issue just means, hey, the jury didn't hear from Dylan anyway, so what does it matter? It's not addressing the issue. So I don't know. But again, it's like you could go on for pages to try to have to explain that to a court that's higher up. I mean, next we have failure to properly file a TUI letter, and that's from the pro se petition. There's a footnote that says, in this case, the TUI letter was a request to the U.S. Marshals Service to allow John Walker to testify at trial. A TUI request is required when an employee of the U.S. government is asked to testify and the government is not a party to the litigation. I remember isn't that when we had the guy sitting in the gallery during trial? Yeah. Petitioner failed to plead a complete factual basis for this claim. At the evidentiary hearing, Marshall Walker testified he obtained proper authorization to testify at trial, and that limitations on his testimony were due to counsel attempting to qualify him as a cell phone expert rather than a 2G tracking expert. No proof was presented that the TUI letter was deficient or prejudicial. The claim was abandoned. Did Doug ask Thompson about this?
I
don't remember.
I don't remember.
But to me, I think that would be the place to ask it, not necessarily Walker, but if it wasn't raised anywhere. Even if not abandoned, Marshall Walker testified at trial. With no proof supporting deficiency or prejudice, petitioner failed to rebut the presumption of effective counsel. The claim is denied. Thompson's request to add defense attorney Luke Evans. Petitioner failed to plead a complete factual basis for this claim and provided no proof demonstrating how counsel's attempt to add attorney Luke Evans harmed the defense. The claim was abandoned. Even if not abandoned, the trial court denied Thompson's request due to a conflict of interest, and the court's ruling was upheld both on interlocutory and direct appeals, so the claim is denied. Ineffective assistance on voir dire. Petitioner provided no specific factual allegations, transcript citations, or questions to trial counsel concerning voir dire. Claim was abandoned. Ineffective assistance for certain states' evidence. All right, so for those claims enumerated in D1 through 6, that list from above, petitioner failed to plead a complete factual basis for the claims, failed to question trial counsel about the claims, and or failed to present proof through witnesses or exhibits supporting the claims. The claims are abandoned. Even if not abandoned, petitioner has not rebutted the strong presumption of reasonable professional assistance. What was that list again? So we got like a blanket. Does he not repeat section 6D 1 through 6? I think we'd have to go reference the petition to see what he's talking about here.
They're not those 6.
No, that's from section B.
Oh. Does it go down?
He's saying that this doesn't even get to the bucket of things that were questioned about during the post-conviction proceeding. So he's putting this in a lot of buckets. Oh, never mind. I should have kept going. Failure to introduce inconsistent statements from Clint Bobo. Failure to cross-examine Ernest Stone. Failure to call District Attorney Matt Stowe. Failure to argue the vehicle was too small to transport the body. Failure to argue either Autry or Clint Bobo lied. Failure to call Autry's attorneys. Failure to question Autry about his claim of innocence. Petitioner did not request trial counsel at the evidentiary hearing. Did not question trial counsel at the evidentiary hearing on this issue. The claim was abandoned. Okay, wait. 7 is not part of this list. That was difficult for me to read. Because this is up to number 6. You see what I'm saying?
Yes.
So this issue being singular is because 1 through 6 is part of this.
Yes.
And then 7 is a new, totally distinct.
Yes.
That is all up there. That was confusing because the indentation is the same. It followed the list margin rather than being.
Yep. Okay, that makes sense. I was not following.
All right. Yeah. So failure to question, because I was like, failure to question Autry about his claim of innocence. But petitioner did not question trial counsel at the post-conviction evidentiary hearing on this issue. The claim was abandoned. Even if not abandoned, trial counsel did cross. Is that abandoned when we had significant testimony? Not just from Thompson, but from Simmons. This was actually a subject matter area that Simmons was questioned on about, look, things changed with Autry, and he was in a good position to want to take a plea because, the case against him was a bit weaker. And notice of death is filed, all these different things. We know notice of death was filed because Jim Simmons wouldn't be in the picture either way. So I actually feel like this was addressed about the shift on the claim of innocence. So I guess they're getting at trial counsel's failure to ask. So you want to ask Thompson because Thompson did the cross-examination? I don't know. I think I'm going to have issues with this. He says, even if not abandoned, this is a short paragraph to address this one. Trial counsel did cross-examine Autry about prior statements of innocence. As stated in the direct appeal opinion, Autry proclaimed his innocence frequently and that he wrote letters stating he did not kidnap, rape, and kill the victim. Without testimony from trial counsel or Autry, the court finds petitioner has not rebutted the strong presumption of reasonable professional assistance. So they're going to say it was strategy to not question on this. I disagree that it was abandoned at the post-conviction proceedings. Even though we didn't have a specific question of Jennifer Thompson by Doug Bates of like, was there a reason you didn't ask him why he would walk around saying innocent man walking? Yeah, we don't have a specific there, but is that really enough to consider something abandoned?
Especially when it was so central and the product of multiple motions to attempt to get information in and just, I don't understand that.
Yeah, maybe Doug thought he couldn't get into some of that because we couldn't get into the recanting.
You're barred from it, basically, right?
Well, that would be critical, right? Like the significance of you maintaining your innocent before trial is one thing, but if you recant after testifying against somebody else, that's the key difference. But if we can't get into that line of questioning with trial counsel, I mean...
And he was going to appear by Zoom, but then it was found on a ventilator. Like, so Zach is punished and accused of abandoning something when the witness shows up on a ventilator when he's going to testify by Zoom. That makes no sense.
Yeah, I just have this, like, I think the significance of it would be if he's recanting after trial, it would bolster the importance of someone claiming they're innocent before they go to trial. And we know Autry didn't actually go to trial. He took a plea deal. So it's more significant that the jury didn't get to... I don't know. I wish this was just a longer opinion because this is just so vague to me. And, like, I don't know if saying, like, well, you cross-examine generally about prior statements. I don't know if that really addresses the issue on how that line of questioning went down and the failure to question about specific claims. Like, I just feel like this is too vague to address the trial record, what happened at trial that Doug is now saying was deficient. And I also don't think it was just abandoned and not... I think we have issues on both sides of this. I don't know.
I agree.
Like, I feel like this section should be way longer. Like,
I'm going to turn my mic off because I am going to eat something. So
okay.
But I'm still here and we'll be commenting and we'll return.
Sweet. We've got failure to question Autry's timeline based on Terry Dykes' affidavit. At the evidentiary hearing, petitioner did not introduce Agent Dykes' affidavit into evidence or question trial counsel on the subject. The claim was abandoned, and maybe it shouldn't have been. Even if not abandoned, trial counsel cross-examined Autry about the timeline of events, and the court will not second-guess alternative methods of doing so. So saying that claim was abandoned by post-conviction counsel. We've got failure to question Autry regarding his testimony about why Zach Adams and Shane Austin were at the Bobo house. That he previously found a body at the same location but never reported it to law enforcement. Why he had not pled to charges involving this case. Why he insisted on proclaiming innocence. So more questions, failure to trial counsel's failure to question Autry. So petitioner did not plead facts, cite transcript locations, or present evidence showing Autry's testimony on these issues was false, or that the state knew it was false. The claim was abandoned. Even if not abandoned, the court finds petitioner has not overcome the strong presumption of reasonable professional assistance. To the extent petitioner alleged a Napue violation, he failed to provide record citations to the alleged false testimony and failed to present evidence that Autry's testimony was false or that the prosecution knew it was false. The claim is denied. We had some testimony about inconsistencies. See, these are just subject areas. I don't know, like the idea of like teaching Clint to make meth, maybe it's more of an issue on not choosing to cross-examine Clint Bobo. Maybe there's a strategy argument there. I feel like there could be more on the merits here. But this idea that it was just abandoned because there weren't transcript locations, I do feel like this was brought up. And it's been so many months, but I do feel like this was questioned at the post-conviction proceedings. Like, you didn't think it was weird that they told you they were going there to teach somebody how to make meth, or that this could be the explanation for these Rubbermaid containers? I feel like some of this questioning came up in Valerie Trout's time on the stand. I don't know. Maybe he was just like running out of time. It was like, I'm going to get this decision filed. Group these together. Okay, so Katie's chatting. Katie says he had Kathy Ferguson saying in her testimony that she didn't believe Autry's testimony was true. Yeah, like I just don't feel like this was abandoned. I don't feel like this was abandoned. And also there was a clear attempt. The number one way to get information at the post-conviction proceedings about this false testimony would be to be able to have a recanting and or testimony of Jason Autry allowed. And that was denied. Different issue, different basis. But yeah. Next issue, failure to cross-examine Agent Brent Booth regarding Bobo family lies. Petitioner did not adequately plead facts or present evidence. The claim was abandoned. Even if not abandoned, trial counsel questioned Agent Booth about statements in his affidavit regarding the Bobo family's misleading statements. And they cite the trial transcript, just one page. Petitioner has not overcome the presumption of reasonableness of reasonable professional assistance. Next up, ineffective assistance, failure to present evidence. For those claims enumerated in 6E1 and 2. So that's going to be the failure to call prosecutor Nickel. They're doing the separation thing again. 3 is going to be a separate issue. So failure to call prosecutor Nichols and failure to call the landowner where the remains were located. All right, so failure to present evidence at trial, ineffective assistance. So for those 2 claims, petitioner failed to plead a complete factual basis for the claims, failed to question trial counsel about the claims, and or failed to present proof through witnesses or exhibits supporting the claims. The claims are abandoned. Even if not abandoned, petitioner has not rebutted the strong presumption of reasonable professional assistance. The claims are denied. Next up, we have the failure to effectively introduce evidence through agents Dicus and Viveros. Petitioner did not plead a full factual basis for this claim by setting forth the evidence he alleged trial counsel failed to introduce. Furthermore, at the evidentiary hearing, petitioner did not question trial counsel about her examination of agents Dicus and Viveros. The claims are abandoned. Even if not abandoned at trial, Dicus testified the cell phone record data placed the victim and petitioner at different locations, and petitioner could not have been involved, that's in quotes, in the victim's kidnapping. Viveros testified about the wiretap on Terry Britt's house and a conversation Britt had with his sister indicating police might be listening. Post-conviction counsel did not highlight any significant differences between their trial testimony and their testimony at the evidentiary hearing. What? All right, I want to rewatch Viveros' testimony. Was that asked? Was Viveros asked at trial about that line where the sister warned said something, and then there was the warning about the police listening. Did that come in at trial? Or was that only elicited during the post-conviction proceedings?
I don't remember.
Yeah, I don't know. That's interesting.
Like, basically, is what he's saying is Art and Dicus put up testimony that contradicts the state, but they basically put the same testimony in the trial, and it wasn't significantly different from the PCR. And so if the jury didn't care then nothing's changed. Like, is that what am I understanding that correctly, or am I missing the mark on that?
I don't know, because he's citing... This is the site for where he's saying Vivero's testimony came in.
Yes, he did
the
testify.
appeal.
I think Viveros did testify about that at the trial.
Yeah.
Yeah, he did.
All right, I don't remember that. I like see that that's where it's originating from. And then they're saying that the problem here is that post-conviction counsel did not highlight any significant differences between their trial testimony and their testimony at the evidentiary hearing. After comparing the testimony, the court did not find a reasonable probability that any discrepancies, which did not involve cumulative evidence, were significant enough to undermine the trial's outcome. Petitioner did not overcome the strong presumption of reasonable professional assistance regarding introduction of evidence through agents Dicus and Viveros, so those claims are denied. Next, we have the failure to introduce the video recorded interview of Rebecca Earp. Petitioner argued trial counsel should have introduced the video of Agent Valerie Trout threatening to take away the unborn child of petitioner's girlfriend, Rebecca Earp, if she did not cooperate. At the evidentiary hearing, trial counsel was not asked why she did not present the video recording. The claim was abandoned. The video was introduced at the evidentiary hearing as Exhibit 113, but petitioner's jury heard this twice through Earp's testimony. As stated in the direct appeal opinion, after the defendant's arrest, Ms. Earp became pregnant with her first child. She was interviewed by TBI agent Valerie Trout, who threatened to take her child away and place the child in the custody of the Department of Children's Services if Ms. Earp did not tell the TBI everything. The court finds petitioner has not overcome the strong presumption of reasonable professional assistance. Trial counsel presented evidence that Earp was threatened, and the video would have been merely cumulative. The video cannot conclude that the failure to present cumulative evidence, even if deficient performance, may have affected the trial outcome. Ineffective assistance on opening statement and closing argument. Petitioner did not plead specific deficiencies or cite transcripts as required. Although post-conviction counsel's closing arguments include the assertion that trial counsel should have played the audio recording of Booth's interview with Dinsmore during her opening statement, he did not question trial counsel about her argument strategy. The claim was abandoned. And then ineffective assistance. Pursuant to the appellate opinion, petitioner did not plead specific facts or allegations and did not question trial counsel. Courts are not required to search the appellate record to find potential claims. The claim was abandoned. And then going on to actual innocence claim, the third bucket. Well, it's going to fall into cognizable bucket. Petitioner asserted a freestanding actual innocence claim based on the December 2023 video recorded statement from co-defendant Jason Autry and 2 ATM video footage captured at 11:12 a.m. on the day of the offense. He further alleged the same evidence establishes ineffective assistance of counsel and prosecutorial misconduct. The court first addresses whether a freestanding actual innocence claim is cognizable, and then, alternatively, considers the merits of all related claims on the two pieces of evidence. So he's not saying it's waived. He's not saying it was abandoned. He's like, yeah, you guys, you raised it, you fought for it. But first, we're going to say it's not cognizable. So Tennessee law on freestanding post-conviction claims of actual innocence is stated in Section 3D. Decisions subsequent to Dellinger have consistently reaffirmed this doctrine. So it's not something that the Tennessee Court of Criminal Appeals likes to overturn. Again, we talked earlier, Dellinger is super high. It's got to be new scientific evidence, specifically scientific evidence. There's holdings saying what is not considered scientific evidence, including recantations, and all of that. There's a lot of developed state case law. Look at this. This whole paragraph is like citations to state holdings. This rule forecloses petitioner's reliance on Autry's recantation and the ATM footage, which are clearly non-scientific. Petitioner raised similar arguments in a petition for writ of error coram nobis, which this court dismissed as untimely. Dellinger is dispositive. The actual innocence claims are dismissed. And then alternative merits-based rulings. Even assuming the claims were cognizable, petitioner must prove actual innocence by clear and convincing evidence, leaving no serious or substantial doubt that he did not commit the crime. And that's really coming from Clardy v. State. Speculative or cumulative evidence cannot meet the standard. So first, we're going to go into actual innocence within the context of Autry's 2023 statement. The court excluded Autry's 2023 statement as inadmissible hearsay, and Autry invoked his constitutional right not to testify. As a result, the court had no opportunity to observe his demeanor or assess his credibility under oath. Even assuming the statement is admissible, it does not prove petitioner is innocent. Autry's expectation of leniency, now cited as the basis for his alleged fabrication, was known to the jury and explored at trial. I think this has so much room to argue about effective exploration.
It was not made known to the jury. It was specifically not made known. I don't think leniency for murder and kidnapping and rape participation is going to be time served.
Well, and I was going to say also a lot of the exploration was objected to and sustained.
Mm-hmm.
So how much testimony? I think the most we have is Autry just saying like, well, right here. Yeah. Autry said he was hoping for leniency. So, but an expectation and a hope, I would argue, are semantically quite different.
Like exactly, adventure and there was no deal, so how could they have explored it if the deal wasn't until afterwards?
Well, I think this is specifically addressing an expectation of leniency. So they're saying his expectation, and again, I think the issue I would raise here would be hoping versus expectation. So this is not him. This paragraph right here, he could go into it, is not the judge saying like, look, the deal, any deal was known to the jury. It's just saying Autry's personal expectation of leniency. And he's citing a trial transcript where he says that he was hoping.
I don't think that we're not saying, nobody's saying that his expectation for leniency, the jury is well aware he had an expectation or a hope for leniency. That's very different than here's the specific deal you're getting that is way outside the norm for what kind of deal someone would get for this sort of crime.
Yeah, the degree of leniency.
Is it an excessive degree of leniency that he received was not known to the jury.
So, but my, and this is where I'm like, is the analysis by Bradbury actually addressing the substance of the issue as raised? Is the issue with Autry's 2023 statement just showing that, hey, the trial jury didn't know he expected leniency? Well, yeah, they did. They heard that he was hoping for it. Or is the issue, look, this explains exactly why this degree of leniency was on the table and why somebody would be so inclined to want to get their story straight and make sure it matches these little data points that would corroborate, even though they're contested when you really put the full picture together. I think we have an issue where his analysis, he's limiting it to a very vague expectation of leniency. So what he's saying at face value can kind of be like, all right, but that's not really the crux of the problem.
100%. 100%.
And I hate that because I consider Bradbury to be someone, and we've done these other exercises throughout this reading. Oh, look at the words he's choosing to use here. Look at the words he's choosing not to use here. And so when I see this, I don't think it's just a manner of speaking. People don't speak precisely all the time. Here, I think it's you're intentionally speaking very precisely, and this is the intent of what you want to rule in on. So
It's just bad faith everywhere.
yeah, and Aaron also says that the jury knew that there was no deal. That significantly undermines the cross-examination because juries see prosecutors as trustworthy and defense can't put forth specific terms.
100% yes.
So, in the 2023 statement, Autry did not implicate any other perpetrator or provide an alibi for petitioner. His description of meeting petitioner at the river was consistent with his trial testimony and the prosecution's theory that petitioner and Autry were with the victim when petitioner shot her. It also matches the trial and post-conviction evidence showing petitioner's cell phone activity on the Tennessee River cell tower between 9:50 and 10:37 a.m. Now, this goes down to, where not only are we crediting the testimony of Autry, but we're relying on like the ancillary testimony that helped corroborate Jason Autry.
And this is false because the cell phone activity that he's speaking of that goes from 9:50 to 10:37, when you watch it leave the sectors, it goes from 10:32 it was in the sector where that river was until 10:32. Then it swaps at 10:35 and swaps again at 10:37 into the home tower. And the only way to make that route,
you're already moving like 11 minutes. It's like 11 minutes of driving or something like that, right?
The only way to accomplish it is being on the interstate. It is impossible by any other means. It proves that he was on the interstate traveling home, which is not supporting anything that Autry said.
Because Autry was doing whatever and getting ready to go on his lunch date that he forgot about.
Yeah, and I mean, just because it's circular logic. It's like it places him at the same place because that's why he used that location, because that's where the cell record said they were. But then on close examination, the story is impossible with what he's sharing because of how the cell sector travel shows up.
So they say the statement creates no serious or substantial doubt about guilt, so that claim is denied. So then moving into the ATM video. The ATM video was included in the state's discovery. Although, and they cite that it's still a still image from the video was also included in the post-conviction proceedings. Although mislabeled or difficult to open, the file was nonetheless in trial counsel's possession. Now, this is important if you want to argue like a cumulative effect of all of these different things. This to me seems to be, this court is finding that it was in fact mislabeled or it was difficult to open. The file was nonetheless, however, in the trial counsel's possession and cannot be deemed newly discovered. Because trial counsel, this is the holding from Nunley v. State, because trial counsel possessed laboratory reports before the trial, they cannot qualify as newly discovered evidence. So a sheer calling in this site from Nunley that possession equals you cannot say it's newly discovered. And then from Casterlow, that although the potential evidence came to light only after petitioner's trial, it appeared in his trial's attorney's files and could not therefore be described as newly discovered. And then Carney v. State, petitioner was aware or could have been aware that the evidence at the time of trial, therefore it did not qualify as newly discovered evidence. Even assuming the video is newly discovered, it is not exculpatory. It depicts a truck backing towards an ATM, so we're finding that it's backing, at 11:12 a.m., well after the relevant window during which the crime occurred. It does not show the occupants of the truck and is merely duplicative of the cell tower evidence already before the jury. Both the state's and defense's cell phone tower experts testified that petitioner's phone was in Parsons after 11 a.m. Now, this is like this to me, I think is the strongest point personally, in my opinion, to continue to argue. If the legal analysis here is supposed to be, well, this is cumulative. We already have something else showing 11:12. Why does 11:12 matter? 11:12, and this is Amy Wyrick's, to me, I think, illogical, very elementary thinking argument of, well, the crime occurred earlier, So who cares where he was at 11:12? That can't be an alibi. It's literally not the same time. But that's not how alibis work. Alibis aren't just limited to the moment that a gunshot went off. You have proof that you were in another place. If the state's theory is you did all of these things and followed this precise route and engaged in all of these activities, including transporting the body to the river after you thought it was dead, then realizing she's still alive, killing her, transporting her body to unload her in the woods, and somehow still get yourself to another location at a certain point in time. If it's not possible for you to get there driving the speed limit through the terrain on the routes that match where you're, not only the phone pings for where that record's available for Holly's phone pings from AT&T, but the phone records showing the other devices, the sector information. If all of that comes together, shows that to make this possible, then we need to forego you stopping and making any stops. Then you are establishing an alibi to the state's theory that you committed this successive stage of crimes, this planning, this stopping at different people's houses, unloading the body and having the time to do all of this and load it back in the car and make sure boat guy doesn't see you. If this is only possible if you drive in a straight line on this route and don't make any stops, then it's not possible that you did all these other things that are necessary for you to have committed these crimes.
And that's exactly what's going on. The state wants to have its like lemon pound cake and eat it too, because it can't just, it has no proof to argue against. It's not like, here's all the evidence the state presented and I can now disprove it. It's like it hangs in the air because they don't have any theory. But it's like when you find DNA evidence that's exculpatory and people are freed from prison because, oh, look, turns out it was someone else. That would be like the state just turning around and saying, well, but it could have been both of them. Maybe they secretly knew each other and it was two people. It's like there's no evidence that conclusively proves someone innocent beyond any like whack theory that you can come up with that is unreasonable. So what if he was in California at 11:12? Would that not be exculpatory because it's not the same time? Oh, but it's impossible to get from California to here in that amount of time. It's impossible for the crime to have occurred what they're presenting in the amount of time. It's just,
the crimes and all the ancillary pieces of the crime, right? Because it's not just the abduction time period and then magically you're in Parsons, you can square it all away. It's how do you do all these other things that are critical to the state's theory? You know, kidnapping, raping, when did the rape occur? How quickly did that happen? Because according to Autry, that happened before we even get there. But we have limited tower movement for where Zach's device is. We also have this Facebook information. And all of these little different layers, that was not presented to the jury. Critically, this analysis of the routes by Paula Dillon was not presented to the jury because it only was done after the trial. And then you're missing the critical tracking information that Marshall Walker did because he was precluded from that area of expertise. He wasn't properly qualified as a witness under the counsel's performance. And you have the state here. And while I think it's helpful, I think it's can kicking again. Because you essentially have the judge leaning. It's like he's finding it credible that it's strong evidence corroborates that Zach Adams physically was in Parsons. That it seems like his conclusion is at least more likely than not that Zach Adams was very likely actually in Parsons. That's not what he's saying changed here. He does not seem to be buying into Amy's theory, like we don't know if he was with that device. But he is buying into Amy's argument that we don't care where he was the rest of that morning. We just care where he was at the time that Holly Bobo was abducted. Doesn't matter where he was at 11:12. And that's glossing over why exactly it's so relevant that the jury didn't get to hear from Walker, at least his full analysis, or from what we know now from Paul Dillon. So then they say the ATM footage does not establish actual innocence. The claim is denied. And the reason the ATM footage layers in here is there's also arguments to be made of disclosure issues by the state. right? So here you kind of have more ineffective assistance of counsel. Maybe the jury could, maybe the prosecution could reasonably rely on Autry pointing to specific cell towers because they don't really understand the data themselves to show why that's not true. Maybe it was negligent for them to not try to recreate the route. Maybe you could skirt away from Brady there, but I think we get into Brady issues when we're discussing the ATM footage. And if not Brady, then a glossip issue where you don't have, like, the state should have known that this video existed if it was present.
They're
But
claiming
they made
they
the
did.
representation.
They're
And, well,
claiming
then
they did. That's the whole thing, is if the state wants to say, well, if it's in your possession, you have to be responsible for it, then
Then
that
we knew.
same conditions should apply. And then the state knowingly put on false evidence because the story is impossible with that evidence. So if they had it, then they were responsible for using it, and then they're at fault
And
for
not
putting
confronting
on Jason, Autry, and Victor Dinsmore.
It's just crazy. And it's like so layered. And
It's
then we
sad
only
that
get a
it's
little
like the
paragraph
laws
here.
being weaponized to protect those that profit from it, instead of just applying it in an even good faith manner as it is supposed to go. It's like you're trying to find the loopholes and ways to exclude information that is clearly valid and obscure. It's like the law should be to protect the truth, not obscure from it.
I
and hide
agree.
from it.
All right, so now we're moving into ineffective assistance of counsel. And again, this is we're beyond the buckets of it was waived or it was abandoned. So relating to ineffective assistance of counsel for Autry's 2023 statement. So petitioner argued that Autry's 2023 statement demonstrate that trial counsel's cross-examination was ineffective. Even assuming Autry's statement is admissible as substantive evidence, the court finds that it does not demonstrate deficient performance by trial counsel or prejudice against petitioner. Trial counsel Thompson cross-examined Autry about his relationship with the Bobo family, his phone records, and the route he claimed he and petitioner traveled that day. Counsel questioned him about his height, weight, and hair color. She asked Autry whether he had access to the discovery materials before testifying. She questioned him about his prior statements and his letters claiming his innocence. What was the new information that we learned about the discovery materials in relation to Autry that Jennifer Thompson could not have known and could not have cross-examined on?
The ATM? Is that what you're talking about? There's also,
I guess maybe she could have known, but I was going to say the email with Joe Walker directing give this version that somebody else can't access, which presumably would be the result of somebody notifying the person who gave the order, who's not named in this order, telling Joe Walker, go release this specifically to Jason Autry. Right?
Mhm.
So could trial counsel have been expected to ask Autry about something he may have had access to that she herself was having trouble and raised issues accessing? Would it be reasonable for her to expect that Autry somehow had special privilege access to it? It would be against ethics. So why would you presume that?
Mm-hmm.
So I have a major issue with this. So yes, she did, but there was something that Doug did a great job carving out at the post-conviction proceedings that really could impact the jury, especially within the crux, the couch of these questions about, you have this expectation of leniency, and I'm trying to ask you these questions. They're getting objected to about formal offers being made. But then you get special access to something that we don't get. Did there come a time where, you were able to look at new cell tower information in a discovery packet that you didn't previously have? That was not able to be explored at this point in time. And I think that's so problematic because it goes to prosecutorial conduct issues.
It's interesting. Someone just posted, they wonder how a juror would feel if they knew all this info now. Real Happy 33. I think that'd be so fascinating to know what a juror who sat through that would think in reading this, just because there's so much that didn't come out to the jury that they're trying to act like wouldn't have mattered to them.
Yeah, I know. And I do think it's a difficult question because a lot of people won't change their mind from what they initially decided. So, I think it's helpful if that information comes forward, but if you consider it like starting from the exact same premise, if you have two trial simulations running from a blank slate, not looking in hindsight and saying, had this been presented here, this one little difference, would it have impacted the outcome, is a different scenario than looking back at it. If I knew this, would I have changed my mind? And it can be very helpful if a juror comes forward and says that, but I think there's also psychological reluctance to do so, especially if there's
I mean, we
community
can't
pressure.
expect jurors to admit they're wrong in something when they weren't given the evidence they needed, when we can't have the people in positions of authority admit they were wrong in any of it.
That part too. So she questioned him about his prior statements and his letters claiming innocence. She explored his agreements with federal and state prosecutors and elicited testimony about his expectation of leniency in exchange. See, this is that careful wording. Where's Adventure Aaron? This is that careful wording, right? So first we only have him say above, like, well, it was explored in the other issue, the other paragraphs. For Autry, he was questioned about his hope. But this is now saying that she explored his agreements with federal and state prosecutors. Did she successfully do that? Did she overcome objections where there were opportunities to get around something? And if she's sustained from getting into something, but there was a opportunity to get into it by asking a different question, is that deficient performance? Do we get into that territory?
Seems very subjective.
It's comes down to analysis. So, during her hearing testimony, Thompson expressed that her cross-examination of Autry was ineffective because she could not get him to admit he was lying. Her cross was broad, covered numerous relevant topics, and mirrored the subjects discussed at the post-conviction hearing. While she acknowledged taking antidepressant medication and feeling overwhelmed at trial, she did not take any medication that affected her mental acuity. Strickland requires objective unreasonableness, not perfect performance. The court finds that Thompson's cross-examination of Autry did not fall below an objective standard of reasonableness. Petitioner also fails to establish Strickland's prejudice prong. Counsel could not have cross-examined Autry about his 2023 statement because it did not exist at the time of trial. Well, but what I like about this is that makes Autry a court, a fact finder, evaluating the recanted statement or being able to whatever. That makes that more significant. So it can't come in through an ineffective assistance of counsel claim as far as how trial counsel questioned somebody in 2017. But it's showing that prejudice could possibly be met if this information became part of the record and was admissible and could be adjudicated. There could be some fact-finding analysis done on it. Should it be admissible in a proceeding, a post-conviction proceeding? So I think that's kind of interesting because it's like a catch-22. You have someone recanting, and because he didn't want to testify at the post-conviction proceedings, maybe because of pressure, we're somehow saying, hey, the jury was aware of the pressure that Jason Autry was under up through the 2017 trial, and now we can't explore that even though he recanted once, we can't explore it under oath because he doesn't want to testify for whatever reason, potentially because of pressure or the risk of unwinding the deal that he's currently under. And I just think that this is so problematic. I think it's a miscarriage of justice that somebody can't even explore a co-defendant, cooperating co-defendant's recantation because of this context. I think it's gross.
It's gross. It's missing the forest for the trees and just being so bogged down by the technicalities of the law that you completely ignore the spirit.
Yes, you said that's more than 6 years earlier. Nonetheless, counsel's cross-examination addressed the key themes reflected in that statement, including Autry's use of discovery materials and his expectations of leniency. So the argument here is, even if that recanting came in, Jennifer Thompson already explored that at the 2017 trial. Her questioning elicited information similar to what Autry gave in the statement, meaning the jury was already aware of the substance of the topics contained in that statement. Accordingly, petitioner has not shown a reasonable probability that the result of the trial would have been different. For these reasons, the court concludes that counsel's cross-examination of Autry was not effective. The claim is denied. The ATM video. Petitioner argued that trial counsel was ineffective for failing to introduce the ATM video as part of an alibi defense. Defense counsel must conduct a reasonable investigation or make a reasonable, professionally informed decision that certain investigative steps are unnecessary. That's under Strickland. Any specific decision not to investigate must be evaluated for reasonableness under all circumstances, with substantial deference given to counsel's judgment. And then when determining whether petitioner has shown prejudice from counsel's failure to present evidence, the court examines whether there is a reasonable probability that the missing evidence would have changed the trial's outcome, considering the strength of the state's case and the credibility of the witnesses. Well, I mean, interesting byline here when the state's case is Autry's statement, and we have multiple post-conviction relief testimony segments stating that, oh, the posture of the case, it changed when Autry was willing to give this statement. And not right away, because it was inconsistent at first, but it needed itself out. It evened itself out.
So much so that we needed him to fill in all the gaps, and we gave him a deal accordingly. Because if it wasn't that important, why doing that deal?
This court finds that counsel's performance fell within the range of competence demanded of attorneys in criminal cases. In other words, her investigation into the facts of the case met the minimum standard required of attorneys in capital cases. I say in capital cases. So, regarding the alibi investigation, trial counsel Thompson testified that petitioner told her he was at specific locations when the victim went missing. Petitioner explained that he, Dylan, and Austin drove to Parsons in Dylan's truck, visited Sonic, and used an ATM to withdraw money from Austin's bank to buy Xanax in Parsons. Counsel was aware of Austin's bank records, which showed transactions in Parsons on the relevant day. She understood that the ATM video was very, very important to the defense and considered it a partial alibi. Petitioner's mitigation specialist, Lee Norton, also recommended obtaining the ATM video because it would function as alibi evidence. Both Simmons and Thompson testified they attempted to obtain the video, but the bank stated that the video did not exist. Relying on that representation, counsel believed the video did not exist. And the investigative report.
And Nichols was saying the whole time it didn't exist until she got caught with it.
I think this is unreasonable. Oh, man. So the bank stated that the video did not exist. Well, Thompson's timesheet shows she spent approximately 366 hours reviewing discovery. Both prosecutors testified that trial counsel thoroughly reviewed the discovery, made follow-up requests, and knew the facts better than anyone involved in the case. However, Thompson testified that she did not know the ATM video was included on the discovery hard drive. She attempted to access the file before her post-conviction testimony, but could not open it. The court finds that counsel's efforts attempting to obtain the video from the bank and conducting an extensive review of discovery constituted a reasonable investigation. Counsel also presented sufficient other alibi evidence to secure an alibi jury instruction. Accordingly, counsel's performance was not deficient. The court further finds that petitioner has not shown a reasonable probability that introducing the ATM video would have changed the verdict. As summarized in the direct appeal opinion, counsel presented testimony from cell phone expert Jonathan Reeves indicating petitioner remained at home before going to the river and later to Parsons after 11 a.m. State witness agent Frizzell offered similar testimony. The ATM video of the truck provides additional but relatively weak corroboration that petitioner was in Parsons because it does not show the truck's occupants. All right, so there we go. Now he's saying it's additional but weak. Moreover, petitioner's presence in Parsons after 11 does not preclude his involvement in the crime earlier that day. Again, I think this is showing why it's so critical for the jury to see somebody's analysis on the records. Not just Dylan driving the routes, but also what they weren't able to see from Walker.
Mm-hmm.
So even though he's using this in a manner that helps affirm on one basis, it on the flip side underscores the significance that another piece of evidence would have had if it had been allowed in front of the jury. The jury rejected the cell phone evidence as establishing an alibi or proving innocence. It is thereby not reasonably probable that the ATM video would have changed the jury's verdict. The claim is denied. But it's not the ATM, it's being able to get to Parsons by 11:12.
It's the fact that Autry's
It's the
entire
timestamp.
story is impossible.
It gives you a tangible timestamp rather than like Shane Austin, his transactions just show that this day, this is the transactions that occurred.
And it's completely objective because you're going from cell tower data on crossing sectors to a timestamp from an ATM. So there's no memory or estimate about where anyone was at any certain time. And it's following the state's witnesses road by road account of exactly what they did. And keep in mind, the route is impossible driving as fast as you can and not making any of the stops.
Not with a body in the bed of the truck.
And not wanting to drive like a bat out of hell when cops are looking around for a girl that's missing, and stop, clean out the truck, switch vehicles, get Dylan, wash the scene, all the things that would be involved in disposing of a body. We just cut all that out. We just went drive time, and it's still impossible.
Yeah, and that has to happen after Autry's in the picture.
So the actual day is beyond absurdly impossible for this to have happened.
Like, we're missing the issue. We're missing the issue. So they've got prosecutorial misconduct. So now we're going to look at arguments about prosecutor misconduct here. In relation to the 2023 statement, petitioner asserted two claims of prosecutorial misconduct arising from Autry's recent statement. First, petitioner alleged that the state could not have believed Mr. Autry's recitation of these facts, or it would have had Clint Bobo arrested for obstruction of justice and never would have presented his testimony at the start of trial. Second, that's from the second amended petition. In other words, remember I paused earlier and I'm like, wait, I don't feel like this issue was abandoned. We had people ask about, like, if he's teaching a meth, couldn't that explain, like, buckets? Like, did anyone explore that? I don't think that issue was abandoned. Anyway, in other words, petitioner alleged that the state knowingly presented false testimony that affected the verdict in violation of Napue. Maybe it was abandoned because they didn't ask Thompson specifically about why she didn't question someone at trial.
That's such an arbitrary thing, though. It's not. Where's the rule that the only way to get something in is to ask the trial attorney specifically about what she thought about it at the time?
It's almost like because she's not testifying explicitly that there was no strategy, when the standard is like, if it was unreasonable, there's no reasonable reason to not do something. You can't really, someone could testify that it was reasonable or why they did something. That's not really the analysis, whether you have that testimony or not. But I think it's ultimately to rely on, like, if you ask them, then you'd have testimony pointing to a strategy or lack thereof. And because there isn't an explicit denial of having a strategy, your argument isn't substantiated. I don't know. That's kind of how I read how he looked at a lot of those issues, though. Because a lot of it just came down to, well, she wasn't asked about why she did that. In other words, petitioner alleged that the state knowingly presented false testimony that affected the verdict in violation of Napue. However, petitioner did not plead a specific or complete factual basis for the claim. Apart from listing the allegation in his petition, he provided no further explanation. Alternatively, I mean, doesn't it kind of speak for itself, though?
Well, that's it. Yes.
Because the reason would be
Self-explanatory, is it not?
like, yeah, if you believed it, then this would have happened. So thus, because this didn't happen, and I don't think you need testimony to prove that somebody wasn't arrested. Like, but anyway, alternatively, even assuming the claim were properly pled, the court finds it's without merit. At the evidentiary hearing, neither Autry nor Clint Bobo testified. Although petitioner testified, he was not questioned about this issue. Prosecutor Jennifer Nichols addressed it. She testified that she did not believe Autry was truthful when he stated at trial that petitioner went to the Bobo residence that morning to make meth with Clint Bobo. She explained that she presented the testimony to the jury. Here's a quote from the post-conviction hearings. Because it was part of what was said. And had I not let it all go out there as that's what it said, you'd be asking me, did you parse the statement to hide something from the jury? The jury could decide. You asked me if I thought that Clint Bobo would have taken and cooked meth at Karen Bobo and Dana Bobo's house. The answer is no. I did not think that Clint was going to cook meth in his backyard at the Bobo's house.
Then you have a responsibility to stop yourself from putting it on the stand and representing it as a truth. Like, there is a difference between the public perception of a prosecutor who's representing the state and a defense attorney who's supposed to zealously represent the best interest of their client. And by merely putting someone on the stand, you're representing that you believe what they're saying is true. And this is some crazy bullshit that we're all just pretending that's not relevant and she can just do whatever she wants without consequence.
And look at this, but you submitted it to the jury? It wasn't my statement, Mr. Bates. Yes. It's like, because she didn't explicitly state it, that gets around this issue.
And usually when we're proud of our behavior, we don't spend an entire conversation trying to avoid ownership of it. And it just seems like there's a lot of passing around of nothing was anyone's idea or actions. It was all somebody else that was responsible for it or somebody else that took the statement. Nobody seems to want to own any behavior on the state side with the evidence chain of custody.
Yeah, it wasn't a concern about suborning perjury with Dinsmore. It was concerned about the tactics used that could elicit an untrue statement. Like what?
Like come on.
Yeah. No evidence presented at the hearing clearly and convincingly established that Autry's trial testimony was false. Moreover, petitioner failed to demonstrate how the statement about Clint Bobo cooking meth could have affected the jury's verdict. Autry's claim that petitioner and Austin were at the victim's home because it would have been a credibility issue for... that was argued. Anyway, Autry's claim that petitioner and Austin were at the victim's home was contradicted by the cell phone data and by Clint Bobo's testimony. Without proof, the court cannot conclude that there is any reasonable likelihood that the testimony affected the jury's judgment. The claim is denied. Anyway, second, petitioner argued that Autry's 2023 statement supports a claim of prosecutorial misconduct because the prosecution, 1, failed to disclose a plea agreement with Autry, and 2, Autry's agreement to testify made him a state agent who knowingly presented false testimony. The state denies these allegations and maintains that Autry testified without any agreement for favorable treatment. At the time of trial, petitioner and his counsel were aware Autry was cooperating with the state and would testify. By not raising the issue of an undisclosed plea agreement or Autry's alleged status as a state agent at trial or on direct appeal, petitioner cannot now raise them as independent grounds for post-conviction relief. Regardless, the claims lack merit. What? But if This is so convoluted because if we're also supposed to take at face value or there wasn't a formal agreement, then why would it be so also on a flip side argument that defense counsel should presume that there's a formal argument and it's their fault if they don't raise the issue and draw it out of the prosecutors when it's their duty to disclose?
It's exactly it. It's like, oh, the prosecutors did a good enough job with their game playing that they got some things by and they were able to misrepresent well enough that the defense counsel wasn't able to overcome their misconduct. So I guess an innocent person will stay in jail, prison.
I hate this. I hate this. I really hate it. It's shifting the obligation.
That is exactly what it's doing. That's a perfect way of describing it. That is the thing that is the thread, is shifting the obligation. And that is something that we need to be really scared of.
Well, because I think this is going to be like the idea that but then if we're going to subvert this and say it's counsel's obligation, and this is a capital case, then don't we run into the issue of this is clearly counsel failing to do an investigation into an issue and raise it? So how do we, like, this is creating such a conundrum where if it's supposed to be on the shoulders of the defense to draw this information forward, and it's not the duty under Giglio for the state to produce any information relating to conveyance of benefits, promises of leniency, anything like that to counsel, then is this argument not then opening up another can of worms and showing that, hey, you have defense counsel, if we're going to act like it's their burden, they didn't do their job on this critical issue of an undisclosed plea agreement to investigate, source it, draw it forward, draw it out, raise the issue before trial? Like, can we just waive that? Can we deem that as a waiver? And then if it wasn't raised on direct appeal, but it should have been, is it like, can something like that be waived?
That's a good, yeah, there are things that shouldn't, like, why would we, there's certain things that we need to just agree are never waived in good faith, because no one is going to do that. And it doesn't make any human sense why we would think that someone would knowingly do that. The only time somebody's going to waive some of these arguments is
if they expect that the opposing party, the officers of the court, follow what's their obligation and turn this over. Because the little rabbit hole I went down was just my convoluted plan B argument. The real context here should be it is their duty, is the prosecution's duty to disclose plea agreements if they have it. It should not, and it should never be, a defendant's duty to raise an issue and say, hey, someone's cooperating, and you'll see counsel will do it for the sake of doing it. And I think because they do it because they suspect, like, hey, this could be an issue.
And this happens.
It's becoming taken for granted that it should just be treated as a waivable issue.
That's super true. That's so true. And it's scary. And it's like the attorneys being extra conscientious to try to protect their clients. Over time, it sets a standard where then we start feeling, then everybody else does obligated. It. So then it becomes a standard where it's like, now all of a sudden it's.
But that doesn't it make it more unreasonable when it's not done? Like, it's every time you look at it in one lens, it raises a separate issue. The whack-a-mole pops up on a different hole.
Like, can you state in your own, like, what? How would you plainly state what exactly is claiming to be waived?
Oh, that they're not raising an issue that there was this undisclosed. It's the header. So the undisclosed plea agreement. You know, so challenging his statement through the grounds that at the time of the trial, you know, he said one thing, and then during his recantation, which is meant to show, like, look, he was under pressure and knew to satisfy the state to do whatever the state wanted, what Jennifer Nichols wanted. I needed my story to work from the discovery. They brought me the discovery and I had to work from it. So what page is that on? Existence. Okay, here. So to get around that argument on why this recanting the substance of it could point to prosecutorial misconduct, gamesmanship, things not being disclosed, is you have in this recanting statement Jason Autry representing that something was brought to him. There's other stuff established on the record with testimony at these post-conviction proceedings that same information brought to him was not provided to at least Zachary Adams. I'm going to assume others. And there's a whole separate rabbit hole of issues with that where you're not providing discovery. You're having plea negotiations with an incomplete and disproportionate, imbalanced availability access to discovery where the witness you want to turn their story has differential access.
There should never be any situation where a defendant can ever be understood to have waived any argument that relates to prosecutorial or law enforcement misconduct. That should always be something that is an argument that at any point you have a case to make on it, you should be able to do that, because the only reason anyone is going to waive that argument knowingly is if they're under duress and being pressured to by the state. That's the whole point. You shouldn't have the ability to waive an argument that the state was deceptive and not following the rules or telling the truth. If the state represents something as true, they are on the hook for that. It's not the same standards. We're not even. State has all the money and resources. A defense doesn't. The state is not supposed to be zealously pursuing a conviction. They're supposed to be representing the truth and be even-handed, and the jury has that understanding when they come in. So when they're not, it's incredibly damaging to how people perceive everything going on. I was gonna not do tangents, and I
No, that was good.
give myself a C minus.
Picking up a little bit. Dinner time. Dinner time. But yeah, so this issue, and again, you're kind of going on a point if they're being deceptive, if they're lying, if they say something that's untrue. And remember, being deceptive is a failure to put forth something, right? So here is just a failure to disclose, and it's worded here as a plea agreement, which expresses formality, but Giglio encompasses so much more than just like a hard paper, ink on paper, signed plea agreement. Even a verbal elbow nudging, theoretically, if it's saying to somebody like, well, I could look into a facility where you'd be more comfortable, that's a conference of benefits. Even someone who's not facing jail time, a cooperating witness who's not in custody, but it's like, hey, you know what, we'll fly you out, that way you can be here to prep for the trial, for the duration of the trial, however long it takes for you to testify. We'll pay for your hotel or whatever, and make sure you can travel here. We'll pay for your expenses. Those are benefits. It might seem like, well, shouldn't that be the bare necessity? If someone needs to come testify, it's kind of nice that they're paid. It's still a benefit. It's still something that could influence somebody's bias, somebody's willingness to testify the way that they'll ultimately testify. And under Giglio, anything like that needs to be disclosed. And so often it's not. So often it's not. And then we have this perversion here where it's suddenly the defense's obligation to seek this out. So they're saying that now petitioner cannot raise it as an independent ground for post-conviction relief. So regardless, the claim lacks merit. And I just hate that that's the way that it is. Assuming the claims were properly pled. So now we're going to say, like, all right, if the Court of Appeals disagrees with my analysis, decides that it's not waived, let's opine on the merits. So assuming it was properly pled and Autry's 2023 statement is admissible as substantive evidence, it does not establish that the state withheld a plea agreement, that Autry's testimony was false, or that he acted as a state agent. I don't know how anyone could listen to that recanting and say it did not establish that the trial testimony was false. He describes creating it, which means it's not personal knowledge.
Yeah, you can answer it. I got to step off. I'll be back.
All
if
right.
it's still on.
Yep, we got a ways to go. So we've got So apparently this recanting doesn't establish this testimony at trial was false. In his 2023 statement, Autry did not claim he had an agreement with the state, nor did he claim to be a state agent. At most, he said the prosecutor prepared him for trial. Autry exercised his right against self-incrimination and declined to testify at the post-conviction hearing. Without his, how come we listed 3 things here, right? It does not establish that he withheld a plea agreement, that Autry's testimony was false, or that he acted as a state agent. In the same statement, Autry did not claim he had an agreement with the state, which would be this one, number 1, nor did he claim he was a state agent. Why do we just not say that he didn't do this? How did we as the court, through our analysis, decide that, all right, assuming we make it to the merits bucket, how did we conclude? What was our analysis that got us to say that this statement does not establish that Autry's testimony was false? We leave that out of the second sentence here. That's interesting. So, at most, he said the prosecutor prepared him for trial. Autry exercised his right against self-incrimination. They also had that slip-up at trial where he said he didn't have time to rehearse or whatever his story. Autry exercised his right against self-incrimination and declined to testify at the post-conviction hearing. Without his testimony, the court considered his recent statement only in conjunction with the prosecutor's testimony and the trial record. Both prosecutors denied having an agreement with Autry. They were not asked about the state agent allegation. Prosecutor Nichols testified that Autry, so this is why he's saying that why did he consider it? Then why did the judge consider these 2 prongs? He's saying that I'm only considering this in conjunction with the prosecutor's testimony and the trial record. Says that the prosecutor's testimony, they were not asked at the post-conviction hearings about the state agent allegation. That was not anything that was in place, argued at the time of trial. That was a post-conviction thing only. So why are we relying on the absence of him claiming this in the statement, but then we're also saying, look, we're only considering his statement in conjunction with the prosecutor's testimony and the trial record? I think this is an inconsistent analysis throughout, because it seems like he's considering some parts of the statement in isolation just to point out what is not being said, while avoiding weighing in on what was said. So you are considering it, but you're not considering it. The prosecutor Nichols testified that Autry ultimately received the maximum sentence the state could justify. She explained that the state's case against Autry was the weakest amongst the 4 co-defendants because Autry had not made an inculpatory statement. Prosecutor Hagerman similarly testified that there was no agreement with Autry in exchange for his testimony, and that the state only indicated that his truthful testimony would be considered. Autry's own trial testimony reflected the same understanding. He hoped for leniency. On this key point, Autry's trial testimony and his 2023 statement are consistent. The court finds petitioner did not prove the existence of a plea agreement, that Autry testified falsely, or that Autry acted as a state agent. The court also concludes that the state's use of Autry's testimony did not violate due process, and the state did not withhold impeachment material. Trial counsel thoroughly cross-examined Autry about his expectations, motives, and potential bias, providing the jury a sufficient basis to assess his credibility. And we've got State v. Bolden, holding that weighing evidence and credibility is a function of the trier of fact. The trial court instructed the jury that Autry was an accomplice and that his testimony required sufficient corroboration. The Court of Criminal Appeals found adequate corroboration. Considering the entire record, including the prior finding that counsel's cross-examination of Autry was not ineffective, the court concludes petitioner's due process rights were not violated. The claim of prosecutorial misconduct is denied. So then we're still under the argument of prosecutorial misconduct, but we're going to move into the ATM video angle. Petitioner argued that the ATM video file was deliberately mislabeled on the discovery hard drive provided to trial counsel, and that this mislabeling constituted prosecutorial misconduct and a violation of Brady. The court finds that the ATM video was neither withheld from petitioner nor material to his defense. The ATM video fell within petitioner's pretrial request for Brady material, and the state produced it to the defense. As previously explained, the court's reasons for concluding that the video is not new evidence of actual innocence also supported its finding that the video was not withheld. It is undisputed that the video was included on the discovery hard drive provided to defense counsel. At the post-conviction hearing, petitioner did not establish that the video file was intentionally mislabeled. Agent Joe Walker testified that interns labeled or mislabeled the files, and other members of the investigative team testified that they did not know how the labels or file names were created. Petitioner also failed to prove that Agent Walker attempted to mislead defense counsel or hide the video's existence when he stated in IR 2743, quote, "The other places were not covered by our videos." When questioned about this statement at the post-conviction hearing, Agent Walker testified he could not recall which other places he had checked, but maintained that the statement was not false. The court finds that, although Agent Walker's memory was limited, petitioner did not establish by a clear and convincing evidence standard that Agent Walker's report was deceptive or intended to mislead. The court further finds that the ATM video was favorable to petitioner and that it contributed to other evidence placing him in Parsons. Nevertheless, it was not material to the defense. While petitioner need not show that the video was exculpatory to establish materiality, and I have a separate issue with this, because if we're finding that Zach Adams is not credible, which is now, that's going to carry upwards, this Bradbury's finding that Zach Adams' post-conviction hearing testimony was not credible. You know, this idea that I think the ATM video is relevant most critically because it gives a hard timestamp video and sets the timeline where everybody needs to be in Parsons, unless we assume that Zach isn't with his devices. But we want to rely on his devices when he's at the Birdsong Bridge, so like, what's the difference? When should we pick and choose? But then this idea that cumulative evidence, sure, you don't want to just like keep going over the same thing over and over, but when there's a question of somebody's credibility, sometimes seeing one piece of evidence and another piece of evidence that point to the same thing could go a long way to say, hey, look, when Zach Adams told somebody, like, I remember being in Parsons because I remember seeing this specific deputy that I always have an issue with. And I'm like, well, I want to stay inside this gas station, or maybe it was the Sonic. I don't want to go outside until I see his car drive away because he's always trying to give me an issue. If you have something else that can help show that you were in that location, it could show that your statement about that happening is critical to going towards your credibility. So I think there's a second issue why this would be material, not just for the trial, but also for the purpose of the post-conviction proceedings. And we're just going to assume it's cumulative anyway, it doesn't matter. While petitioner need not show the video was exculpatory to establish materiality, the court's earlier discussion of his actual innocence claim is relevant to determining whether the video could have cast doubt on the verdict. The video does not offer a different perspective. At best, it is cumulative of the cell phone data introduced at trial. The jury heard evidence regarding petitioner's cell phone activity on the morning of the victim's disappearance, including activity in Parsons after 11 a.m., which did not align with the victim's cell phone locations. Petitioner's argument that the video is significant because it places him at a specific, he's addressing it at a specific location at 11:12 a.m., a time when the cell phone data already indicated he was in Parsons. Oh, he's not going for it. Overstates the video's importance. The video does not clearly show enough of the truck to identify it as Dylan's vehicle, and it does not show any person, including Zach, inside the cab. Its probative value is further limited because it depicts events after 11 a.m., which, according to the state's theory, was after petitioner had killed the victim near the river. I thought he was going there. I thought he was going to address the argument. To me, he's still not addressing the specific issue raised that this 1112 is not, I couldn't have been doing the crime because I was doing something else hours later. It's, I couldn't have done the crime and all that I needed to do to complete this crime, as alleged, and still get to this other destination by 1112. He's missing the issue. For these reasons, the court finds that petitioner has failed to prove that the ATM video was material, so the claim is denied. Conclusion. Co-defendant Autry's 2023 statement and the ATM video, taken alone or together, do not establish that petitioner did not commit the crime, show that counsel's performance was ineffective, or support the allegations of prosecutorial misconduct. For these reasons, the claim of actual innocence and the alternative claims of ineffective assistance of counsel and prosecutorial misconduct are denied. Next up, hey, we've got ineffective assistance of counsel. Oh, I'm echoing.
Hi, sorry, I'm back.
That's okay. I don't think my echo's going away. Did you switch to a different headphone setting?
I didn't. I turned it off and then back on. It's echoing now. I can turn it off.
Wait, let me say something. Testing. Do I echo? Should I do a boom like under the bridge? I don't hear myself echoing anymore.
Okay, good.
That was over. It was we were just doing a little birdsong bridge there.
Zach, thanks everyone again for the support. And if all of you are, if anyone's on the fence about just sending him a letter or reaching out in some way, I think that he's real crushed for his family more than anything. I told him that we're not done.
Yeah, make sure you send some good vibes to Cindy as well.
She's struggling. They're all really struggling today. The reality is it's not a good day for anyone. I feel like that Saturday Night Live character that's like, rah, rah, and I'll just come into a wedding and say Ebola virus, but.
Oh, no. That's a good point about cumulative KDR. So we're moving into ineffective assistance of counsel. And so I think this is, again, like very reluctant, didn't want to weigh in on any prosecutorial misconduct findings. But here, I think we get kind of interesting, right? So now we're moving into ineffective assistance of counsel. That wasn't abandoned, wasn't waived, isn't precluded because it's non-cognizable. We've got a failure to retain a ballistics expert. Petitioner claimed trial counsel was ineffective for not retaining a ballistics expert to show that the skull defect was consistent with a .380 caliber bullet rather than the .32 caliber pistol identified by the state. The record shows the victim suffered a single gunshot wound consistent with a .36 caliber or smaller bullet. The state linked a .32 caliber revolver to the homicide. No .32 ammunition was found in petitioner's home, and his grandfather testified neither owned such a gun. At the evidentiary hearing, firearms expert Alberto Davis described .380 dimensions. Trial counsel Gonzalez, this is Jerry Gonzalez, testified that he researched skull defects, consulted with the forensic anthropologist, and cross-examined the medical examiner thoroughly. Thompson attempted to find an expert who would exclude a .32 as the cause of the defect, but could not find one. The court, well, that sounds pretty bad, actually. The court finds that trial counsel's investigation was reasonable and met professional norms. The state did not present a ballistics expert and relied on the medical examiner. Trial counsel conducted a meaningful inquiry and cross-examination. Petitioner failed to prove deficiency or prejudice. The claim is denied. And I think this makes it seem like nobody was willing to cast doubt on that. But I think it could very reasonably be attributed to Thompson was running around with her hair on fire and wasn't even speaking with witnesses who she subpoenaed and trial was starting. So, but the way this reads is like, you couldn't find a single expert to give the conclusion that you wanted, could you? Is kind of how that reads.
Mm-hmm.
And failure to review discovery. And the issue isn't excluding, right? The issue is this was excluded as a possibility by Jennifer Nichols. That's the particular issue, is that the .380 was excluded. And we don't have confrontation of that, proper confrontation of that at trial which is jury got to miss an analysis and also pushing back on the prosecutor's representation, putting forth a mischaracterization to the jury, right? So it's specifically not countering the exclusion, the state's theory that this was excluded, which was argued in closing to the jury, the last words, versus excluding 32 necessarily. Because I don't think if we got this in and someone was still saying like, yeah, it's possible, I still think the jury could reach a totally different verdict had they not thought that that 380 casing was definitively excluded.
They did such a good job of just, and that's another thing. It's just so much of it was presented, but it was presented in a way that was not effective. And the jury's attention and focus was being pulled into other directions in a way that was misleading and caused them to, exactly. So they can't hold all that information at once. And it's like, they were really weaponizing, like using every cognitive vulnerability that we know exists for juries and just weaponizing them to make sure this jury walked away cross-eyed and not knowing which way was up.
But the investigation was reasonable. I think this needs to be spelled out more than this. Did I scroll? No. Where was the failure? Yeah, this could not find one. Anyway, so they say that I think the investigation was reasonable. I think this needs more analysis. Because did she attempt to find it? Like, how many people did she contact? What were the billable hours? Is she just saying I wanted to do that? Because she testified that she wanted to do a lot of things. But I think there should be a specific quote here from the transcripts that suggests that it was declined, that she actually interviewed several witnesses that said, look, this is hogwash. But anyway, to not find an expert that could come and say that this isn't actually excluded is a separate issue that's not addressed here, and it's just glossed over. And we're just assuming that because this was done, that she also investigated having someone come in that could specify this 380 issue.
I still don't think she or Nichols or Wyrick, I don't think any of them fully grasped the issue. Like, I don't think any of them really understood it.
The podcast could help them. I agree. I don't think they get it. I don't think they want to understand it. I think their brain shuts down when they hear discussion of caliber. It's something that took me a long time to get. I'm not familiar with it. I don't like speaking about firearm related terms. I don't know how to pronounce things. I'm not the expert.
I forced myself. I'm going to know all about this because I don't want a case with 3 female attorneys to go down over math and firearm.
Oh my gosh. But
that's
what's happening.
We are not going to be that. Yeah. It's like, come on, ladies, like learn it, please.
No, I really think that that's exactly what's happening. Like, it's
sad.
The court finds that, so they deny this claim. Trial counsel conducted a meaningful inquiry and cross-examination. The state did not present a ballistics expert and relied on a medical examiner. I think this might be interesting because I believe that this testimony, even though you can talk about what you're used to seeing, how wounds and entrance exits might present as you examine, and you go through all these autopsies, you probably come across more than one shooting incident or wounds caused by some type of ballistics. But how this was not the type of person that could opine, in my opinion, on the dimensions, which is the critical issue here, the dimensions of every part of that projectile. And what if an ammunition is rated as being this dimension when it's whole, after it's fired, and again, if we're this relates to the credibility on the revolver issue, it would require us to assume that it's true, which is we shouldn't be doing. This is something that the jury needs the information to fully consider, all available information and expertise to consider if that's truly credible. But it wasn't contested because we didn't have a firearms person presented by either party. We just had, well, this revolver could have fired this thing that could have caused a wound of this size. And this idea that It's not ineffective assistance of counsel just because the state didn't put on a ballistics person. They put on ballistics testimony and ballistics expertise through their medical examiner. And I just don't think that that was appropriate. So, and I believe, we're not saying that that issue was waived. I would love to see another court opine on this issue. Anyway. Trial counsel conducted a meaningful inquiry and cross-examination. Petitioner failed to prove deficiency or prejudice. That claim's denied. And we got failure to review discovery with petitioner. Petitioner alleged that his attorney failed to review the entirety of the discovery material with him, and that jail restrictions prevented review of electronic materials. Petitioner testified that counsel met with him frequently and reviewed discovery. He contended, however, that he did not see all the materials because the jail restricted computer access. Thompson testified she met with petitioner 10 times before trial and would review anything upon request. But how would he, upon request, how would he know what to request? But petitioner struggled cognitively due to long-term methamphetamine use. The court finds no deficiency. Petitioner failed to show specific omitted discovery that would have affected the verdict. Jail restrictions are not attributable to counsel and should have been raised on direct appeal. This claim is waived under Tennessee Code Annotated. I don't really have a particular issue with the finding on this issue, but I think going back to the umbrella of the ATM video and, why wasn't that honed out sooner? How was Zach supposed to know that there was the still frame of his truck until he saw it on Boyano's screen during a proceeding? I think that's a very different issue than the overall, he wasn't able to go through all of his folders. There's still a survivable issue that this thing was available, that to him, he did truly newly discover it in the middle of court. But
it's dangerous to me that we're not distinguishing honest error from a pattern that looks and feels like gaminess and acting in bad faith on the part of the state. Our unwillingness to call that out is scary to me.
And then Autry gets particular access. So it steers me back to this idea, well, you can't fight with the court. There's issues with electronic access. But then you have one co-defendant who got special treatment access. Stupid. Failure to recreate a timeline of the offense. Oh, Lord, I don't even want to read this one. It's going to piss me off. I know it. They say the petitioner alleged counsel
failure to recreate a second amended petition, failure to recreate a timeline of the events. We had a table. There was a table. It's an excellent table.
Well, they're saying ineffective assistance of counsel at the trial. Because they didn't do this at trial. So it wouldn't be when you guys came into the picture. It wouldn't be when you came into the picture.
I'm following, but how could they do that? So isn't that a cascading? I guess we'll see. I would think that'd be a cascading error because you need the ATM footage in order to build a timeline.
So I'm pretty sure that this does not include the factual basis required is in this second amended petition. They don't cite to a transcript of testimony where somebody's saying, yes, we failed to recreate a timeline of the offense, right? We've seen that argument repeat. They don't provide a factual basis. They also say it's without merit. Okay. Marshal John Walker created a map based on cell phone data. Although the trial court excluded the map, Agent Dykus testified the cell phone records established that the defendant could not have been involved in the kidnapping. Cell phone expert Jonathan Reeves testified that the victim's phone traveled in a direction inconsistent with petitioner's cell phone movements. The same evidence plus excludes the map. The same evidence plus the excluded map, I read that wrong, was introduced at the post-conviction hearing. Petitioner failed to overcome the strong presumption of reasonable professional assistance. The jury heard the substance of the cell phone movement evidence related to the victim, petitioner, and the co-defendant. Petitioner has not demonstrated that admission of the map would have changed the verdict. The claim is denied. What really sucks about the admission of the map is you could use it in your closing if it was admitted. And really, the critical part of a timeline to me would be as a demonstrative, where you'd be combining. So if an expert can only say, like, these are the cell phone records that I'm mapping out, they might not be the right person to sit there and add markers that notate, look, this is where we found these objects on the side of the road, or where this was discarded, right? The attorneys have to compile that through different expert reports, through different pieces of testimony, and put together a demonstrative that combines everything.
Well, and it's also, to me, it's the prejudicial aspect of it in the jury's perception. It's not just about whether they have the map or not.
If they see it not allowed in, they're like, oh, it's bunk.
Exactly. It's about the weight that the jury is going to be giving different evidence based on what they see the judge modeling and what evidence he's giving credibility to, what evidence and jury, give him a speech all you want. Something's not allowed in. There's a reason why, and you make inferences. And then you combine that with his behavior and how incompetent he made Jennifer Thompson look throughout the entire hearing, combined with he's watching football and clearly indicating to the jury that this isn't important. And so it's like all these little things, if we review them in a vacuum and look at it,
you make it look like a desperate attorney that knows their client's guilty and they're just trying to make anything stick, and there's nothing that they can work with that would show that the client actually has an alibi, that the contesting the state's ability to meet their burden. It's
exactly
just a desperate defense attorney.
Exactly. It's not the absence of the evidence being presented as much as it is the inferences they're going to draw from the interactions between the court and the attorney over it. And that's why,
especially when everybody disagreed with Terry Dicus, right? We have that testimony as well by the time he's put on the stand by the defense. Crazy. So he fails to overcome this. The jury heard the substance of the cell phone movement evidence related to the victim, petitioner, and the co-defendant. Petitioner has not demonstrated that admission of the map would have changed the verdict. I don't know. The substance of the wording.
Mm-hmm.
Alleged hostility towards trial counsel and her recording of other attorneys. Petitioner alleged Jim Simmons inadequately represented him regarding hostility towards Thompson and her recordings of other attorneys. Petitioner introduced evidence of contentious trial environment, but failed to question Jim Simmons about this issue. Petitioner presented no evidence showing the allegations regarding Thompson's recording practices impacted her performance before the jury. The court has not found, and petitioner did not suggest, that the trial court made any findings of misconduct, nor was any evidence presented to the jury regarding these allegations. Wasn't the issue that it was like keeping her out of going back to TBI to do physical reviews of the evidence? Well,
you're trying to arrest her for recording evidence that she needed recordings of.
So how are we circling this to say that they presented no evidence showing that the allegations impacted her performance before the jury? Like, the argument would not be this was tense and it impacted her before the jury, although I think there's a cumulative, like, her demeanor in front of the jury for a multitude of factors was an issue. But the idea that this issue stemmed down to a direct impact of how your demeanor comes off in front of a jury, it's not that. It's if you feel like you can't go and properly evaluate the evidence because you have to go in person to look at it, but then you have Jennifer Nichols standing over your neck and running to the judge and saying you're doing something illegal, that's going to chill you. That's going to chill your advocacy in looking into the evidence, which could then impact what you present in front of a jury.
That's such a good phrase. That's what they do. They chill the advocacy any way they can.
And it's to treat this issue, and I don't remember being pled this way. I do remember, like, a general argument that, like, her demeanor in front of the jury was so chaotic nobody would be able to track it. Like, it was just overall a bad performance because no one could follow it, even if she was saying something in the middle of 10 bumbling phrases that could be effective had the jury had a pause and rewind button. but yeah, to me this is jumping the gun on what the issue actually is. So They say petitioner presented no evidence showing that allegations regarding Thompson's recording practices impacted her performance before the jury. The court has not found, and petitioner did not suggest, that the trial court made any findings of misconduct, nor was any evidence presented to the jury regarding these allegations. It's not about the jury thinking that Thompson was chastised in front of the jury about this specific issue. Like, though there are other instances and examples where that was raised. It's about being scared to go back to that evidence room. Petitioner relied on State v. Zimmerman, which emphasizes the importance of a defense attorney's credibility before the jury. But Zimmerman is distinguishable. There, the attorney promised evidence to the jury in opening statements and then failed to produce it. Here, the jury was unaware of any allegations against Thompson.
Which makes it worse, because they're just wondering what's going on and they're not able to see what is happening. Or even, I mean, I think it'd be better if they did hear the allegations against her, because then at least they would see how ridiculous they sound.
But this is so, you're right. But I think that the critical issue is if Thompson in openings, like, you're going to hear these phone records make it impossible, you're going to see it mapped out, all these different things, and then that stuff's not allowed. You do have an instance where something's promised in openings and then it's not produced because somebody gave up. And they might not have given up because of this one specific behind closed doors. But he's pointing to all of this stuff that led to that waterfall, that cascade, that collapse of Jennifer Thompson. We're going to produce all of this stuff. And then after I'm getting berated every time I want to introduce something in front of the jury, and the court keeps ruling against me. And you have Gonzalez. Didn't Gonzalez testify that she lost track of what legal basis to raise when she did raise objections to opposing counsel? That
she wasn't able to pay attention to the testimony because she was going through trying to review her notes when she would find out who was being called to the cross. That the other counsel would be nudging her, like, object, and she'd object and wouldn't know what she's objecting to because she wasn't hearing what was going on.
Which means that by the time you get up there to clean it up on cross, you don't know what you need to clean up because you don't even know what you're objecting to. Yeah, so that is separate, but also a problem. But yeah, this idea that he's honing in on this one particularity of this, like, behind doors chastising, were you recording opposing counsel, whatever, as if that's the thing that is what Doug and co were referring to when they made a broader argument that, like, this repeated instance of here's the thing she wanted to present, she promised an opening, she failed or was either not allowed to. Either way, she either missed the opportunity, but it's not prejudicial. It was deficient but not prejudicial. Or, you know, she just, for whatever reason, it was sustained, objected to, this can't come in. She looks like a bumbling mess in front of the jury because of all of this, like, cumulative repeat stuff. And he's watering it down like it was just one tiny thing that the jury had no idea of and no promises were made in opening that were bailed on.
That's exactly it. It's a pattern that he's reducing to an isolated event when it's not an isolated event. It's an illustrative example of what was going on throughout the entirety of the case.
There you go. I like that. Isolated, and it wasn't. Attorney Gonzalez testified that when he joined the team, Thompson and Simmons no longer were communicating, and the courtroom atmosphere was highly adversarial. He described the trial judge as very confrontational. Ooh, are we going to finally get that one mention? Towards Thompson, and that prosecutor Nichols as equally adversarial. Oh. He described... How is this worded? He described the trial judge as very confrontational towards Thompson and prosecutor Nichols as equally adversarial.
I think he's saying that the trial judge was adversarial towards Thompson and Nichols was also adversarial towards Thompson.
That reverse wording.
Mm-hmm.
It confuses me when he does that. This hostility, he said, caused Thompson significant stress and impaired her ability to work effectively, according to Jerry. Thompson testified similarly. She stated the judge belittled her repeatedly and that both the judge and the state were rough on her in front of the jury. She believed this dynamic harmed her confidence and made it difficult to advocate effectively. The stress also impacted her mental health to the extent she began taking high doses of antidepressant medications. However, Thompson ultimately acknowledged that she did not believe her performance changed the outcome of the trial. Petitioner's attorney inquired, "Do you think if you'd done a better job, the verdict would be the same?" She says, "I think so, because I think the way we picked the jury and the way the judge was handling the case, I don't think the judge was going to let Zach get a not guilty. I think the judge was going to do what he needed to do in order to see that there was a conviction in that case." Okay, it would hurt you professionally if it were your fault, right? I'm not sure it would hurt me more than this testimony's hurting me.
I really like her. I mean,
The court finds that petitioner failed to rebut the strong presumption of reasonably competent professional assistance. The evidence does not show that either Thompson or Simmons fell below the minimum professional standards, nor does it establish a reasonable probability of a different result. The claim is denied. All right, now we're going to look at Jim Simmons' motion to withdraw. Petitioner argued that Simmons' motion to withdraw improperly expressed a belief in petitioner's guilt, violating attorney-client privilege and constituting ineffective assistance. Thompson testified that Simmons pressured petitioner to plead guilty and that petitioner therefore wanted Simmons removed. She recalled that the motion to withdraw mentioned something to the effect that he believes Zach was guilty. Simmons, however, testified that he never stated petitioner was guilty, only that, given co-defendant Autry's cooperation, a death-qualified jury would likely return a guilty verdict. He believed but that's the inconsistency we talked about earlier. He was already positioned to look for a settlement before Autry had this like glorified story. So to say that I then, had concerns that this would likely be a guilty verdict only at the point in time where Autry came around, then why were you looking for a settlement and almost not wanting to go to trial from the very inception? And he says he believed the ABA guidelines obligated him to pursue settlement discussions. This to me is deficient. This belief is objectively deficient.
I've always thought if anyone in this case does, and I know people say he's a nice guy, I'm sure he is. If anyone in this case deserves ineffective assistance of counsel, I think it's Simmons.
On a critical thing, specifically because it's in the context of a death penalty case, he's like, "Oh, I thought my obligation was to pursue settlement discussions." Like, maybe pursue, but like
he's so concerned about his obligation. What did he do? Did he really do much work on the case?
No, and then he visibly distanced himself, which he tried to give a reason for that, but to me that conveys, like every other case, it's like humanize your client, sit next to them, show that you're not afraid to sit next to your big bad, accused of being so dangerous client. I
do give him, I think that's because he's a death certified. Often they do that where they have the sentencing attorney not sit at the table for the guilt portion, because the idea is if they're found guilty, then basically your team has lost credibility with the jury. They've been telling the jury their client's innocent for however long, and the jury clearly doesn't believe them. So you want to bring in a fresh attorney who doesn't have any experience of the jury associating them with the client, because they may have more credibility when they're explaining why he shouldn't get the death penalty. I think that's what he's getting at there. That being said, he still totally owed his client a lot more than he gave him, and I think it was deficient the way he handled himself.
I wish I was familiar with more death penalty cases, because we just watched the Julio 4, it's Florida. They only needed 8 of 12. They didn't need all 12 to be convinced of a death recommendation.
Oh my gosh.
And they all opted to give life without parole rather than recommend death. And counsel all sat at the same table for all 4 defendants. And anyone that had a separate attorney do the mitigation arguments was present during the guilt phase as well. So
yeah, I mean, I can see. I think there's a different schools of thought, I guess.
Yeah. Well, and that's what I'm saying. I'm limited. I wish I watched more, because that's like one instance, and there could be more factors. Like maybe the jury decided to opt for life without parole for all 4 because they didn't want to do it for one and not for all 4. You know what I mean? Like there's factors that could play into something that's different than a credibility or merits assessment of the argument raised for mitigation. Because they did find that the state met aggravating factors, but they still recommended no death recommendation. Which I think it's interesting that that's how the penalty verdicts work. Like, you have to make a explicit finding that aggravating factors were found and then still make a distinctive recommendation. It's not just if you find the aggravating factor, then automatically your recommendation must be given. So,
Well, and I think this is all completely calculated. They wanted the death penalty certified jury because they're more likely to convict, and then they don't want it to actually be death penalty because you have a whole bunch of extra protections built in that Zach could have leveraged, and I think they didn't want any flashlight shining on this case file.
crazy. The justice system is so complicated and so long-winded. But yeah, he says the death qualified jury would likely return a guilty verdict. I mean, he says it there, just what you just said. He believed the ABA guidelines obligated him to pursue settlement discussions, which created friction with Thompson. And importantly, petitioner offered no proof of how the Simmons motion prejudiced his case. The court finds that petitioner failed to prove by clear and convincing evidence that Simmons actually informed the trial judge that he believed petitioner was guilty. Simmons' affidavit clearly states, "Based upon my experience, education, and the facts of the case, I believe a trial would result in a guilty verdict and sentence of death." His statement of a belief about how a jury may rule is not a statement of belief about petitioner's guilt. This distinction is legally significant. Even assuming the motion implied guilt, petitioner provided no evidence showing prejudice. The claim is denied. And then during trial, ineffective cross-examination. You know what could have been argued? I kind of wish it was argued. If the rift started after Thompson began to believe that Zach was innocent, after she explored the evidence, and that's where some of the rifts. I think it was around the same time period, but there was so much going on. You need testimony where someone, hey, like, look, I'm the one that was boots on the ground, and this is when I noticed the change.
And Thompson didn't testify to that?
Not in that specific context. She testified that she began to feel that she didn't initially think so, but then she began to change her mind. But I don't think she testified along the lines of that timing had any causation with a rift, whether the first showing of a rift or a significant growth in a rift between myself and co-counsel. But I think if that's the case, if that happened that way, and it wasn't something that she talked about, it could have been helpful.
That makes sense.
It's like a bit more specific, right? You're not leaving it up in the air for someone to make that leap if you can get testimony about it, if that matches the timing.
I just thought I remembered her talking, not in the frame of, I guess, the timeline of it. I did think she was testifying about the pressure she was getting from other defense counsels because everyone wanted to settle the case, and she was the only one who wanted to take it to trial. And she was arguing the innocence, and everyone was telling her that she believed her client too much.
You might be right.
I'm not confident in it. I want to go back after reading this. I want to go back and watch sections of her testimony again now.
Rewatch the whole thing.
Yeah.
We'll run it back.
You
We'll run it in a different order
the whole
this time.
thing.
They've got the during trial ineffective cross-examination, just generally speaking. Petitioner alleged that trial counsel's cross-examination was lackadaisical and rambling. I agree, objectively, resulting in ineffective and disorganized presentation. Thompson acknowledged she was unprepared for trial and unable to conduct the focused, strategic cross-examination she believed were necessary. She expected a continuance and dedicated considerable time pursuing newly discovered leads, rather than preparing targeted cross-examination of key witnesses. As a result, she reviewed records during direct examination instead of listening and forming cross-examination questions. Co-counsel Gonzalez confirmed Thompson's difficulties, noting that unknown witness scheduling increased the burden and caused Thompson further stress. Okay, that's important. Before we get there, I wish there was a specific inclusion here that Gonzalez had to nudge her to object. That would have really driven this home, and it is part of the record, but it's just not part of his analysis here. I think
any unknown witness scheduling. I mean, I do, I'm glad that it was at least indirectly referenced.
Yep, so we have here, guys, a finding that Thompson lacked a strategic reason for omitting the cross-examination questions raised by post-conviction counsel. This is prong 1 of the Strickland analysis for ineffective assistance of counsel on the issue of her general lackadaisical / rambling presentation, cross-examination when it came to questioning witnesses. Thompson conceded these questions were consistent with her theory of defense and, in hindsight, should have been asked, meaning she's explicitly stating there's testimony that she gave where she said, hey, I don't really have a reason why I didn't ask those. However, the court credits testimony showing Thompson possessed a deep factual knowledge of the case, possibly more than any other lawyer involved. Given the voluminous discovery, the court's review of Thompson's trial performance, and all the circumstances of the case, the court cannot conclude that Thompson's failure to ask certain cross-examination questions constitutes, quote, egregious error under Tennessee law. And we're citing here Douglas v. State, recognizing that the failure to ask particular cross-examination questions does not alone establish ineffective assistance of counsel. And then Moffitt, where effective assistance is not flawed, perfect, or error-free assistance. So it doesn't need to be the most perfect. So he's saying that, look, there's no strategic reason. This was deficient. The first prong is met. But this deficiency is not enough to meet the prejudice prong. It's not enough. So then we've got under Strickland and Goad v. State, counsel's conduct must fall below an objective standard of reasonableness. The court finds that under the circumstances, Thompson's preparation efforts and cross-examination performance did not fall outside the range of prevailing professional norms. Wait. What? How are you finding that there was no strategic reason for the omission, but then finding it not to be deficient? I think this is inconsistent.
Yeah, he's saying in the context of everything else that it's not egregious enough.
It's almost like saying it's reasonable that she was so busy, that's why she wouldn't be able to be prepared to ask this, but that's not the way you're supposed to analyze whether it's reasonable to not ask a certain question. Like, he's taking the practical issues of someone that's juggling a bunch of plates, not being able to juggle an additional plate. But that plate, it's really about whether a plate, there's no strategic reason to not make that one of the plates that you make yourself juggle. I think this is such a weird analysis. I think this is weird. I'm stunned that we have this. Just to have this. The court makes a finding that there's no strategic reason for omitting the cross-examination questions. It wasn't a decision of strategy. But he's also finding that the conduct must fall below an objective standard of reasonableness, and that under the circumstances, which are she's so busy, Thompson's preparation efforts and cross-examination performance did not fall outside the range of prevailing professional norms. This to me is almost like an endorsement that, so what if there's something that should be presented and it's unreasonable not to present? If you're busy, if you're under-resourced, it's too bad, so sad. That's how this reads to me. But they say even if certain cross-examinations were deficient, petitioner has not established prejudice. Evidence related to the themes raised at the evidentiary hearing was presented to the jury at trial. Additional questioning of witnesses would have been cumulative rather than outcome determinative. Thus, petitioner has not shown a reasonable probability that the result would have been different had the cross-examinations been more thoroughly conducted. That claim's denied. Petitioner's scars. At trial, the state argued that scratches on petitioner's arms were defensive wounds inflicted by the victim. FBI Special Agent Matthew Ross observed those scratches during his interview with petitioner. According to Agent Ross, petitioner consented to photographs, which were admitted as exhibits at trial. The photograph showed vertical linear marks on the inside of the left forearm, along with a round scab on the tricep. Petitioner stated he received the scratches while running through the woods and a briar patch a few days before the victim disappeared. Agent Ross agreed the marks appeared as reddish-pink lines without scabs and resembled pink-colored scars. Petitioner's girlfriend, Rebecca Earp, testified that she noticed 3 parallel scratches on Petitioner's neck the day after the victim went missing, which she'd not seen the previous day. On cross-examination, Earp described the scratches as superficial and located on the right side of the neck, extending from beneath the jawline towards the Adam's apple. She stated she initially did not report the scratches because she was scared. She also told a defense investigator that the scratches were unrelated to the victim's disappearance and were sustained when Petitioner ran from a park ranger prior to the offense. She testified Petitioner always had scratches. Defense counsel also presented testimony from bail bondsman Christy Gutzel, who assisted Petitioner after his arrest at Natchez Trace State Park. Gutzel testified that Petitioner has scratches all over him like he ran through the woods basically, along with older scars on his arm. She observed scratches across his arms, legs, and neck. At the evidentiary hearing, trial counsel Jennifer Thompson testified that she addressed the scratches during trial and introduced testimony from multiple witnesses offering an alternative explanation for their origin. The court finds counsel effectively challenged the state's theory and presented the jury with a reasonable alternative account. Although the argument was ultimately unsuccessful, counsel's performance was not deficient. That claim's denied. The petition also alleged that counsel should have objected to a dermatological assessment of Petitioner's scars by a lay witness. Petitioner, however, did not question trial counsel about the issue at the evidentiary hearing, nor present any such dermatological proof. Accordingly, the court finds the issue waived. Alternatively, Petitioner has not overcome the presumption of reasonable professional assistance, and without proof, the court cannot determine any significance or prejudice. The claim is denied. So this particular specification is like put back in an earlier bucket. DNA of the hair in Terry Britt's vehicle. Petitioner failed to plead a full factual basis for this claim. He did not cite the record to show any instance of deficient performance by trial counsel concerning DNA evidence, and it is not the court's role to research the record on his behalf. At trial, Agent Terry Dykes testified about the search of Terry Britt's home and property, including hair recovered during that search, as summarized on direct appeal. Inside Mr. Britt's van, hairs were found that were microscopically and macroscopically identical to the victim's hair, but DNA analysis later showed that the hairs did not belong to the victim. At the evidentiary hearing, post-conviction counsel did not question trial counsel about hair evidence, nor present any forensic proof or argument explaining how counsel should have addressed the DNA results differently. So he's relying on what the appeals court concluded. So, on that, which is why he pointed out earlier that after that, at this post-conviction hearing, which happens after the fact, when we have testimony from someone who's pointing out, like, hey, the hair, we have Walker saying, like, hey, there was his hair, we don't have any lab results come in. So it looks like he was looking, he's saying that he would have been open-minded if something came out that contradicted what the Court of Appeals relied on, as far as that DNA result. And nor should they say that they didn't present any forensic proof or argument explaining how counsel should have addressed the DNA results differently. Post-conviction counsel referenced the victim's hair in Britt's vehicle several times while examining witnesses, but testimony on this issue was inconsistent. Viveros testified that Janet Britt stated there would be various types of female hair in her husband's vehicle. Viveros also said a hair matching the victim's had been found. Marshall Walker testified that the FBI indicated it was the victim's hair. Lewis testified the victim was excluded from the hair found in Britt's home, and Booth stated a hair sample was not tested. This inconsistent testimony does not establish by clear and convincing evidence that trial counsel should have pursued the matter differently. The court finds petitioner failed to prove the hair matched the victim, failed to overcome the presumption of effective assistance, and failed to show prejudice. The claim is denied. What was the claim specifically? Just deficient performance concerning DNA evidence? Was it the failure to ask a specific witness?
Well, I think it was the failure to test the DNA evidence, wasn't it, of the hair, and to different. I believe it was to test the DNA evidence of the nucleus of the follicle that's still sitting in the evidence locker, and to better explain the whole convoluted thing about the mitochondrial DNA, where they tried to, basically they took advantage of the fact when people hear DNA, they think that that means for sure.
But like, there's like a 1 in 5 chance that if you like test the outer strand of my hair now, and then in like a few weeks from now, it could be totally different. It'll look like it's not a match as far as a mitochondrial read, because it
mutates
cells
at
reproduce.
a high rate. Yeah. And
Mhm.
so it's like there's a high, so if you get a match, you can be confident that's legit, but if you don't get a match, it doesn't mean that it's not. And it's actually got weird things with the confirmation, because it's like a maternal thing that passes. But anyway, basically microscopic sounds less official than DNA. So they're acting like, well, it was this, but then the DNA, but it's like of the two, one test is way more accurate than the other, and neither are even anywhere near as accurate as the nucleic DNA testing that they could have done, but they didn't run the evidence they had.
Yeah, and he's not weighing in on that, and I don't know, because the distinction I remember like my biggest recall of it is watching your podcast episode about it, the Trial and Error podcast episode about it. Was maybe there was an issue in how it was pled, and that particular argument, the distinction, like he's saying it's consistent as if, while some person's saying DNA testing was done and someone else is saying it wasn't done. And it's not really just that, it's the type of testing that was done versus the type of testing that wasn't done. And that would kind of go, if that's lost on him, that kind of ironically shows that why it would be so important for the jury to be aware of it. So, but maybe it wasn't, maybe it was pled in a way that wasn't clear, but this would kind of be interesting to I mean, I think that's huge for the reasons that you said. Juries are very inclined to give weight to DNA evidence. And if there was a distinction between how reliable the testing that was done versus they got to see, the follicle, any type of follicle results, I think that could be impactful. But I mean, either that wasn't argued in a way that it was understood, or it was lost. It was argued, but it was just lost on the judge here.
Yeah, it's like the concept never really clicked.
Yeah, like missing the concept of why 11-12 matters.
Mm-hmm.
Yeah, so he goes over the inconsistencies and then says the inconsistent testimony does not establish by clear and convincing evidence that trial counsel should have pursued the matter differently, and then this court finds that petitioner failed to prove the hair matched the victim, failed to overcome the presumption of effective assistance, and failed to show prejudice. The claim is denied. So also, I think this touches more on an actual innocence claim, right? It's not just a failure to test to see what the result was. It's also saying, like, you can't, if we're going to go the actual innocence claim, you need to do the lab work yourself and produce that scientific information for the record for these post-conviction proceedings. So he structured this like we're going to address these certain buckets in this order, but he's like trickling in and interweaving them. Ineffective cross-examination, petitioner's inculpatory statements. All right, so we're getting the Zach's stupid mouth or whatever folder. 7 witnesses testified that petitioner made inculpatory statements. Trial counsel cross-examined each of them. At the evidentiary hearing, petitioner testified regarding his relationships with those witnesses and the context for those statements. However, he did not question trial counsel about her strategy, nor present testimony from any witness to show what additional or different cross-examination would have accomplished. The court therefore finds petitioner has not overcome the presumption that counsel's performance fell within the wide range of reasonable professional assistance. Without evidence of counsel's investigation, strategy, or decision-making, the court cannot identify deficient performance or resulting prejudice. So that claim is denied. So is this like not, is he saying that this wasn't abandoned, but there still wasn't enough for him to weigh on? So it's like there's no merits determination here?
That's how I'm taking it.
Interesting. Ineffective cross-examination, Jason Autry. Generally. This is the broad top level, guys. Petitioner argued that trial counsel failed to conduct an adequate cross-examination of Jason Autry, who petitioner claims provided blatantly perjured testimony. It's from the second amended petition. He further contended counsel should have used an expert to educate the jury about false testimony and that Autry's 2023 statement shows Autry fabricated the entire story to avoid what Autry's attorney described as a 95% certainty of conviction. According to petitioner, counsel could not get Autry to admit he was lying because Autry was manipulating everyone in order to obtain a reduced sentence. At the evidentiary hearing, trial counsel testified that she consulted with a memory and false confession expert. Petitioner did not ask why she chose not to call that expert at trial. Nor did he present testimony from that or any other expert explaining what such a witness would have said. Trial counsel acknowledged she was unable to get Autry to admit he was lying. How was your cross-examination of important witnesses? She says, well, Victor Dinsmore and Jason Autry, it was poor. In the past, when somebody lies and makes up stories, I've been able to go through their story very slowly and show all the lies. I mean, they get twisted up in their story. But Jason didn't get twisted up. He stuck with it. And so what I ended up with, this is the problem. What I ended up with doing was just nailing down, just confirming and reaffirming Jason's story. Instead of showing that he was lying, he was lying. I wish there was a follow-up question from Doug to the effect of, reinforcing, did you expect that Jason would be called that day? Because I do think there was some post-conviction testimony about the surprise of who was being called on day 4, whatever he testified. But then, what time of day was this? You asked for more time, right? And you weren't given more time, right? Because the problem that I'm seeing here is it's like Doug assumes that because it's in the record that this judge is going to see it. And this judge is multiple times now said, well, you didn't specifically ask this person during the post-conviction proceedings about this. And it's almost being taken for granted. So, and I mean, maybe having her specific testimony is critical on that issue. But I would still think if she's acknowledging that it was poor, she's admitting that it's poor performance. And we also have the record showing that she asked for more time, and so thus she didn't have the time to go through their story very slowly. We get there. But Judge Bradbury's like, no, you didn't specifically ask, so I'm acting like it doesn't exist elsewhere in the record. Counsel's inability to achieve her intended impeachment strategy standing alone does not constitute deficient performance. So they cite Strickland. The mere fact that counsel did not pursue additional impeachment methods does not establish deficient performance. A defendant is not entitled to perfect or error-free representation, only constitutionally adequate assistance. And then it cannot be said that a failed witness examination strategy rises to the level of incompetent representation. Here, counsel cross-examined Autry over more than 150 transcript pages addressing his drug use, phone calls on the day of the crime, and the route he said he traveled that morning. She also used satellite images and had Autry mark them. While she chose not to use an expert, she was not required to do so. Moreover, petitioner, but that's not why she's doing the satellite imagery exercise. Is that lost in the sauce too? Because that seems like glaringly obvious why you'd have Autry do it. He's the fact witness. You're locking him down on his recitation of his supposed personal knowledge of the route that they allegedly took that day. He's the one to turn that from allegedly to actually, if you find him credible. That's why you have him do this exercise. And here it's being treated like, sure, she could have had an expert do that. But it's about his testimony and his descriptions as he's describing where he's drawing on the map. This is bizarre. Moreover, petitioner produced no evidence that an expert would have provided testimony that would have changed the result. Because Autry invoked his right against self-incrimination at the evidentiary hearing, this court was unable to assess his credibility. The jury's verdict, however, demonstrates that it credited enough of Autry's testimony to support a conviction. Petitioner has not overcome the strong presumption. Oh, that's actually important. This whole thing. You want to weigh in on this, Katie? These two sentences here.
Okay. Because Autry invoked his right against self-incrimination at the evidentiary hearing, the court was unable to assess his credibility.
So stop there. Why is that important?
Well, I think it's important in part because he's making a point of saying that he could have possibly found different if he had reviewed it. And
there's been no factual determination on recanting, because part of trying to call him was to ask him questions to lay foundation to make that recanting statement admissible, right? It wasn't just calling him blindly.
Exactly. Well, and he was going to appear by Zoom, but he was found unconscious on a ventilator 2 days prior and put on a ventilator 2 days prior.
That'd be great context to have in here.
It would be great context. And the state was adamantly opposing and interfering with every attempt the defense made to bring him. And we have no idea of really knowing if Jason was wanting to or willing to testify or not.
It's the state's word.
Exactly. They wouldn't let me talk to him. Because I don't think his attorney was really able to get in touch with him in a meaningful way.
Did he submit an affidavit?
The attorney?
No, Jason.
No, because I tried to go back when their original.
No, I mean, like, did he send an affidavit with a sworn statement that he was afraid to come testify, didn't want to come testify?
No, nothing directly from him.
And I think that's problematic because we're relying on it without that qualification that it wasn't a direct. He's invoking his right, maybe through his counsel, you could argue.
Yeah, and the problem with that is my understanding is Ben Harmon was appointed to represent him and never met with him in person and had like 1 or 2 shitty phone calls with him where he could hardly hear anything. And Jason Autry is, I think, part of why the state jumped on it to ask for Jason to have an attorney is the state wants it known that it requested an attorney. Like, do you think Jason Autry is going to trust an attorney that was requested by the state? When he thinks I'm not willing to talk to him because they're blocking my communications. They're not letting him call his mom. They're not letting him talk to anybody.
It's important context.
He's isolated and then we're taking the state's word that he's too dangerous. And the state is simultaneously concerned about Autry's well-being and is concerned that his rights are being violated somehow. And they're trying to protect him while also acting like he's so dangerous that it would be a harm to everyone else if they brought him to jail.
And honestly, I think that puts more weight into what he says in 2023, because if there's been all this time where someone was pissed and wanted to make sure that 2023 statement goes nowhere, there's all of that timeline where you would have no access to, no knowledge of, no awareness to create that arm's length distance from what you previously said to that lady that recorded you. So then we've got the jury's verdict, however, demonstrates that it credited enough of Autry's testimony to support a conviction. What is that part hinting at? The jury credited enough to support a conviction. What if something happens that discredits Autry? I think it'd be very hard to get around a harmless error claim. Like, you can't just claim a harmless error when this is not the first time the judge has been like, all right, we're pointing out somebody saying that Autry's testimony was critical. And now he's concluding that the jury's verdict demonstrates that it credited enough of Autry's testimony to support the conviction. Petitioner has not overcome the strong presumption of reasonable professional assistance, and without expert testimony, the court cannot assess the significance or prejudice of any alleged failure. Next up, we've got Austin's gun. At trial, Autry testified that the pistol he saw holstered on Austin on the day of the offense was the same pistol used by the defendant to shoot the victim and was the same gun recovered by law enforcement. Trial counsel Thompson cross-examined Autry about this identification. Question. Now, initially during your proper session, you specifically said that the gun that Shane Austin had was a .38 or a .357, didn't you? That's correct. That's what I was under the impression of it being. Why would impression? It's supposed to be your knowledge. Anyway, that's before they found a gun in a creek, isn't it? The gun. And the gun they found in a creek is a .32, isn't it? If you say so. You don't know what caliber that gun is? I do not. So you just eyeballed that gun and you're pretty sure, even though it's rusted, it's the same gun? That is the same gun. It's the same gun, but you have to admit it's much rustier than it was when you claimed to have originally seen it. The bluing's off on it and it's aged. So at the evidentiary hearing, counsel testified she failed to clearly emphasize that Autry originally identified the murder weapon as a .357, but later described it as a .32. She admitted she did not know why that point was unclear and attributed it to inadequate preparation. The record, however, shows that counsel did cross-examine Autry on this inconsistency. Autry conceded he did not know the caliber, but maintained that it was the same weapon. I think the problem is you don't follow up on it. There is no, because I think he's missing the issue again, right? Because she's clearly, you first gave a statement that it was not a .32, and then you give a statement that it is a .32. And he's treating this like, well, she did question that about the calibers. Do you think that's questioning on the critical inconsistency?
I think it's so key that she said, you said it was a 38 or 357. That's to me the critical error there, because oh, you said the gun was a 38 or a 357. That to me, what I'm hearing is you're not exactly sure what kind of gun it is. So you're naming two guns that, I mean, are similar, versus saying it's a 380 with an interchangeable 357 chamber. That to me is, I have really specific knowledge of this gun, that I know exactly what caliber it is and something unique about it. That's a firm, exact statement. And so that's to me where I think this went wrong, is when she, by her own lack of understanding of the differences,
the follow-up questions don't come out because she doesn't get the significance.
She projected
and why?
the doubt onto Victor Dinsmore and made it look like something that was far less damning than it actually was.
And how, like, so, and then your impression suddenly changed to this very specific 380 with an interchangeable barrel, but you weren't even sure if it was a 380 or a 357. How did your impression change and get so specific later in time?
Well, that's
the questions you need to ask.
And then it moved to 32. So it's like the idea that you thought it was a 380 or a 357 and then changed your mind and thought, no, it was a 32. To me, that, while I don't believe, is much more believable to me than it's a 38 with a 357 interchangeable chamber. Oh, wait, no, it was a 32. It's like you're going from a place of uncertainty to a different caliber, versus you're going to a place of extreme certainty and specificity to a completely different caliber. That's where I like, it's a subtle thing, but it's huge to me in how a jury's going to receive it and all the inferences they're going to make on it.
Well, and the importance of follow-up questions. So the idea that she's like, hey, that was poor questioning. I wasn't prepared because I didn't prepare my cross-exam flow. Saying that, well, you did do some cross-examination misses the point. Autry conceded he did not know the caliber. It's leaving the jury to just be experts and figure out why it's an issue without the facts being elicited through further cross-examination questioning. It's just to presume that they know the rest of the record and watch the trial and error podcast, which they're instructed not to do and would be excluded if they had that information otherwise available. Autry conceded that he did not know the caliber, but maintained it was the same weapon. There's no indication that continued questioning would have changed his testimony. If you question him on how he was so sure at some point in time, how did you suddenly change and say that a new weapon must have been the weapon? This is, I hate it. I hate it. Once again, petitioner has not rebutted the strong presumption of reasonable professional assistance. Without proof, including Autry's testimony or other evidence, the court cannot assess the significance or prejudice of any alleged deficiency. The claim is denied. All right, so petitioner also claimed counsel failed to question Autry about the echo of the gunshot, failed to use a photograph of the scene, and failed to present flood level or water level information. At the evidentiary hearing, petitioner did not ask counsel about these issues. The state asked whether she consulted with a sound expert, and she could not recall. Without evidence of counsel's investigative process or proof of what such questioning would have revealed, the court cannot evaluate the significance or potential prejudice of the alleged omissions. I think we got into the prejudice and significance of it through questioning of other witnesses.
I noticed a pattern where he keeps saying
it has to
something
be of
wasn't addressed.
Thompson.
Yeah, or someone it's often Thompson. It's like, well, they didn't ask this one specific witness. Well, it doesn't mean that it wasn't addressed, because it seems like it's always instances where I can think of other witnesses he was asking about it.
We're going to have an ineffective assistance counsel argument on a layered appeal. Because there was earlier, he cited, like, in Tennessee, like, certain arguments, it's required that you point to, like, citations in the transcript or whatever. But he didn't frame it out as, like, every single issue needs to be asked of a particular witness that might relate to the claim. So, without evidence of counsel's investigative process or proof of what such questioning would have revealed, the court cannot evaluate the significance or potential prejudice of the alleged omissions. The petition also states that counsel should have used a photograph showing the area where Zach allegedly shot the victim to challenge Autry's testimony about visibility. Second amended petition. Yet the record indicates counsel used satellite images during cross-examination. Her performance is not deficient simply because a satellite image is above. It's not going to show height, standing, visibility. Because Jason Autry's testimony is he couldn't see certain things over the very tall brush that were totally taller than Zach, but then he also saw things very clearly, like how Holly was positioned right when he was about to shoot her at a specific part of her head. So that's why the vantage point of a photograph at eye level, where you're standing where Jason Autry testified to, under the bridge where there would have been an echo, was more important than just a photograph looking over the shoulder from the highway, or satellite imagery, which is going to be top down. So I don't get how we miss this. So presenting satellite images is not the same as showing a photograph. Her performance is not simply deficient, simply because she did not ask a specific question about visibility. Autry testified they left the river because they heard a boat motor. Whether Autry saw the boat does not undermine that stated reason. Petitioner has again failed to rebut the strong presumption of reasonable professional assistance, and without supporting proof, the court cannot assess the significance of prejudice of the alleged failure. So the claim is denied. And then ineffective cross-examination. Brent Booth. Petitioner asserted that trial counsel should have used the factual basis contained in the wiretap warrant of Britt's residence to demonstrate that Britt lied about his alibi, his cell phone, and his prior knowledge of the victim. At trial, the jury heard that Agent Booth initially focused on known sexual offenders and that law enforcement took Terry Britt's life apart. Booth conducted physical surveillance, placed wiretaps on Britt's phone and inside his home, executed search warrants on Britt's home, property, vehicles, and outbuildings, and interviewed Britt's neighbors. Booth testified that despite this extensive investigation, law enforcement found nothing connecting Britt to the victim. Trial counsel Thompson did not cross-examine Booth, specifically regarding Terry Britt, though she questioned him about other search warrants, including the warrant for the Bobo family's bank records. At the evidentiary hearing, trial counsel testified she should have relied more heavily on the search warrant affidavits when examining Booth. So her answer was, so with the search warrants, I mean, I did bring up the fact that he'd done hundreds of search warrants, and I did ask Brent Booth about that, but I should have gone through them, each one, and said, you know, you at one point said it was the Bobo family, and you at one point said it was Terry Britt, and all the different search warrants he'd done for all the different people that he'd sworn on oath that they were guilty. I should have been much more organized and laid things down like that in a solid... I should have just gone through one by one and just shown how the state had changed their theory of the case so many times. And then also found that no physical evidence was found in Zach's home either, which is why you stopped looking at other suspects. But post-conviction counsel questioned Booth about the facts asserted in the probable cause affidavit for the search warrant. So this is Doug. You just tell the court what the probable cause was, sir. If you need time to review this, you can. And then the answer was identification of Terry Lee Britt as a suspect. Terry Britt's past sexual predatory behavior. Terry Britt's alibi is false. Terry Britt changes his physical appearance. These are headlines to paragraphs that Terry Dykes and I wrote. Analysis of the Holly Bobo cell phone records. Subject's residence and proximity to physical evidence recovered. Terry Britt's pre-abduction knowledge of Holly Bobo. Additional predatory behavior of Terry Britt, etc., etc. It goes on and on. And then Agent Booth then reiterated, consistent with his trial testimony, that the search warrants that we had served on his property, his residence, his vehicles, a totality of everything that we looked at and heard on Terry Britt, did not yield probable cause that he was the individual that committed this crime. Although the facts supporting the search warrant might have supported the defense theory that Britt was the perpetrator, Booth had already testified at trial that the thorough investigation yielded no evidence linking Britt to the crime. As his post-conviction testimony shows, further questioning by trial counsel would likely have led Booth to again emphasize that the investigation did not yield probable cause to suspect Britt. So that's saying, like, there's a clear strategy why you might not continue questioning, because it could elicit something that would confirm the state's theory and bolster the state's theory. So the court concludes that petitioner has not overcome the strong presumption of reasonable professional assistance. Even assuming counsel should have questioned Booth further, petitioner has not shown a reasonable probability that the additional testimony would have affected the outcome of the trial. Claim is denied. Ineffective cross-examination of Victor Dinsmore and the mistrial. Petitioner contended that trial counsel inadequately cross-examined Victor Dinsmore on his inconsistent and evolving statements, as well as the circumstances surrounding those statements. Petitioner asserted that counsel should have questioned Dinsmore about whether he previously identified the gun received from co-defendant Austin as a .38 revolver with a .357 interchangeable barrel, rather than simply a .38 or a .357. Petitioner further asserted that private investigator Dennis Benjamin threatened Dinsmore with the death penalty and pressured him to adopt a false narrative implicating petitioner. Petitioner also alleged that Dinsmore told Benjamin that Dillon was the weak link among the co-defendants, prompting law enforcement to pressure Dillon to talk. Petitioner also alleged that Booth suggested the facts Dinsmore should testify to and told him that remembering certain facts would help the case. At trial, Dinsmore denied that on the date of the offense, the defendant said he'd parked his truck in Dinsmore's shop. Dinsmore said, though, that the defendant hid the truck in the shop sometime after the victim's disappearance. He recalled that they moved tires in the shop to conceal the truck, and that the defendant hid it because he attempted to run over Natchez Trace Park police with the vehicle. Dinsmore also testified that after 2 months after the victim's disappearance, Austin traded Dinsmore a pistol for drugs. Although Dinsmore knew he could not possess the gun due to his status as a felon, he believed he could sell it. He identified the pistol recovered during the police investigation as the handgun Austin traded for 12 morphine pills, and stated that Autry was present during the exchange. Dinsmore ultimately gave the pistol to his wife, but later told her to get rid of it because he feared it had been used in a homicide. She disposed of the pistol, and in 2016, Dinsmore aided law enforcement in recovering it 3 to 4 miles from Yellow Springs Road. Trial counsel cross-examined Dinsmore on his prior inconsistent statements, highlighting that, although he told Agent Trout that the petitioner hid the truck, he did not specify the barn. She questioned him about his interview with Booth, his changing memory, and the inconsistencies in his description of the gun. Dinsmore confirmed that Booth returned the next day so that he wasn't the one putting words in your mouth. He acknowledged making various inconsistent statements and explained that speaking with his wife and daughter refreshed his memory. He also admitted suggesting multiple types of guns prior to the victim's remains being discovered. At the post-conviction hearing, trial counsel testified that she received audio recordings of Booth's interviews with Dinsmore before trial, considered them significant, and had them transcribed because Brent Booth was absolutely telling Victor Dinsmore how to testify. She described her cross-examination as poor, explaining it reinforced Dinsmore's account rather than undermined it. She conceded she did not address the inconsistency in the timeline involving the argument between petitioner and Austin over who would hit it first, which did not fit the state's theory if referring to the victim, because the argument occurred after her death. Counsel also admitted she created the impression that Dinsmore mentioned 2 guns rather than 1, the .38 revolver with a .357 interchangeable barrel. Finally, she acknowledged she did not object or seek a mistrial when Dinsmore testified, contrary to the recorded interview. That he spoke with his wife prior to the Booth interview. She stated she avoided requesting a mistrial because she did not want another opportunity for the judge to belittle me in front of the jury. Dinsmore did not testify at the evidentiary hearing. As a result, the court cannot assess whether his testimony would have differed, if at all, nor can it evaluate his credibility. And I'm going to highlight because I think this is an issue I want to see if this continues to be argued further up. Because I think while it might be reasonable why somebody might not want to act a certain way, might not want to deal with repercussions, there's a presumption where the judge isn't supposed to put his finger on the scale. They're not supposed to opine unless something warrants a rebuking because somebody like did something out of line. You're not just supposed to chastise one party or the other because it could impact a credibility assessment that's supposed to be in the jury's hands and not influenced by a judge's facial expressions or commentary towards counsel. So to me, to argue that this was a strategic decision not to ask for a mistrial, but it's couched within because the judge was doing something the judge shouldn't have been doing anyway, and I didn't want him to do it again. I don't think it's appropriate to say there was a strategic reason that she didn't ask for a mistrial. And in other words, because she didn't object, that it's waived because she made a strategic decision and failed to object. And it's not ineffective that she failed to object because it was a choice. A strategic choice. She never should have been in that position where that had to have been a strategic choice.
Exactly.
Is how I read it.
Exactly. You shouldn't have to pick between bad options about how do you deal with systemic and like inappropriate behavior by people who know better.
Well, I wonder, is there like a case that's had to deal with this before? Where you have counsel say, look, I intentionally chose not to object or request a mistrial. And my strategy for it was something that relates to like this issue that shouldn't be happening anyway. Is there case law that instructs what should be done here, how this should be analyzed? Because to me, it should require a different analysis. It's not just plainly there was a reason why something wasn't done, and a reasonable circumstance that warranted a reasonable strategy call.
Yeah, it's a tough situation because there's just no right answer, and it's totally victim blaming in the sense that you're basically, we have laws and rules we're supposed to follow. I mean, I think the proper response is probably to file a complaint to the Board of Judicial Ethics, whatever their exact title is. And I mean, who thinks that would have worked? Nobody.
In the middle of a trial.
Exactly.
Dinsmore did not testify at the evidentiary hearing. As a result, the court cannot assess whether his testimony would have differed, if at all, nor can it evaluate his credibility. As stated, counsel's performance is judged objectively, not by hindsight or by whether cross-examination successfully led the witness to admit to dishonesty. Trial counsel cross-examined Dinsmore on his inconsistent statements concerning the gun and the white truck and relied on the transcript of the recorded interview with Booth to challenge his account. Petitioner has not rebutted the strong presumption of competency. The court finds that counsel was aware of the facts, prepared for cross-examination, and addressed the relevant issues. Accordingly, the court concludes counsel's performance was not deficient. Furthermore, because Dinsmore did not testify at the post-conviction hearing, the court cannot find prejudice resulting from any alleged deficiency. And again, part of that comes down to, he said earlier, he's not going to consider some of Dinsmore's statements in the recording. That was kind of just shown to show the manner of questioning that Dennis Benjamin was engaging in.
I think it's concerned, like, that makes it seem like it was something that Doug didn't do that he should have, or didn't address that he should have. Dinsmore was subpoenaed twice.
Uh-oh.
And didn't show up. And I think I have a strong feeling Dinsmore might say that the state was communicating with him during this time period and trying to pressure him not to come.
I would love that. And I would argue that this is an important place to, if you're going to ask the appeals court to evaluate Judge Bradbury's decision, this would be an important piece of context. Sure, he cannot weigh in on something that he didn't have presented to him. But it's important context to know. And it's interesting because I don't think, Bradbury's not saying this thing's waived because he abandoned it, he didn't present something. But he is saying that I can't get into this. Well, if somebody was requested and didn't want to show up, couldn't you normally make an inference from that? You might not be able to make a full
the reason
conclusion.
they're not showing up might be because they're being continuing to be intimidated and pressured by the state.
And that would be, I think, something that would warrant a hearing. If there's something that could be established there, I think that would warrant a hearing, because it would be critical to something that the court's saying, hey, like, I would have weighed in on this if it was available to me. Here's why it's not available.
Another thing that I think might warrant a hearing would be the body and dash cam footage of Jason Kilser when those get released.
That'll be a good time. Not going to be new scientific evidence under Dellinger, but the failure to establish an alibi. Petitioner argued that trial counsel was ineffective for failing to establish an alibi for Zach through Facebook login information. All right, guys, this is a lot to track. We saw a little bit of a mention of this earlier. Facebook login information, testimony from Rita Austin and her son's ATM's receipts, and a more developed timeline of his movements on the date of offense. The Facebook login. Petitioner contended that counsel should have corroborated his alibi by introducing Facebook records showing he logged into his account on the morning of the offense while at his grandparents' home. At the evidentiary hearing, petitioner testified accordingly. Agent Ferguson confirmed that someone logged into petitioner's Facebook account at 8:39 a.m. on the day of the crime. Ferguson also testified that the records did not identify who performed the login. Right? So you can't say it was Zach. Trial counsel Thompson testified she had no strategic reason to withhold the Facebook login information, acknowledged it was available in discovery materials, and noted that the login appeared to have originated from a landline connection. The court finds that petitioner established the absence of strategic reason for counsel's failure to introduce the Facebook records. However, petitioner has not shown prejudice. So earlier when I was like, all right, we're finding no strategy, you see how he's not specifying here, no strategy, and I'm also finding I'm finding deficient performance, or I'm not finding deficient performance. He jumps from no strategy, next prong. But earlier, he found lack of strategy, but I'm going to say it's not deficient because of the circumstances, which I thought was interesting. And then
mixed messages.
And I think, again, that the appeals court can review that de novo. They can actually weigh in on that determination with their own fresh eyes. But here, he's doing it absence of strategic reason, next prong. We're going to the prejudice prong, and he failed on prong 2 of the Strickland analysis. Petitioner did not show prejudice. He says that the jury heard multiple sources of evidence placing petitioner at home during the relevant time period. Agents Frizzell and Dykes, along with defense expert Reeves, testified that petitioner's phone communicated with his home cell tower. That doesn't put someone at home, though. Right? We do all understand that logging in on a device that's connected to a landline is very different than an appearance on a tower.
Yeah.
So it communicated with his, quote, home tower between 8:19 and 9:12 a.m., which includes the 8:39 a.m. Facebook login time. Thus, the Facebook evidence is cumulative of other evidence presented to the jury. No, it's not. How is that cumulative?
How is that cumulative?
This is ridiculous.
Who are they suggesting was at home at his grandma's house logging into his Facebook?
I need the Court of Appeals to disagree. And maybe they could still find it wasn't harmful, but I hope that we do not establish.
He was somewhere else at the exact time this crime was happening. Seems relevant.
This is crazy to me. And also the idea that, like, the towers were so close between Holly's home and Zach's home tower. So to have a precision, how is that cumulative? It's the same thing. It's very different to be able to distinguish more specifically that somebody likely to be Zach was logged in on a hardwired landline connection through a device, logging in on Facebook.
That happens
This-
to be
this just pissed
exactly
me off.
consistent with the alibi he was giving before all of this data was pulled.
Because he's consistent and credible in those statements. Maybe he doesn't remember everything.
But the things he remember align with later evidence that is pulled based on his statements, not the other way around with Autry, where we have all of the evidence and then we give it to him and have him fashion a statement that fits as best as he can make it.
I'm so annoyed. I did read like, oh, they talk good. He looked at the Facebook thing, but I glossed over this detail. I'm so annoyed that he called this cumulative.
Mm-hmm.
Facebook evidence is cumulative. And I would argue somebody borrowing your phone, hey, Dylan doesn't have a phone. That's a good reason why maybe he would borrow his brother's phone, walk around with his cell phone where his tower's pinging. If we don't know who has a different device, it's objectively more important to know that something that would require a password is being utilized. And something that's not likely to be moved around. Like, we're not carrying this PC and logging in to Facebook wherever we want. Like, this is just so ass backwards.
And
this
again,
is so ass backwards.
If you are having someone else log in to your Facebook as an alibi for a crime that you're going to then commit and then forget you were on Facebook, so you don't even bring this
You
up.
wouldn't volunteer your alibi.
And you'd probably have that person do something else on Facebook other than post, "You never was, you stupid whore." Like, that's just not what you'd post. That's what you'd post if you were going to go do drugs that day and you were going to spend the day preoccupied with a fight you're having with your girlfriend.
Yeah, you keep the records in a safe.
Getting in a fight at Joe's video and headbutting her and falling down.
And that explains the fight at Joe's video, because you were calling her something gross earlier in the day. Oh, man. This just... I'm like, wind down. We're like almost done. We got like 15 pages, not even 12 pages to go. And this just riled me all the way up. Further, the investigative report in Exhibit 100 does not identify the device or person associated with the login. Fair enough. Reducing its probative value. Not so. You want to know why? Because counsel could have reasonably investigated that information. They could have done something else to try to bring it forward. Or if they already had the information, such as the substance of the message, they could have asked the detectives, especially during the post-conviction proceedings, like, we have testimony from Ferguson saying, like, hey, there was this login here, and yeah, we don't know who's on the device. But at trial, if you thought to ask it at all, and someone tried to offer that explanation, like, yeah, but we don't know who actually signed in on the device and was using the Facebook, then you can ask the substantive follow-up questions. And all of that, to me, goes to demonstrate further an ineffective assistance of counsel and no strategic reason to not ask such a thing. Maybe you could argue you didn't want to show that he was cursing, but that evidence came in anyway, that they were fighting. So it's not like there was a strategic decision to not want to show something mean when that was already going to be established through Rebecca Earp's testimony. And then, I don't know. I want to go back and see if there were objections about specific lines of questions during trial on the substance of the fight. Like, was she just not going to be able to get into it? If maybe she wanted to ask Rebecca Earp about it, would she not be able to ask? Or did she just not even try? I don't remember. But they're saying here that the investigative report, it doesn't identify the device or person associated with the login, reducing its probative value. Accordingly, petitioner has not demonstrated that the omission of this evidence affected the outcome of his trial. And then they cite Williamson v. State. So we have a case here with a holding that says counsel's failure to preserve phone messages did not prejudice the defendant when he was able to introduce evidence of the victim's anger through other means. What? Was Williamson v. State like a self-defense case? I'm going to get pissed off again if that's the case. Because how would that holding apply to the context here? Because it seems like the argument Williamson would have made would be, look, I wanted to introduce specific messages. Counsel failed to preserve the messages. And those messages would have shown something that I showed otherwise. But what Zach Adams is trying to show here is a specific and precise, constrained physical location at the home at a precise time.
That supports an
very
alibi
different.
he'd previously given to police on multiple occasions.
Let's see. First degree murder, life sentence. Let me see if request for self-defense instruction. I searched the word defense. So this case deals with self-defense. So I can tell. I'm not a lawyer, guys, but I love when the holding, the little teeny quote that we get from a case that's being cited, when I can tell just from the holding that the context isn't going to be applicable for the purpose of the analysis we need to do here for what we're evaluating. Because this very clearly signaled to me, sounds like someone's trying to show evidence of self-defense, and they weren't able to show, here's the angry messages that somebody said, where maybe it would show, I could argue, they were the aggressor. They were coming at me. That's
that like
not
just
relevant here.
premeditation, not alibi.
Well, that too. Different.
Also,
a different reason it's not applicable.
it's a
to
different.
here.
Yeah.
And it's not really a failure to preserve messages. It's a failure to introduce them.
And I think it probably would. How would she have introduced? I guess without Zach to authenticate it, it would have been. Could she have introduced that by getting someone at Facebook as a records custodian? Although that wouldn't have authenticated it as him writing it if they're saying that someone else could have been on his Facebook.
But listen, if a prosecutor wanted those messages introduced, they damn well would just go get the business records, and they would say, look, if you have any question that it was him, his personal cell phone was also in this area, you make the conclusion on if you think Zach was, or the person we're trying to show sent these messages, which
a prosecutor would have, but how would the defense counsel get it in?
But I'm saying that business records, and it seems like Jennifer Thompson didn't go that route at all for admissibility. So it's a missed opportunity.
Yeah, she could have said the same thing. She could have said, well, and I guess we know what they're going to think about it.
Yeah, the state obviously didn't think these they were aware of them. They looked at him.
They were just hoping that they didn't come up, that they could drown Thompson enough not to bring up the things that would have proven their shit story wrong.
They deny that claim. Rita Austin. Petitioner asserted counsel should have questioned Rita Austin, mother of co-defendant Austin, about her son's financial transactions on the day of the offense. Although Ms. Austin testified at trial, petitioner offered no testimony from her or from trial counsel at the evidentiary hearing on this issue. Trial counsel Thompson testified that petitioner told her he was with Austin when he withdrew cash from an ATM in Parsons. Trial counsel knew Marshall Walker had subpoenaed Austin's bank records. When shown an ATM receipt at the hearing, which was not entered into evidence, counsel noted it was dated 2 days before the offense. She was also told no ATM video existed, although she believed that such a video would have been strong evidence. Counsel explained she presented other evidence placing petitioner and Parsons through Reeves. All right, so I think this is saying that her failure to do something in questioning of Rita was because of her impression of the existence of a video. And that might make it, in a bubble, reasonable why you don't see Thompson questioning, because based on what she was aware of, she's like, I can't get into something because I was told it didn't exist. But then that confounds the problem and the importance of all the other fuckery with the ATM video, quite frankly. That's how I'm looking at this paragraph.
And I just have to say, it was super dirty what they did with Rita Austin in the original trial when they put that in front of her and wouldn't let her read it, but asked her to identify the handwriting. And they made it seem like that was a confession. He never confessed. It was a list of 4 things. They asked him to write down any rumors that he has heard going around town, same thing they did with Dylan. And he made a list of the rumors that he had heard people saying. And that's what she was shown. Not any kind of, he never gave any kind of confession. That never happened. It's a complete lie, like everything else. He took an immunity deal because no attorney ever is going to represent you and say, no, don't take an immunity deal that's being given to you. like, I'll take an immunity deal on any crime that's going on. Just why not? It doesn't mean you're guilty. It means you were offered an immunity deal. But then they took it from him because he couldn't tell them where the body was. He would have no self-serving interest not to give them that information at that point. He's already taken the deal that would make him look guilty, which is what I think they did on purpose. And he can't give the information to keep it when he wouldn't have been charged for it. And then they're going to pull some dirty shit like that on the stand. If as a state, if you have good evidence and you believe in what you're doing, you don't have to play these games and these tricks. And just weaponize the system. But yeah, I just think Rita really got a bad shake on that.
All right, so she said that she was told no ATM video existed too. And counsel explained she presented other evidence placing, but this is interesting. This is so interesting to me. I know I keep coming back to this stupid ATM video because there's like multiple reasons why, like there's multiple issues that stem from this ATM video. And there's multiple points of why this would be something that could lead to reversible error. And this idea that you have a witness on the stand confirming, like, oh, I was told no ATM video existed.
They're the reason we found them too, Rita and Jimmy.
The video or?
Yeah. Because the bank manager had come to them and told them that he had offered it to the TBI and they didn't want it. And I think he didn't feel good about it. And that's what clued me in that it existed.
And the jury didn't hear that. They got to hear that they were told that it didn't exist, presumably by TBI, which to me just, yeah, we were also told that. That's contemporaneous. You're being told the same thing by a bunch of agencies. So any inconsistency could be narrowed down that there is, in fact, no ATM video. And if Jennifer Thompson decides to suggest otherwise, she's going to sound like the crazy loony defense attorney throwing spaghetti at a wall. So I don't see the strategy for some of this. But again, I guess he's leaning on to Rita didn't testify at the post-conviction proceedings. So he's finding himself constrained on weighing in on Jennifer Thompson, whether or not she should have questioned Miss Austin about the ATM transactions that particular day. So they're saying that petitioner didn't prove by clear and convincing evidence that the existence of an ATM receipt dated the day of the offense. No receipt was produced for this court. Because petitioner failed to show such a receipt existed at the time of trial, he cannot establish deficient performance or prejudice. Additionally, counsel presented alternative evidence of petitioner's presence in Parsons. Petitioner has not overcome the strong presumption of reasonable professional assistance. The claim is denied. The timeline. Petitioner claimed counsel failed to offer a complete timeline of Zach's movements on the date of the offense. But this makes the... Help us. This makes the 11-12 so much more important. But he said it doesn't matter. It would just be cumulative of cell phone information.
It's not cumulative. It's corroborating. It's corroborating the cell phone information that they're trying to discredit. You can't have both at the same time where you discredit evidence as being insufficient to prove your point, and then you say the corroborating evidence that supports it is cumulative and therefore doesn't matter in this context.
And then obviously if she's told that this video doesn't exist, Miss Austin's not going to be able to be like, well, I actually just randomly know that they're on video. This truck's at least on video at 11-12.
Yeah, she didn't find out until 2019.
I hate this. I hate the way that this is just like getting lost.
The state's getting rewarded for having been effective in their deception and bastardization of the system.
I agree. They say the petitioner claimed counsel failed to offer a complete timeline of Zach's movements on the date of the offense. He asserted the timeline should have included evidence that he lacked access to a vehicle, that Deputy Tony Weber saw him at a gas station in Parsons, that a drug dealer, Gay White, saw him at her home, and that he subsequently visited his girlfriend, Rebecca Earp, at her workplace. So we're saying that, like, hey, there should be a complete timeline. Again, that would bring 11-12 into the picture. Why it would be relevant and not just cumulative of cell phone location information or whatever. The records reflect that on November 2016, Counsel Simmons filed a response to the state's alibi notice request, stating that petitioner was at home and in Parsons on the date of the offense. Counsel identified Dick Adams, Dillon, Autry, and Earp as alibi witnesses. At trial, counsel advanced an alibi defense, although not in the form petitioner now proposes, which you say is cumulative. The trial court gave an alibi instruction based on Reeves' testimony, which included a detailed timeline of cell phone location data from 8:17 a.m. when the victim's phone moved through 12:18 p.m. when petitioner's phone was in Parsons. Counsel also relied on Terry Dykes' testimony to support an alibi in closing argument. Yeah, this is why the 11 is so important, because it narrows the time to make all the other things happen.
Exactly.
At trial, Deputy Weber was not questioned about whether he saw petitioner in Parsons. Earp testified but admitted making inconsistent statements about petitioner's whereabouts. She testified petitioner came to see her close to the afternoon and that they argued because she believed he lied about going to the scrapyard. She also stated that after petitioner's arrest by a park ranger for an unrelated event, petitioner's grandfather left the white truck in the impound lot for a while. Trial evidence indicated petitioner drove Dillon's truck on the day of the offense. At the evidentiary hearing, trial counsel testified she could not verify that Weber ever saw petitioner in Parsons. Agent Ferguson confirmed that the records did not show Weber purchased gas from the station, contrary to petitioner's claim. Petitioner presented no testimony from Weber, White, or Earp, the alleged alibi witnesses. Dillon testified that he lied to authorities when he incriminated petitioner, but the state impeached him with 2014 jail calls, where he told his mother that he knew Zach was involved. Dillon claimed he lied during those calls. However, the court finds his testimony was impeached, and Dillon did not provide an alibi for Zach. Petitioner has not shown by clear and convincing evidence that Weber or White were alibi witnesses, as neither testified at the evidentiary hearing. Earp's testimony at trial contradicts petitioner's assertions. The record demonstrates that counsel did present an alibi defense, and the jury was instructed accordingly. Without proof that additional witnesses were available and would have offered exculpatory testimony, petitioner has not shown deficient performance or prejudice. The claim is denied. Failure to effectively introduce evidence through Marshall Walker. Petitioner asserted that trial counsel rendered ineffective assistance by failing to properly qualify Marshall John Walker as an expert witness, which resulted in the exclusion of his testimony. At trial, Walker testified that he had tracked and mapped the location of the victim's cell phone. However, the trial court prohibited him from providing further details regarding the phone's movements or from introducing the map he created. At the post-conviction hearing, Walker testified that the trial court's limiting his testimony stemmed from trial counsel's attempt to qualify him as a cell phone expert rather than as an expert in 2G tracking, which was his actual area of expertise. He also testified that he met with trial counsel for about an hour the night before he testified. Trial counsel testified that Walker's testimony was important because it supported the defense theory that the victim and petitioner were not in the same locations, that the victim was abducted and killed between 8:26 a.m. and 8:50 a.m., that the perpetrator traveled a particular route, and that the victim's belongings were discarded along a route leading towards Britt's residence. She stated that the trial court ultimately prevented her from offering this testimony. Counsel recalled meeting with Walker before trial, but did not remember whether they discussed the map or his qualification. She explained she may have misunderstood Walker's expertise, impairing her ability to qualify him as an expert. She also testified she could have subpoenaed Walker to bring co-defendant Austin's bank records, which she believed would have been consistent with petitioner and Austin being in Parsons. Although she described the bank records as not a smoking gun, she agreed there was no reason not to present them. There was no strategic reason to say, hey, it'd be better if we don't. The court concludes that trial counsel's performance in attempting to qualify Marshall Walker as an expert did not meet an objective standard of reasonableness. Counsel failed to properly understand Marshall's field of expertise. I have that finding there. Counsel failed to properly understand Marshall Walker's field of expertise and did not clearly convey his qualifications to the trial court. He cites Mobley, finding counsel's performance was deficient where he failed to understand the law and elicit an expert opinion. Counsel initially informed the court, "I'd like to use him as a cell phone expert." During the voir dire of Marshall Walker, the state twice elicited his acknowledgement that he was not a cell phone expert. Thompson then questioned Walker about tracking individuals through cell phone data and offered him as an expert in finding people using their phones. A very technical term. Later, she argued he could testify as a fact witness. The trial court ultimately concluded that Walker was not an expert in cell phones, he could not express an opinion, and he could not refer to his map because it was outside of his area of expertise. The court finds that counsel's inconsistent description of Walker's role were confusing and that a reasonable attorney, particularly one who considered the map central to the defense, would have understood the witness's actual expertise and been prepared to lay a proper foundation. Accordingly, this portion of trial counsel's performance was deficient. Nevertheless, petitioner has not shown a reasonable probability of a different outcome had this evidence been properly introduced. The jury heard substantially similar testimony from the defense's cell phone expert Reeves. As the Court of Criminal Appeals summarized, Mr. Reeves concluded that the victim's phone moved north from her home, traveled east, and then moved south, which was east of the victim's home. This mirrors the information that counsel sought to introduce through Marshall Walker's map. The jury heard evidence concerning the victim's phone movements, yet still convicted petitioner. Hearing the same evidence, but Reeves didn't get to opine and give any opinion on an alternative suspect, the behavior of an individual who would commit this type of offense in relation to what the data shows. Like, Reeves is totally different because he's just like, here's the plotting of the sectors and the towers and 3 devices, just 3 devices. The jury heard evidence concerning the victim's phone movements, yet still convicted petitioner. Hearing the same evidence a second time, so he's saying that this would be cumulative. He's saying that Marshall Walker's analysis would be cumulative just because one other guy talked about mapping. About cell phone data was not prejudicial. As to the Austin bank records, the court finds no strategic reason for counsel's failure to introduce them. The records show that Austin's bank card was used to withdraw money from an ATM in Parsons and to make purchases in Parsons and Holiday on the day of the crime. However, the records lack timestamps. Although the evidence supports the defense theory that petitioner and Austin were in Parsons, the court agrees with trial counsel that the records were not a smoking gun and were cumulative of other evidence already before the jury. So, for instance, Agent Frizzell testified that petitioners and Austin's phones communicated multiple times between 10:10 a.m. and 10:49 a.m., with petitioner's phone using a tower near his home. At 11:16 a.m. and 12:18 p.m., petitioner's phone used a tower in Parsons. Reeves similarly testified that both phones were likely together in Parsons. The bank records add little to this existing evidence, and lacking timestamps are weaker than the cell phone data that provided precise times and general locations. The jury rejected the cell phone evidence as establishing an alibi. It is not reasonably probable that the bank records would have altered the verdict. But it's missing the route explanation on what it takes to get there. I don't get how this is lost in the argument here. The issue in dispute is not that he was or what. I mean, I know the state was trying to argue that as a possible other issue. But moving that aside, if you accept at face value, yes, he's in Parsons at 11:12 a.m. or 11:16 a.m. The issue is the timeline to get there, and the jury did not get to see the analysis of all the factors along the path in time and the moving parts. They got to see where phones were, and then they were told that, hey, someone might not be with their phone at all points in time. That's it. And that's quite different than a tracking analysis.
What's hard for me is cumulative is there's like a connotation that it's not important because it's like it's just more of the same. But in a situation like this, isn't that the value of the evidence in many ways, that it's cumulative in nature? It's like, it's not just one little incident. It's not just two. Like, sometimes the cumulative aspect of it is the value of it, because
The
it's
strands
showing,
of the rope, they're not strong when it's just one strand. But when you have a bunch of strands together.
yes, it's like any one of these things could be written off as a mistake or not that big a deal on its own. And any one of these things in this 97-page order maybe wouldn't have changed on their own the jury's verdict, but cumulatively, I don't know of anyone that is actually following this and watching all this and knows everything that was presented in the PCR and is like, yeah, that seems legit.
Yeah, that's the way we should do all investigations. And all trials.
Yeah, no, nothing wrong here. So it's just, it's odd that it's like cumulative. I know in legal speak is it means less valuable, but really when everything's cumulative and there's something wrong with all of it, and you can show comprehensively how the cumulative nature of what was presented inaccurately is exactly, like, that is exactly the point. No, any one of these things, a jury may have still found the same verdict, but you take them all together, cumulatively, I think it's a very different situation that the jury would have responded differently to.
Crazy. But then you call it corroboration when it works for you, right? The difference. They say it's not reasonably probable that the bank records would have altered the verdict, so counsel's omission, therefore, did not result in prejudice. The claim is denied. Failure to properly advise and present Zach's testimony. At the evidentiary hearing, petitioner testified that he maintained his innocence and wanted to take the stand at trial. He stated he felt pressured by trial counsel, as well as by his mother and cousin, not to testify. According to petitioner, his family urged him not to testify because the state would introduce damaging information about his prior convictions, including drug offenses and his reckless shooting of his mother. Petitioner acknowledged the trial court conducted I don't even know how to say it, Maman colloquy regarding his decision not to testify. This is where you go through, you got to colloquy the defendant, you know your rights, you understand that you have the right to testify, you also don't have all of that stuff. Nevertheless, he maintained he did not realize he could disregard counsel's advice. He explained, we paid her a lot of money and I was told to listen to her, and that's what I did. On cross-examination, however, petitioner testified he already decided not to testify before the colloquy occurred. He reiterated, my mind was already made up about the testifying before the judge asked me all this. My mind was made up the minute that I promised my mom and my cousin that I wouldn't testify. There was nothing that was going to change that. The court observed petitioner's demeanor during this testimony and found it credible. Petitioner further stated that, with the benefit of hindsight, he would have insisted on testifying. Trial counsel Thompson testified she advised petitioner not to testify. She did not recall petitioner ever telling her he intended to testify, nor did she recall who brought petitioner's mother and cousin to speak with him on the issue. On cross-examination, Thompson acknowledged the colloquy, but maintained, I think he did not want to testify because I told him he shouldn't testify. During cross-examination, the state presented what impeachment evidence would have been presented had petitioner taken the stand. This included a frantic 911 call from his grandfather on the morning of the offense, multiple phone calls petitioner made that morning, several inconsistent statements he gave law enforcement, and his admission that, in a previous incident, he recklessly discharged a firearm when he was high on drugs, injuring his mother. Although counsel recommended petitioner not testify and believes she influenced his decision, the court finds petitioner ultimately chose not to testify because he promised his mother and cousin he would not. He testified this promise was determinative of his decision. Therefore, the claim lacks merit. Additionally, based on the testimony of both petitioner and Thompson, petitioner had limited memory of the events on the day of the offense and could offer little beyond general denials. The claim is denied. Failure to introduce false confessions from others. Petitioner asserted trial counsel was ineffective for failing to introduce the multitude of other false confessions procured from other people throughout the course of the investigation. Petitioner did not fully plead a factual basis for this claim, except for the assertion that trial counsel should have introduced Dillon's statement to show it conflicted with the state's theory of Autry's testimony. At the evidentiary hearing, trial counsel testified she obtained a transcript of Dillon's recorded interview. She described the interview as terrible and very suggestive, explaining that investigators repeatedly fed Dylan information. She believed the inconsistencies in Dylan's statement could have been useful to the defense and testified she expected him to be called as a witness for the state. He was not. Counsel testified she did not introduce Dylan's statement or evidence related to Benjamin's involvement with Dylan. She acknowledged the statement was inconsistent with the cell phone evidence, but believed it was significant because it contradicted Autry's account and could have shown Autry's motive to distance himself from the rape allegation. Thompson stated she wished she had introduced Dylan's statement to undermine Autry's testimony and admitted she had no strategic reason for failing to do so. The court finds that although counsel did not make an intentional strategic decision regarding Dylan's statement, she did attempt to undermine Autry's testimony through cross-examination. She challenged his timeline and sought to present evidence regarding Autry's affiliation with the Aryan Nation to explain his motive to deny involvement in the rape. The trial court restricted this line of questioning as irrelevant, and the Court of Criminal Appeals upheld that ruling. And they cite that the finding on that issue that the trial court did not abuse its discretion by limiting the cross-examination. The appellate court also concluded that sufficient evidence corroborated Autry's trial testimony, including petitioner's lack of an alibi, the firearm evidence, petitioner's scratches, and his multiple inculpatory statements. Because Autry did not testify at the post-conviction hearing, the court cannot determine whether his trial testimony would have been affected by the introduction of Dylan's statements. Accordingly, petitioner has not met his burden. The claim is denied. And then Thompson's mental health. It says, finally, petitioner argued counsel rendered ineffective assistance by failing to disclose her declining mental health or her use of antidepressant medication, and by failing to move to withdraw from the case. A defendant alleging ineffective assistance based on counsel's impairment must show, through specific examples, how the impairment affected trial strategy, preparation, or performance. Proof of the impairment alone is insufficient. And then Brimmer v. State here says, examining cases where attorneys abused alcohol or drugs. That's it. Okay. Petitioner need not demonstrate that the trial would have resulted in an acquittal to establish prejudice. He needs only to prove that there's a reasonable probability that, but for counsel's unprofessional error, the result of the proceeding would have been different. Trial counsel testified she sought medical treatment because of depression and anxiety stemming from the case. She stated that she increased her antidepressant dosage over time, ultimately taking Zoloft and Wellbutrin at levels exceeding FDA recommended limits. Counsel admitted she did not inform petitioner, the court, or anyone else about her mental health struggles. She explained that she did not move to withdraw because she feared replacement counsel would urge petitioner to plead guilty. Counsel also believed that even if she had performed better, the verdict would have remained the same. The court credits counsel's testimony that she avoided medication that could impair her mental acuity and finds her efforts to seek medical assistance were reasonable. Petitioner presented no proof that counsel's mental health affected her performance at trial. He testified counsel met with him often, reviewed discovery with him, and engaged with the case. His complaints centered on counsel's organization and the volume of discovery, not on her mental condition. But didn't he find earlier that that was the basis for which she failed to request a mistrial? Because she was afraid of the franticness of potentially something that would be stressful.
That's consistent with what I remember.
So the trial court reflects counsel's active engagement. The trial record reflects counsel's active engagement. She cross-examined nearly all of the prosecution's witnesses, presented expert and lay witnesses, advanced the defense theory of innocence, and presented alibi evidence sufficient to warrant an alibi instruction. The jury deliberated for 2 days. Petitioner presented no evidence that counsel's use of antidepressants or her mental health condition affected the outcome. The claim is denied. The court also finds no showing that a motion to withdraw would have been granted. The trial court had previously denied co-counsel Jim Simmons' motion to withdraw. The only evidence concerning the potential effect of withdrawal was counsel's speculation that a replacement lawyer would have urged a guilty plea. Petitioner has failed to establish prejudice. Claim was denied. And for all the reasons stated herein, having presided over multiple days of evidentiary hearings, observed the witnesses' demeanors, reviewed the extensive trial record, and considered all exhibits, arguments, and applicable legal standards, the court concludes that petitioner has failed to establish any ground for post-conviction relief. The court finds that petitioner did not prove by clear and convincing evidence that counsel rendered ineffective assistance under Strickland, nor did he establish that any alleged prosecutorial misconduct violated the principles articulated in Brady, Napue, or their progeny. Likewise, petitioner's claims of actual innocence, whether asserted as freestanding claims or as alternative theories supporting ineffective assistance or prosecutorial misconduct, are not cognizable under Tennessee law, and even when considered in the alternative, do not create serious or substantial doubt as to petitioner's guilt. The court further finds that all waived and abandoned claims were properly dismissed pursuant to Tennessee Code and applicable case law. To the extent any issue was addressed in the alternative, the court finds no merit. These findings are based on the court's review of the full evidentiary record. Accordingly, petitioner has not met their burden under Tennessee's Post-Conviction Procedure Act, and this court is left with no serious or substantial doubt concerning the validity of the jury's verdicts. Post-conviction relief is therefore denied in all respects. The clerk shall file this order. There you go. So ordered the 17th day of July 2026. Big signature there. Brent Bradbury. So there we go. There we go.
The sad thing of all of this is it's not even a trial where it's decided whether he's guilty or innocent. It's literally whether he should get a trial or whether this trial is good enough. They're not, I mean, I think it's clear he didn't do it. But even if you're not on board with that, how do you think this was a legitimately fair carrying out of justice? Yeah, if this case doesn't qualify for a new trial, then what case would? But Murdaugh is going to get one.
Well, this here, Kaz looking up the other case that was cited, that Williamson case. It says, like, so the evidence was still sort of presented rather than just not allowed at all. Yeah, about their contents. Yeah, okay, that makes a... that was just such a dumb, inapplicable cite. So the specific contents, which to me would be more comparable of like, you found another way to get the specifics, something more precise in. So you don't need to do it in two different manners. That would be like, hey, look, if you already had a timestamp showing you were doing something at 8:39 precisely. Like a content showing 8:39, not just like a cell phone tower sphere, circle. Then you don't need to do something else that gives a precision of 8:39 on a specific device located in a specific home. I'm gonna wake up at 3 a.m. like that Williamson case. Why did he cite that? So, oh my goodness.
He cited one I'm curious about. I'll follow up once I look it up. But I mean, who predicted in the chat 9 hours? Somebody is good.
It's a long one. I mean, that's it's kind of a bad pacing. It's like, about 10 pages per hour. But, we had a lot of context. We had a lot of context there.
Yeah, no, I think it's good to get all the way through it and have it in one spot.
I feel so detached from this, but I promise, guys, in my mind, I was like 97. We've read some long transcripts before, and it was like 4 hours-ish. So I was like, I can get through. So I did not mean to neglect anybody. So I want to give a big, big thank you here to Miri, who says, I love Thompson. She owned it. She did literally everything she could to defend Zach until the very end. She fell on her sword, as you said. We did have some, like, her falling on her sword, I think on two prongs, was found to be, hey, Judge Bradbury saying, I don't think it changed the outcome. I think we're not meeting the prejudice prong, but I am finding it. She was deficient, and she's told us she was deficient. She had testimony on these issues at the post-conviction proceeding. And then other rulings, he's like, well, I didn't get to hear her fall on her sword in relation to this particular issue because she wasn't asked questions about that during the post-conviction proceedings. So I can't make a deficiency analysis because she just simply wasn't asked. So I think he acknowledged that she did fall on her sword when she didn't do something the way it should have been done. And then also made rulings based on the absence of her opportunity to fall on the sword. So thank you for the 5 here and the great food for thought.
And please, you guys, be generous to Kat because she just read 97 pages, and I had promised y'all I was going to get on a live as soon as this thing came out, and I didn't have it in me. So I am incredibly grateful, and you did an amazing job going through it. And I feel like I learned from it, and it's just, I feel less devastated now, because now it's just like, all right, let's get back to work.
I think the most monstrous task, aside from this always being an uphill battle, is how do you explain? I had difficulty expressing to a chat that I'm largely making a blanket assumption that you guys, a lot of us, we rewatched the trial. We looked at the post-conviction hearings. We watched those proceedings. We looked at some of the news coverage before. Like, we have an awareness. How do you articulate some of the things that just kind of like, well, wait a minute, to a panel, an appellate panel, who you don't know has sat here and actually like actively consumed the raw material from this trial? Even the filings. We've also read through some of the filings. We're familiar with the way some of the issues were raised or were not. How do you, in a brief that I'm assuming, I don't know what the limit will be, but imagine the brief has to be shorter than this order. How do you continue to raise and articulate the specifics of the issue? Because this isn't going to be the type of thing where there's an exhaustive hearing spanning days and 25 witnesses. This is going to be, you file a brief.
Witnesses. Yeah, it's going to be a brief, and what do they get, like 15 minutes?
If you get oral argument, you get a brief, the opposing party gets their response, and then you get a reply to that, which in theory should be shorter in length. Like, it should get shorter. But that's it. You don't have this chance to make opening and closing arguments. You don't have these extended hearings. You don't get to introduce anything new. This is limited. This is going to, at least for the Tennessee Court of Criminal Appeals, for an appeal of this order, it's going to be limited to the record up until and through this order. You don't get to like weave in something new that we should, some of the context we sprinkled in that nobody's gotten to hear yet. You don't get to bring that in. So it's just, to me, it's just such a monstrous task of the human need to leave no stone unturned, especially when you're fighting for someone's freedom, someone's rights. But you can't just argue forever. You've got to constrain yourself. And you've got to choose what arguments you're going to focus on. And you've got to decide, like, this is how much space I need to articulate what the issue is and what the record shows to support that issue, and why the legal analysis of the judge who issued this order was either incorrect or he didn't consider what should have been considered, and there's something missing from the record. But yeah, I just think it's a monstrous task to constrain and limit down how to word things. So, and then Mary says Dylan was literally kidnapped by that dirty cop with the help of other people who facilitated that, right? Like, to me, that's not just Dennis Benjamin saying, oops, I'm going to go, this kid's going to come live with me. Come on, kid. It was ordained by other persons. It's not a one pony show to make that happen. And it's still the most bizarre. It's why I wanted to cover this. I saw Kathy Rasan post like, well, this is weird. It was in the middle of the November post-conviction hearings, and she's like, well, this is weird. This I've never heard a condition of probation where someone has to go live with a retired police officer. That's weird. And that alone is weird. That's like without the context of like, oh, working in the capacity of a private investigator for the family of the victim. Oh, there's reward money out there that might be relevant to this decision. Like, it's without that context, and it's already weird. So, man. Mary, I agree that it probably seems like a kidnapping. It seems like Beauty and the Beast. Like, you get the Stockholm syndrome. Like, as far as Dylan knows, he doesn't get why he's living there, but then we have Dennis Benjamin admitting he's fragile, he's impressionable. And then he has fear. Well, what was the order of events there? What was the sequencing?
Well, it was definitely, goodness. There's the recording of Dennis Benjamin with Victor Dinsmore, literally asking who's the weakest one, like who's the easiest one to get. And he said Dylan. And then here we go.
I was bothered by that. And where was the link? I guess we said linked a lot of times in this. There we go. This bothers me because we're in this pickle. We're in this legal pickle where it's like the court's like, look, because we only have Dennis Benjamin here, who I don't find credible, but I'm listening to and seeing the pattern, the nature of which he's doing the questioning, which is so weird if you're going to find that everything he's living with a co-defendant is honky-dory. But he says here that he leaves it as alleged that Dinsmore said that Dylan was the weak link because he's, look, I'm not considering Dinsmore's words. Like, the purpose of admitting these recordings is to show the way that Benjamin was doing the questioning. So we leave this as an allegation, right? We're leaving this as an allegation. We're not making a factual determination on this issue. We're just pointing out that petitioner was arguing the issue. And I think it's so critical to have, like, an indication at face value that Dinsmore's pointing someone to Dylan, and Dylan's the first person they go to, and they ultimately have to go to Autry because they realize Dylan just won't work.
Mm-hmm.
So all of this is just, I don't even want to read these names. I don't want to read the names on the right side of that. Let's just go back to the beginning. Lord.
I think that was an excellent analysis, though. I so appreciated you brought up so many things that I would never have caught, and I think the chat too. It's been super helpful to just go through and analyze it. And
yeah, and I have a lot of like gray areas where I'm like remembering something because I was told. Like the idea that like, hey, I do remember something about that, but I didn't think of it randomly. Something had to prompt it. And not something notable like a gunshot going off and then there's an Amber Alert for a missing girl, and I don't think of it until I have a good conversation with my friend Mr. Booth. But you know, there are things here where I'm like, oh yeah, I remember that, but it's fuzzy, like it's not apparent. I would need to go review the primary source material to remember exactly how that went down.
Well, I can say this, the next time I'm on here, it's going to be for episode 14. And if you haven't yet caught up with 13, please check it out, because 14 is going to be basically a continuation of that. And I'm going to get it out within the next few days. I'll put something out to let you guys know, and I'll drop it. But there's more to the story.
That was like an hour and a half, right? That wasn't like that wasn't a long lot, because it was a video that you uploaded as a premiere. So
yeah,
it's pretty focused, guys. You can cram that in. I don't know how quickly you're going to release the next episode, but
I'm going to try to get it out in the next few days. I have it. I'm just finishing up some tweaks on it and making sure that it's clear. So hopefully hopefully pretty soon I'll put a message out when I have it. I'll send you and see if we can do a live debrief afterwards, maybe.
Yeah, that'd be a good time. I have, for whatever reason, I think I have a bunch of hearings crammed in this week I think Courtney's the week after, but like the Rashawn Jones case I mentioned earlier. And the reason I mentioned that earlier, there was a witness in that case that was like in college. This is the University of Miami murder, like 2 decades ago at this point. There was a friend that lived in the dorms with them who ended up becoming a cop like nowadays, decades later. And his testimony now, that they decided to bring this cold case and charge Rashawn Jones years later, is they believe he had this little revolver, and that they knew he had this revolver because his mom or grandma used to watch a lot of spaghetti westerns, and then when he became a cop later in time after that, he learned to identify weapons better and worked backwards to realize that that was the same gun that would have been consistent with what they think could have been the fatal gunshot wound to the victim in that case. So that's why I was mentioning Rashawn Jones earlier in relation to identifying revolvers and being sure. But, oh my goodness. I think you'd like
Never
that a lot.
ends.
Never ends. I think you would also very much enjoy that prosecution team, and I don't mean actually enjoy them. Like, not enjoy them. Bad Mom Bree, thank you for becoming a member. Thank you for becoming a member. We've also got Jay Money in the building. Thank you for being a member for 10 months. Says happy Saturday. You know, it's Sunday for some folks. So happy weekend. Happy weekend. Always good to have Jay Money in the building. Christy very generously gifted 5 memberships. Very generous here. And also, Christy, thank you so much for when you jump in with some context, pointing things out. You helped a lot yesterday on the stream we did on the spicy prosecutor that seems to have a dating MO. Has a type. If you're not going to date a defense attorney, go after the defendants. That was a great stream. Thank you for the context you helped add there and joining us today. We have Tennessee Lake Gal. We always love our local Tennesseans. Said, I know family on the Bobo case and some have different opinions, but I can tell you one of them believe that Terry Britt was very suspicious. I also know Larry Stone, who found her skull. So I didn't know you were that low. I just knew Tennessee from the name. Thank you for the super here. And very interesting. I never expect that like families can be big. They can have differing opinions. But it's interesting to hear like an anecdote that I've spoken to a family member. They have this certain viewpoint. They have a red flag about, and here you're speaking to Terry Britt, but just in general in cases. So thank you for sharing that. I think the Larry Stone thing is interesting as well. I can't quite put my finger on it. And I understand that a lot of people say when they come across something on a kind of like interesting time and place, they think, oh, there's no such thing as coincidences. I was meant to. I was destined. God brought me here. And I know that we had to have a ruling that at trial we cannot testify that we believe that we have this greater purpose bringing us here to find this piece of evidence. So just very interesting layers around the Larry Stone discovery of the skull during the time.
Very interesting layers around that.
During the time that Dylan Adams is living with Dennis Benjamin and will, within 10 days of that finding, be brought in. He told all. He told all. He told all in a way that we think we can make work. Let's get an official interview for him. So, good stuff there. Also, I think we have another gift parade. So I want a big thank you to Steph here, turning green. Love to see you in green. Thank you so much for supporting the channel. And then we had a wave of gifts here. So Sheriff Chuck like bombarded the chat with like a million booms and echoes. The Jason Autry echoes. Gifting another 5 and another 5 here. So holy moly, you turned like the whole chat green today. And DV here with another 5. Like I'm going to put 5 on it. Can't just be all Sheriff Chuck. So big thank you to you guys. Tara Rayner says, Autry wasn't looking out for his own interests? ?
No, because it didn't benefit him. I mean, the recant was no benefit to him, and he knew it would not be a benefit to him.
I think, correct me if I'm wrong, Tara, I think you've been a member for 2 months, but this could also be like, because this was earlier.
Like maybe his testimony?
Yeah, like questioning, like it's credible because, the most to his benefit would be that there was a weak case against him, but that's kind of hard to reconcile if the case is weak.
And if the prosecutors are coming to you asking you to commit perjury, that they're suborning, that in and of itself tells you that you're not in a fair legal system. So if that's an option on the table, how could there be another option to select where I'm just going to go for it and hope that the right thing happens? You're being exposed to the corruption that exists. So that's not an option. It's the option. Do you want to be the one to be the fall guy, or do you want it to be somebody else?
And it only worked because they already found the body or the skull, like, and some of the remains, because that's what screwed up for Shane Austin. So the idea that he wasn't at risk of having to look out, like, okay, we'll offer you immunity, but only on the condition that you bring us to this information. That wasn't something that was going to be a factor for him to look out for his own interest, because he didn't need to provide something that he couldn't provide. He just needed to provide and recite what was available to him in the discovery. Because for Shane Austin, the discovery was never going to include the location of where the skull was found before that fateful moment where we have the skull being found by that divine intervention. So Crazy. So I think that's what we're getting at. And I think it's such a convoluted argument, but I see it in other cases where when there's a recanting issue or the credibility assessment on, like, if an appellant is arguing, look, this conviction is largely based on the testimony of somebody who's not credible. Here's why we're arguing they're not credible. And because they're not credible and it was a circumstantial case otherwise, it's critical. This is harmful that this was presented to the jury in this way and not contested or whatever. And you must find it was harmful. You must reverse. It's always the counter argument that, well, they wouldn't lie. It wouldn't be in their interests. Or when it's recanting and somebody introduces a recanted statement, it's not an issue of credibility. It's, hey, they've recanted. Then the opposing party, usually the state, will argue, well, it's self-serving for them to recant now. And they'll argue whatever way it needs to go. Quite frankly, I think either party can argue credibility in either direction they want to. But yeah, that's a lot. Oh, man.
It's a lot.
Oh, Katie was typing. I think she pressed something on her keyboard that exited the studio.
Oops,
what
sorry.
did you just do?
I have no idea. I did that twice. I'm not sure what happened. I must be bumping.
You're like, it's a lot. Bye.
Yeah, it's a lot. Peace out.
Oh, that's how I need to learn to exit streams. Where's EJF? EJF's gonna be like, can we go 24 hours? And right on cue, Dr. Dakota, thank you for the generous 20 here. Says, I can't believe you are still going. You all are incredible justice warriors.
Takes one to know one, Dr. Dakota.
That's right. I would love to be the type of person that can just condense and put a headline out there.
That ain't me either. Yeah.
I want the whole source material.
Mm-hmm.
I want you guys to be able to look at it, like, read it with me if you want to read it with me. If you want to, like, grab the link and go about your business and read it on your own. And this one took quite some time. So
I love the way you did it too, because people can go back and forth and just go to you went from, front to back where people can kind of find wherever they're in it, reading it and hear it. So I think it's
worth it. I want to emphasize, guys, if you're going to do like a find in page, try to word search, there were several names. So if you want to be like, oh, what are the mentions of Sheila Kilsner in this? Her name's going to be spelled wrong. So you're not going to be able to do a perfect. That actually might be something that's good for AI. Put it in AI and ask AI, like, hey, where are any mentions of this name or similar name variations that might be the same person? And then whatever it puts out, like, go and verify that that's within the context. That's I think one of those good uses for a tool. But yeah, we are still going because I don't think there was a natural point to, some filings, it's like, well, here's this, and then there's a bunch of exhibits attached. Maybe we can do the exhibits on another stream, but this was like all in one. So thank you so much for the generosity here, and good to see you. Looking forward, if you're going to do a video on this at all or anything, looking forward to that. If you don't want to touch this case on your channel ever again, still looking forward to whatever you put out next. Actually, good question. Do you know, is there like a timeline for Autry?
He was sentenced to, 19 years. He has a health issue and would need something else to happen other than his sentence coming up for him to be out again ever. Yeah, he doesn't have 19 years in him, I don't think.
I was going to say, you mean for him to have a chance to get out within his lifetime is what you're saying, and not, okay. Yeah. That's where I was going with an inference, but I wanted to explicitly state it. Well, I hope to hear from Jason Autry again, and unfortunate circumstances for that to be a motivator, but I do think that can be a strong motivator if you're on your way out and you're harboring this, especially if he said, I'm hoping that what I said is enough to give them any person with reasonable discernment to look through this and say that it's not right.
I have through contacts. I'm confident that Jason Autry continues to follow this as much as he's able and is continuing to be hopeful that the right thing will happen. while not
Isn't it
being
interesting?
particularly confident that I will be able to manage it because of the immense corruption that I am naively facing. But he's pulling for it.
It made me think of somewhat a part of the underlying theme of what you want to do with the Trial and Error podcast, where voices get lost in the woods, like the trees, the forest, and you get tunnel visioned, so you're not even looking for the actual answer, and then the people you're supposed to be seeking answers for, they become these forgotten voices, these forgotten victims. And then the person who might be the one authentically and genuinely trying to admit their wrongdoing, admit what was self-serving, and admit their dishonesty, maybe even admit a mistake in their strategy play. If you accept that a recanting from Jason Autry would be truthful in its recanting, right? Because you could say it's not truthful. It's interesting that would be the individual that owning or admission of a mistake would come from, and not someone with a duty, with an obligation, a professional and ethical obligation to want to get things right. And it's kind of like, I don't know if you had Jason Autry's like recanting in mind when you were thinking of that, because to me it seems like a broader number of cases, well beyond the bounds of this case, that's an issue. And like we want to stick to our initial theory, we don't want to course correct. And that means we never really get justice, because we just don't want to, we want to hold on to what we said years ago and not have to be like, hey, I made a mistake. Nobody wants to admit that they made a mistake.
And it's hard to do that because it's not just an ego thing. I think it feels like it's an ego thing and no one wants to admit they're wrong. But there's a deeper cognitive process that is involved in challenging your own beliefs and your own assumptions and being willing to let go of years and years of theories.
You've got all those neurons, the synapses built up from the reinforcement over the years.
I think it's a discipline to know how to challenge yourself and know when to course correct and when to hold strong. It's not something that I think it's harder than people realize, and we're all way more vulnerable to it than we want to admit.
Yeah, no, I totally agree.
This case has a lot of lessons in it.
Dana passed you the torch, so this is on you and Kinsey, I'm sure. And I don't know about DB, or we had a DB reveal a little bit on the Trial.
Yeah, DB, we're waiting on those episodes. Come on, buddy. He's gonna impress the hell out of all of us when he finally releases.
I imagine so.
It'll be worth the wait. We're coming out strong. We'll be putting out lots of stuff. Thank you so much for doing this and putting it out. And I'm gonna go, and I will be back on YouTube soon with more stuff to share.
All right, I'm going to do the same after giving a big thank you here to Sheriff Chuck. Again, incredibly grateful. Sheriff Chuck, you made it possible for me to do those deep dives back in November and December when we were going like every day. Thank you for continuing to support. Guys, I'm going to end this though. I don't mean to like do the opposite of what I normally do. I'm going to hit the end button because Katie's leaving. And it's been 9 hours, 30 minutes. And I've got a case write-up to do on an expert witness, a medical examiner who did not want to admit her mistake from like years ago in another case that recently the formerly convicted individual just won wrongful conviction compensation, Ashley Jordan. So I was going to record that today before this decision came down, and then plans changed. So I'm going to rest up and do that work on that tomorrow. Katie, thank you so much for joining.
Thank you so much
for all the work that you do and your advocacy for, I know it's not just limited to this case, even though we're exposed to you through this case. I know.
I'm going to be focused on this case for a while, I think.
I know the feeling. All right. Well, thank you.
Thank you so much, guys.
Sarah sneaking in here with the encore, like the free bird, says just starting the replay, but I had to pipe up and say, hey, and F the shit. Love you both and your channel peeps. Well, hey from the future, Sarah. And thank you for saying it. Thank you for giving me the opportunity to read that, because it is how I feel, especially last night. I was in a different mood last night. And today I'm back to the justice takes a scenic route, and I hate that. But I'm a little more positive that there's things to argue, and there's pathways here to be argued.
It's not wasted. We're going to be stronger. Every step we have to escalate, it's going to be stronger, and it's going to be a lesson that will hopefully correct a lot of ongoing systemic issues in our justice system.
All right, the whole chat's gonna leave. They're like, go get some rest. Go,
Yeah, bye,
seriously,
everyone.
leave. Go take a break. I'm gonna hit the end button. You guys have a good one, and thank you so much, Katie. Always good to see you.
You too. Bye.